ಕ್ಯಾಮ್ರಾನು ಎಲ್ಲೋ ಹೋಗ್ಬೇಕು. ಅಡ್ಮಿಷನ್ ಇದೆಲ್ಲ ಕಮ್ಮಿ ಇದೆ ಅಲ್ಲ? ಅಲ್ಲ, ಅಡ್ಮಿಷನ್ ಜಾಸ್ತಿ ಇದೆ. ಹೇಗಿದೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲ, ಸ್ಪೀಚ್ ಇದೆಯಂತೆ. ಓಪನ್ ಸ್ಪೀಚ್ ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು. ವೆರಿ ಹ್ಯಾಪಿ ಟು ಸಿ ಹಿಸ್ ಫೇಸ್. ಇಲ್ಲ, ಅವ್ರು ಬಂದು ನೋಡಿದ್ರೆ ತಕ್ಷಣ ಬಂದು ಮಾತಾಡ್ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ. ಇಲ್ಲ, ನಾವೇನ್ ಮಾಡಿದ್ವಿ ಗೊತ್ತಾ, ಸಿಗ್ತಾ ಇರ್ತಾರಲ್ಲ, ಅವಾಗ ಬಂದ್ರು ಅದೇ ಹೇಳಿದ್ವಿ 5 ಕಾಲ್ಗೆ ಹೋಗೋಣ ಅಂತ. ಬಂದಿಲ್ವಾ? ಇದೆ, ನಾನು ನಂಬರ್ ಕೊಡಿ, ನಾನು ಹಾಕಿಸ್ತೀನಿ. ಏನು ಹೇಳಿ ನಂಬರು? ಏನು ಯಾವುದ್ರಲ್ಲಿದೆ ಇದು? ಹಂಗಾರೆ ಅದು ಇಂಥದ್ದೆಲ್ಲ ಕೆಲವುದು ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ. ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ವಿಚಾರಿಸ್ತೀನಿ ಬಿಡಿ, ನಾನು ವಿಚಾರಿಸ್ಬಿಟ್ಟು ಕೇಳ್ತೀನಿ. ಬೇಡ ಇನ್ನೊಂದು ಬೇಡ, ನಾನು ಹೇಳ್ತೀನಿ. ಇವತ್ತಿಂದ ಇದೆ ಅಲ್ವಾ? ಇವತ್ತೇನಾದರೂ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ವೆರಿಫೈ ಮಾಡಿದ್ರಾ ಕೇಳ್ತೀನಿ. ಅಂದರೆ ಏನಂದರೆ ನಿಂತರೆ ನೋಡಿದ್ರೆ ಮಾತ್ರ ನಿಂತ್ಬಿಟ್ಟು ಹತ್ರ ಬಂದು ಮಾತಾಡ್ತಾರೆ. ಅದನ್ನು ಮಾತ್ರ ಇಷ್ಟ ಆಗುತ್ತೆ. ಕೇಳಿಸ್ಕೊಂಡ್ರಪ್ಪ? ಕೇಳಿಸ್ಕೊಂಡ್ರೆ
ಇನ್ನೊಂದು ಆಗುತ್ತಲ್ಲ ಒಂಥರ ನಾನು ಅದನ್ನು ಹೇಳಿದ್ಮೇಲೆ ಗೊತ್ತಾಗಿದೆ. ಪ್ರಕೃತಿ ಜನ ಇದ್ರ ಬಗ್ಗೆ ಮಾತಾಡಿದ್ರಮ್ಮ,
ಎಲ್ಲಾರನ್ನೂ ಒಂದೊಂದು ಸ್ವಲ್ಪ ಮಾತಾಡಿ ಅಂತ ನಾನು ಇಳಿದು ಹೋಗ್ತಾ ಇರ್ತೀನ, ಬಂದರು ಬಂದು ನಿಂತಿದ್ರು, ನನಗೆ ಹೋಗೋಕ್ಕೆ ಪ್ಲೀಸ್ ಕಮ್ ಅಂತ ಅಂದರು. ಅಯ್ಯೋ ಹೌದು, ಬಂದಿತ್ತು ಆಮೇಲೆ ಇದರ ಮೊದಲು ಥರ ರಾಜ್ಯದ ನಿನ್ನೆ ಯಾರೋ ಯಾರೋ ನಿನ್ನೆ ಕೇಳ್ತಾ ಇದ್ರು, ನಂಗೂ ಒಂಚೂರು ಹೇಳ್ಕೊಡು ಮಾಡಿ ಅಬ್ಬ
ಏನು ಮಾಡಬೇಕು
ನಾನು ಹಂಗೆ ಮಂತ್ರ ತಕ್ತೀನಿ. ಆ ಥರ ನಾವು ಮಾಡಿದ್ವಿ.
ಇಲ್ಲ ಸರ್, ಒಂದು ನಾರ್ತ್ ಕರ್ನಾಟಕದಲ್ಲಿ ನಿಂಬೆ ಕೊಟ್ಟು ಡಿಶ್ ಮಾಡ್ತಾರೆ, ಅದು ಇದೆ.
ಇದು ಮಾಡ್ತೀವಿ.
ಅದು ಇದೆ.
ಯಾರಿಗ್ ಗೊತ್ತು? ಅದನ್ನೇ ಮನ್ಸು ತಗೊಂಡು ಕೊಟ್ಬಿಡ್ತೈತಿ. ಆ ಕಡೆ ಎಲ್ಲ ಸ್ವಲ್ಪ ವರ್ಲ್ಡ್ 12 ಕೊಟ್ಟಿದ್ದೀನಿ ಅಲ್ವಾ? 11, 12 ಕೊಟ್ಟಿದ್ದೀನಿ. ಇವತ್ತು 12, 12. ಅದಕ್ಕೆ 7 months.
15 months
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ತುಂಬಾ ಇದೆ. ಇವತ್ತಂದ್ರೆ ಎಷ್ಟಾಯ್ತು? ಮಾತ್ರ. ಮನೇಲಿ ಬರೀ ನಾವು
ಬರೀ 20% ಕಷ್ಟ ಇರುತ್ತೆ.
Permission RS 101/24 is already court has issued emergency notice and ceasing the day of the operation of the settlement in RS. Maybe not date may be given.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಏನಾಗಿದೆ ರೀ?
It is served.
ಸರ್ವ್ಡ್ ಆರ್ಪಿ ಸರ್ವ್ ಆಗಿದೆ. ಆಯ್ತು ಕೊಡಿ ಮೆಮೊ ತಗೊಳ್ಳೋಣ.
My lord,
ನಮ್ಗೆ
I think emergent notice we have already fixed the date returnable by. Then why you are giving memo? Huh?
There is a urgency, your lordship. Because the
ಆಯ್ತು ನೋಡೋಣ ಹಾಕ್ಸ್ ಏನಾದ್ರು ಇದ್ರೆ.
my lord, final degree proceedings are going on, my lord. Commissioner is being appointed. Kindly have
What
that
do you want,
matter
madam,
for-
now?
Kindly have that matter for tomorrow, my lord. Kindly have that matter for tomorrow.
Matter.
RSA, my
You
lord.
have already given memo.
Yes,
Now
ma'am.
that will come in usual course. Yes.
Your lords, there's a connected matter for this RSA, your lords. So kindly have this matter on the same day, your lords. Yes, your lords, there's a connected matter with the same cause of action, your lords.
Then
It's
you
coming on
make,
4th,
you make a mention when the matter comes today.
your lords, it's on 4th of 12, your lords.
4/12.
4/12, your lords.
What do you want now?
The same RSA and another RSA has to be listed, your lords, on the same
Be
day.
listed on 4th.
Yes, your lords.
ಕೊಡ್ರಿ ಮೆಮೊ ತಗೊಂಡು ಹಾಕ್ಸಿ ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್
ಅದು fourth ಗೆ.
ನೋಡಾಕ್ಸಿ.
4th.
4/12. 4/12 ಅಂತ ಬರೀರಿ ಅಷ್ಟೇ.
mentioning from page number 5, 15, 16 to 18, 9.
Serial number 65, my lord.
I think final
H
hearing
wise ಕರೀತಾ ಇದೀನಿ.
need not wait. Today for final hearing need not wait. I have 45 admission matters and apart from that criminal matters also. Final hearing will not reach. Need not wait. Yes.
16 to 18,
Hmm?
16 to 18, 19,
16 to 18.
19 to 25.
Serial number 15, my lords, apologies. I just,
ಹೇಳಿ ಏನು 15.
lords, where for the,
15.
please, my lords,
You
Senior
are-
SV Giridhar is unwell, my lords, he'll not be able to make his submissions today. If it may be adjourned by 2 weeks, my lords.
Statement already last time we have given 3 weeks time to file
Please, my
statement
lords,
of
he is unwell, my
objections.
lords, he
When-
is taking time in
No,
all
no,
matters.
no grounds. No grounds. Next.
Adjourned by 1 week.
No, madam.
Nine-
No, last time he sought 4 weeks. Other side objected. I have given 3 weeks time.
Page wise ಕರೀತಾ
Hmm. No counsel, no non-prosecution ಅಂತ ಮಾಡಿದ್ವಿ. Dismissed as non-maintainable, premature, red paper, no adjournment. Otherwise dismiss it. Premature, this government land. ಹೇಳಿದ್ನಲ್ರಿ ಅರ್ಥ ಆಯ್ತಲ್ಲ? Non-prosecution ಅಂತ ಬರ್ದಿದ್ದೀನಿ, ನಾನು ನೋಡ್ಕೊ ಬಂದಿದ್ದೀನಿ. I have read the paper also. Government land. ಮಾಡಿದ್ದಾರೆ. People every time, 6 time. I am spending every day 3 hours for reading the papers. You people are coming and seeking time.
26 to 31, 32 to 37.
36 your lordship.
Yes, madam.
Council on record ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ ಅವ್ರ ತಂದೆ ಕಾರ್ಯ
ಊರ್ಗ್ ಹೋಗ್ಲಿ, ಅಲ್ಲೇ ಇರ್ಲಿ.
ತಂದೆ
I have read
ಕಾರ್ಯ
the,
ಅಂತ
I have read the papers. No adjournment. Next.
one short accommodation
No
your
adjournment.
lordship.
38 to 43.
Serial number 39 my lord.
39 ಹೇಳಿ ಏನು?
ನಿನಗೆ ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಹಾ.
ಅಲ್ಲಿ FDP ನಲ್ಲಿ ಲೋಕಾಯುಕ್ತ ನಾವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡು ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ we will report.
ಏನ ಮಾಡಿಫೈಡ್ ಏನೇನು ಇದೆಯಲ್ರಿ? ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಪಾರ್ಟಿಷನ್ ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಲೋಕಾಯುಕ್ತಗೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊಂತಾರಂತೆ.
ನೆಕ್ಸ್ಟ್ ಲೋಕ್ ಅದಾಲತ್. ಲೋಕ್ ಅದಾಲತ್ ಮೇಲೆ ಆದ್ಮೇಲೆ ಡೇಟ್ ಕೊಡೋಣ.
ಡೇಟ್ ಕೊಡೋಕೆ FDP ನ ರಿಪೋರ್ಟ್ ಮಾಡಿ.
Both council submit that matter already been settled and going to report the same on the
possibility of settlement ಅಂತಂದ್ರೆ.
ನೀವು ಹಂಗಂದ್ರೆ ಹೆಂಗ್ರಿ?
ಆಗಿದೆ.
ಹಂಗಿರ್ ಕೊಡೋದಿಲ್ಲ ಡೇಟ್. I have already read the papers, you assist the court.
ಆಗಿದೆ. ಆಗಿದೆ.
ಮತ್ತೆ and going to report the settlement on the next lok adalat day
in FDP.
In FDP. Then list this matter on 16th 16/12.
44 to 48, 49 to 52, 50.
Serial number 50. ಹೇಳಿ ಏನು 50?
Report number is dead.
ಯಾರು ಡೆಡ್ ರೀ?
ಸರ್ ಅದು ಸತ್ತೋಗಿದ್ದಾರೆ.
ನೀವ್ ಯಾರಿಗೆ ಹೇಳಿ?
Respond number is dead.
ನೀವ್ ಯಾರಿಗೆ ಹೇಳಿ?
I'm for the appellant.
ಅಪಲೆಂಟ್ ಅಡ್ಮಿಷನ್ ಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ಕೇಳಿದಿರಿ?
ಇಲ್ಲಿ ಟೈಮ್ ಕೇಳಲ್ಲ, ಅರಿವು ಮಾಡಿದೆ, ಬಟ್ she is dead. I take steps.
ಏನ್ ಸ್ಟೆಪ್ಸ್? ಬರೀ ಕೇವೇಟರ್ ಮಾತ್ರ ಇದ್ದಾರೆ. ಬೇಕೋ ಬೇಡವಾ ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡುತ್ತೆ. ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿ ನೀವು.
53 to 59, 60 to 63, 64 to 68, 69 to 71, 72 to 75.
69 my lord.
ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತೀವಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆಲ್ರೆಡಿ.
Could a date be fixed my lord? There was urgency in the matter.
ಮಾಡೋಣ.
ಅಲ್ಲ vacating of interim order ಗೆ ಹಾಕಿದ್ದೆ.
ಮಾಡೋಣ ಹೇಳಿದಿನಲ್ರಿ, ಎಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅನ್ನು ಕೊಟ್ಟೋದು ಇವತ್ತು. ಫೈನಲ್ ಹಿಯರ್ ಲೈವ್ ಇದೆ, ಆಯ್ತು.
Orders matter seal number 1.
Lordship, pray for a direction to the trial court to receive the cost of rupees 10,000, your lordship. The matter was listed on Friday on 21st, your lordship.
What happened?
Your lordship had directed the cost to be paid on the next date of hearing.
What was the order? Miscellaneous appeal was January 24 disposed of, and thereafter last week in order ಮಾಡಿದ್ವಲ್ರಿ. What is that order? Order sheet ಎಲ್ಲಿದೆ?
To pay the cost of rupees 10,000 and a direction to the trial court to decide the matter within 6 weeks, your lordship. The lordship had directed
6
that the
months.
cost be paid before the next date.
Cost of rupees 10,000 is payable before the trial court before the next date of hearing. If the defendant fails to pay the cost, trial court is directed to strike out the defense of the defendant in the case. Trial court is directed to dispose of the matter within 6 months from the date of receipt of copy of this order. And then why you have not made the payment?
The next date of
This
hearing-
order was passed on 21st of.
Yes, your lordship. Next date of hearing was the very next day, 22nd, to the 4th Saturday, your lordship. The banks were closed, ED could not be taken.
Why?
We went to-
Who directed you to pay the cost by way of DD? You would have paid the by way of cash.
No, my lordship, they were not accepting.
Why?
We went to the cash branch.
Cost of rupees 10,000 is payable before the defendant is fails to pay the cost. Trial court is directed to strike out the defense of the defendant in the case.
We filed a memo also before the honorable court, your lordship, with the cash amount.
Ah.
The honorable court recorded the memo. I have the order sheet, your lordship.
ಕೊಡ್ರಿ ಅದೇನು?
Memo was filed by the council for the.
Now what is the order by the trial court? Memo is filed by the council for defendant with online daily status copy in MFA. Passed by the High Court of Karnataka, Bangalore, and our orders on call on 3/12.
On Monday, next working day on Monday, we went to the DV. Trial court said that the lordship has directed to be taken only on the next date of hearing. So please get a direction.
Where is that order? Where is that order? I have to pass an order. No such order.
Wait,
Just adjourn the matter for orders call on 3/12.
Please, your lordship. But they are not accepted.
Where is the refusal of the order, council?
The lordship, they have only taken the memo record. They have not accepted.
But there is no any order at all, even refusing also. How can I pass an order without any refusal?
No, your lordship, an amendment to your lordship's order to kindly to direct them to.
This
pay
is the
more.
trial court proceedings on that day.
Yes, your lordship. We
Not-
filed a memo. We filed
Where is the order? Refusal in not accepting the cash or not permitting you to deposit the cash amount.
My lordship,
What, where is the prayer you have sought?
it is there in the memo, your lordship. We filed that memo before the order.
But there is no any order. How can I pass an order now without any order
Lordship,
the
my
trial
humble
court.
request is my humble request, Your Lordship.
Lord,
Kindly
the
direct-
counsel
My,
appearing to the,
my lord,
you
I
are
am for the,
appearing,
I am for the respondent.
for the appellate.
Now that,
ಹೇಳಿ.
who has to receive the cost paid by the appellant in this matter, man? There is no order.
Cost only the government. Payable before the trial court, before the next date of hearing ಅಂತ ಇಲ್ಲೇನ್ರಿ? ಕೋರ್ಟಿಗೆ ಕೊಡೋದು ಅಷ್ಟೇನೆ, ನಿಮ್ಗೆ ಕೊಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ.
ಅದಕ್ಕೆ
Payable
ಅದು
before the trial
specific
court ಅಂದ್ರೆ ಏನು? ಏನ್ ಸ್ಪೆಸಿಫಿಕ್ ಬೇಕು? Payable 10,000 cost is payable before the trial court, before the next date of hearing.
to whom
ಸರ್ಕಾರಕ್ಕೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ ದುಡ್ಡು. ಏನ್ ನಿಮಗೆ ಕೊಡ್ತಾರ?
much
ಹಾ.
obliged.
Kindly direct to receive them, Your Lordship.
Sure.
Receive them.
The counsel orally submits that the trial court not accepted the cost since he could not pay the cost by way of DD. ಹೋಗ್ಲಿ ಈಗಲಾರು ಪರ್ಚೇಸ್ ಮಾಡಿದಿರಾ DD ನ?
Yes, Your Lordship. Monday it was ready. We moved an advancement.
ಏನ್ರಿ ನಿಮ್ಮ ಹತ್ರ ಈಗ DD?
Yes, it is.
And counsel submits that already purchased the DD in the name of the
Registrar
City Civil Court.
Yes, Your Lordship.
And hence trial court is directed to accept the cost.
Please, sir. Grateful, Your Lordship.
Number 2, Murli BS.
Notice to Aarti Dimana deserve.
25-11 ಹೋಗಿದೆ.
25-11 ಅಂದ್ರೆ ವೆಕೇಶನ್ ಬರುತ್ತೆ. Await notice of R2 and R3 and also registry is directed to secure the records by issuing the reminder. Await both post TCR ಅಂತಿದೆಯಲ್ಲ, list this matter on 7/1/26.
Serial number 3, GT Narendra Kumar.
In favor of petitioner, my
With
lord.
proof of delivery served on IN number 1 of 25 to counsel for appellant filed by party in person. ಏನ್ರಿ ಅದು?
My lord, filed memo for retirement, my lord.
Memo for retirement.
Yes, my lord.
ನೀವ್ ಯಾರಿಗೆ ಅಪೇರ್ ಆಗೋದು?
Appearing for appellant, my lord.
ಅಕ್ಲಾನ್ಮೆಂಟ್ ಇದೆಯಾ?
Yes, my lord. Filed.
Counsel for the appellant files memo for retirement. ಎಲ್ಲಿದ್ದಾರೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್?
First sheet ಅಲ್ಲಿ.
ಫಸ್ಟ್ ಶೀಟ್ ಅಲ್ಲ,
Counter file ಮಾಡಿದ್ರು.
ಏನ್ ಫಸ್ಟ್ ಶೀಟ್?
Memo for retirement file ಮಾಡಿದ್ರಂತೆ ಸರ್ ಸೀನಿಯರ್ ಅದಕ್ಕೆ.
ಬಟ್ ನಿಮ್ದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್
ಕೋರ್ಟ್
ಬಟ್ ನಿಮ್ ಕಾಪಿನ ಇದು?
ನಿಮ್ ಕಾಪಿ.
ಕೋರ್ಟ್ಗೆ ಹಾಕಿದ್ರೆ ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
ಇವತ್ತು ಬೆಳಗ್ಗೆ ಹಾಕಿದ್ದಾರೆ ಸರ್.
ಇವತ್ತು ಬೆಳಗ್ಗೆ ಪಾಸ್ ಅವ್ರು ಬರ್ಲಿ ನೋಡೋಣ. ಅಪಲೆಂಟ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಮೆಮೋದಲ್ಲಿ ಇಲ್ಲ, ಅಪಲೆಂಟ್ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ. ಆಯ್ತು ನೋಡಿ, ಅವ್ರಿಗೆ ಏನಾದ್ರು ಕೊಟ್ಟಿರೋದು ಇದೆಯೇನು? ಪಾಸ್ ಅವರು ಶಿವಕುಮಾರ್ ಎನ್.
Serial number 4.
ನಾಟ್ ಕ್ಲೈಮ್ಡ್ 4 to 6. ನೋಡಿ
ID ಅಂತ ಇದೆ ಸರ್. ID ಅಂತ ಇದೆ.
ಎಲ್ಲರಿಗೂ ಇದೆಯಾ?
ಹೌದು ಸರ್.
Matter has been settled.
ಕೊಡಿ
Settlement.
ಕೊಡಿ ಅದೇನು
Madam.
note issued against R 4 to 6.
Memo is also filed with respect to.
Was
Number 2 to 6 may be.
returned with an endorsement not claimed and intimation is also delivered. Now the parties have filed the compromise petition. ಇಬ್ರಿಗೂ ಇದರ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋರು ಇದಾರಾ? ಅಪಲೆಂಟ್
ಇದ್ದಾರೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಇದ್ದಾರೆ. 2 to 7 ಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿದೆ. Since they are the sellers to appellant.
They are the sellers, sir.
Yes, ma'am. Sellers to the appellant.
Appellant counsel files memo to dispense the notice against respondent number 6 to 2 to 6. Since they have alienated the property in favor of respondent number 7.
2 to 7 minutes. 2 to 7.
ಅಂದ್ರೆ ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಎಲ್ಲರಿಗೂನಾ?
Yes, my lord. Apart from
dispensation of notice against 2 to 7.
2 to 7.
Since they were not having any subsisting interest. And appellant herein is claiming through them.
Yes,
hence notice is dispensed against respondent number 2 to 7. Third, appellant and the respondent number 1 have filed the compromise petition before this court under 23 rule 3. And both are present before the court. Yen compromise terms eno?
We have agreed.
R1 has paid 6,25,000.
6 crores 25 lakhs.
6 crore adu?
Yes, ma'am.
6 crore totally. In terms of the compromise, R1 paid an amount of rupees 6 crore 25 lakhs by way of two demand drafts in favor of the appellant
Then is added.
as full and final settlement.
Appellant has given up all his right.
The appellant has given up all his rights in respect of the suit scheduled property, having accepted the said amount. The DDs are handed over to the appellant through court, so in front of the court,
The original document.
and the same is acknowledged. Original
documents have
document,
been handed over, my lord.
original hand over ಮಾಡಿದಾರಾ?
ಮಾಡ್ತಾ ಇದೀವಿ, ಮಾಡ್ತೀವಿ, ಅದು
ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತೀವಿ. ಸೇಲ್ ಡೀಡ್ಸ್ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇದ್ದ ಸೇಲ್ ಡೀಡ್ಸ್ ಎಲ್ಲ ಕೊಡ್ತಾರೆ.
ಆಯ್ತು. The original documents are also handed over to the respondent number 1 before the court. To the respondent number 1, and respondent number 1 acknowledges the same. ಅಷ್ಟೇ ಅಲ್ಲ ಕಾಂಪ್ರಮೈಸ್.
That's it. ಅದು ಇನ್ನೊಂದು RA ಪೆಂಡಿಂಗ್ ಇದೆ, ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ.
ಯಾರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ಳೋದು?
ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ತೀವಿ.
Appellant also in terms of the compromise going to withdraw the pending appeal in RA ANE dot 300 of 22 pending before the assistant commissioner Anekal. ಹೌದಾ?
ಹೌದಾ?
The parties have understood the terms of the compromise and also acknowledged the amount of the compromise, and hence compromise petition is accepted and appeal is again disposed of. And in terms of the compromise,
Dismiss. Confirming the trial court judgment. Since both the judgments are to be confirmed, my lord.
and in view of the compromise, judgments passed by the trial court and appellate court is confirmed.
Yes, ma'am.
Signature ಹಾಕ್ಬೇಕು.
Seal number 5, Prasad Hegde.
Appeal for respondent A. Filed, my lords.
ಇವಾಗ ಮಾಡಿದೀರಾ? ಸರ್, ವಕಾಲತ್ ಫೈಲ್
Told counsel Sri Rakshit Kumar files wakalat for respondent number 8 before the court.
Your lordship, we have
ಇದರ ಹೆಸರು ತೋರಿಸಿದಾರ ಮೇಡಮ್ ಇವ್ರದ್ದು ಆಲ್ರೆಡಿ? hence registry is there. ಇದೆ ಹೆಸರು ಇದೆ. ಆಯ್ತು, ಈಗ ಆಯ್ತಲ್ಲ, filed wakalat before the court. What about PF ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
Your lordship, we had already filed PF, but due to some changes in address, we'll just look into the address and again we'll furnish the PF.
Last time ಫಾರಿನ್ ಕವರ್ಸ್ ಏನೇನ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರಿ ನೀವು.
We have paid the
notice in respect of R4 and R5 issue ಆಗಿದೆ ಮೇಡಮ್?
ಸರ್, R4 and 5 awaiting sir.
awaiting notice of R4 and R5.
12/11 ಹೋಗಿರೋದು.
12/11 ಬಟ್ ಈಗಲೂ ನೋಟಿಸ್ ಇವ್ರು ಯಾರಿಗೂ ಕೊಡ್ಬೇಕಲ್ಲ
ಸರ್, ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು.
R2 R3 and R7
R2 R3 we had already furnished.
ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದು ವಾಪಸ್ ಬಂದಿದೆ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ. Appellant counsel is directed to pay PF within 2 days to issue notice to R2 R3 R7 and list this matter on 19/12. Immediate ಆಗಿ ಕೊಡಿ within 2 days ಅಲ್ಲಿ.
Oblige.
Serial number 6.
Srihari NS ಹೇಳ್ರಿ. PF.
Ram lots has come as respondent number 4 and 5 have expired. I'll have to take instead.
Appellant counsel is given 2 weeks time to bring the LRs of R4 and R5 since they are no more.
I may need some more time.
And counsel is directed to pay PF to issue notice to R3 R6 to 9 within 1 week ಕೊಡ್ತೀರಾ?
That I will give it immediately. No difficulty.
Within 3 days. If PF paid, issue notice against R3 R6 to 9 returnable by.
So far as the LRs are concerned, I may be given some 3 weeks time because I'll have to.
ಈಗ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, 2 weeks ಇದೆ, 3 weeks ಮಾಡ್ರಿ. Returnable by 19/12.
I am obliged.
PF immediate ಆಗಿ ಕೊಡಿ ಅವರಿಗೆ, ಹೋಗೋರಿಗೆ.
7, Chandrasekhar Reddy.
Non filing of
weeks time, my lord. I'll file the certified copies.
ಅಲ್ಲ ರೀ, 24 ಹಾಕಿರೋದು ಅಪೀಲ್, ಇನ್ನೂ ಯಾಕೆ ಹಾಕಿಲ್ಲ ನೀವು?
ತುಮಕೂರಿಂದ ತರಿಸ್ಬೇಕು.
ತುಮಕೂರಿಂದ ತರ್ಸಕ್ಕೆ ಏನು ವರ್ಷ ಬೇಕಾ? ಯಾವಾಗ ಹಾಕಿರೋದು ನೀವು ಅಪೀಲ್?
24.
ಅದಕ್ಕೆಲ್ಲ ನಾವು ಕೋರ್ಟಲ್ಲಿ ಪ್ರತಿ ಸಾರಿ ಡೇಟ್ ಕೊಡೋದ? Learned counsel appellant is directed to produce the certified copy of the OS judgment within 2 weeks ಅಂತ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ.
Weeks time, my lord.
ಅಪೀಲ್ ಹಾಕಿರೋದು 2024 ಇಸ್ವಿಲಿ. The counsel again seeks time. Given 2 weeks time on cost of ₹500. ಕೊಡಿ, 2 ವಾರ ಬಿಟ್ಟು ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ.
10/12.
10/12. ಕರೆಕ್ಟ್. 2 ವಾರ ಆಗುತ್ತಾ ಮೇಡಮ್? 10/12 ಕರೆಕ್ಟಾ?
26 ಹೌದು.
ಆಯ್ತು.
8. Girish Kodgi.
Girish Kodgi, accepting of acknowledgement in respect of R6 bearing the signature of appellant counsel ಇಲ್ವಾ?
Clarify ಮಾಡಿ
ಮಾಡಿದೀವ ನೋಡಿ.
Last time ತಾವು order ಮಾಡಿದ್ವಿ. Appellant counsel has to
ಬರ್ಲಿ ಹಂಗಾರೆ ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
9.
Furnishing of PF etc. to issue notice to R2 to R6 for first time.
One second. Last occasion, there is no notice was issued, my lord.
Huh?
No notice was ordered.
No notice was ordered ಅಂದ್ರೆ ಏನು? ಮತ್ತೆ PF ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹಾಕ್ತಾರೆ? With no order.
no pay the PF, my lord. When once the entry order is granted.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ತಗೊಂಡವ್ರು ನೀವೇನಾ? ಮತ್ತೆ ಕೊಡ್ಬೇಡ್ವಾ?
ಇವತ್ತೇ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ಅದು ಬಟ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಅಂತ ನಾನು
ನಾಟ್ ಟು ಡ್ರಾ ದಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ.
ಇವತ್ತೇ ಕಟ್ತೀನಿ ಸ್ವಾಮಿ. ನಾನು ಐ ಆಮ್ ರೆಡಿ. ಐ ಆಮ್ ನಾಟ್.
ಯಾವಾಗ ಅದು ಆರ್ಡರ್ ಆಗಿರೋದು? 25/10 entry order granted by this court is vacated.
ಅಲ್ಲ ಇವತ್ತೇ ಕಟ್ತೀನಿ.
Since the PF is not paid to issue notice to the respondent.
ಇಲ್ಲ ಅಂತ ಕಟ್ಟಿರಲಿಲ್ಲ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ಕಟ್ಟಿರಲಿಲ್ಲ.
ಏನ್ ಆರ್ಡರ್ ಇಲ್ಲ? ಇಲ್ದವ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಟ್ಟ ತಕ್ಷಣ PF ಕೊಡ್ಬೇಕಲ್ವಾ? ಎಂಟ್ರಿ ಮಾಡ್ರ್ ನೀವು ಹಂಗಾರೆ ನೋಟಿಸ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ತಗೊಂಡು ನೀವು ಇಟ್ಕೊಂಡು ಸುಮ್ಮನೆ ಕೂತ್ಕೋಬಹುದು ಅಂತಾನ?
ಇವತ್ತೇ
vacated.
ಅಲ್ಲ ಇವತ್ತೇ ಕಟ್ತೀನಿ ಸ್ವಾಮಿ. ಕೈಲಿ
ಪಾಸ್ ಓವರ್
ಪ್ಲೀಸ್.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
10.
Avoid service of notice in respect of R1 to 12. ಯಾವಾಗ? 7/11. 9/12. Avoid notice 9/12.
Hearing on
Ananjay Kumar recalling the order dated 28/25.
11.
Matter was dismissed for non-prosecution.
ಏನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಹೇಳಿ ಮೇಡಮ್? 22ರದ್ದು 22ನೇ ಇಸ್ವಿ ಅಪೀಲ್ 25ರಲ್ಲಿ ಡಿಸ್ಮಿಸಲ್ ಆಗಿದೆ. ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸಲ್ ಆಯ್ತು? ರಿಕಾಲ್ ಯಾಕೆ ಮಾಡಬೇಕು? ಟೆಲ್ ಮಿ ದ ರೀಸನ್ಸ್.
Matter was listed for non. Matter on the.
ಎಲ್ಲ ನೀವೇ ಓದ್ಕೊಂಡು ನೀವೇ ಬರೀ ಆರ್ಡರ್ ಅಂತನಾ ಅಥವಾ ಏನು? ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಎಷ್ಟು ಸರಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ? ಒಂದು ಇದು 20th August. ಇದ್ಯಾಕ್ರಿ ಎರಡೆರಡು ಕಾಪಿ ಇಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್? Case called twice. None represents on behalf of the appellant. By order dated 9/1/24, this court granted 2 weeks time as a final chance to comply the office objections on the condition of payment of cost of rupees 1,000 to Karnataka State Legal Services Authority. Neither the cost is paid nor the office objections are complied even after 1 year 7 months. Taking note of the fact that appeal is of the year 2022 till date no office. ಏನಕ್ಕೆ ರಿಕಾಲ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಕಾಸ್ಟ್ ಪೇಡ್ ಮಾಡಿದ್ರು ಹೋಲಿ ಇಲ್ಲ, ಕಾಸ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ.
Yeah, we have paid that.
ಯಾವಾಗ? ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ? 1 2 3 4 ಸರಿ ಇವ್ರ ಮುಂದೆ, 5ನೇ ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಕಾಸ್ಟ್ ಹಾಕಿ 2 ವಾರ ಟೈಮ್ ಕೊಟ್ರು, ಆದ್ರೂ ಕಟ್ಟಿಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ 2 ಸಲ? ಆರ್ಡರ್ ಆಗಿರೋದು 9/1/24. ಅವಾಗ ಇನ್ನೊಂದು 24 23/8 ಅಲ್ಲ, 23/8 ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ ಕಟ್ಟವ್ರೆ. ಮತ್ತೊಂದ್ಸರಿ ನಾವು ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಏನು ಆರ್ಡರ್ ಮಾಡಿದೀವ? ಮತ್ತೆ ಹೋಗ್ ಮೇಡಮ್ 7/11. ಮತ್ತೆ ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ A number 25. 1 week time is granted to comply with office subject since the learned counsel for the appellant submits that cost of rupees 1,000 imposed earlier was paid subsequent to the dismissal of the appeal. ಇಲ್ರಿ ಮತ್ತೆ ಕಟ್ಟಿದ್ರು?
On the last date of hearing, you imposed a.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀನಿ ನಾವು ಅದಕ್ಕೇನೆ, ನಾನೇ ಆಮೇಲೆ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಅಂತ ಮಾಡಿದ್ದೀನಿ. ಮತ್ತೆ ಆರ್ಡರ್ ಆಗಿದೆಯಾ 3/11 ಅಲ್ಲಿ ಆದ್ಮೇಲೆ? ಒನ್ಸ್ ಅಗೇನ್ ಮತ್ತೆ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೋಗ್ಲಿ ಕಂಪ್ಲೈರ್ ಮಾಡಿದ್ರೇನ್ರಿ?
Yes, my lord. This has been complied.
ನೋಡಿ order on A number 1/25 for recalling the order dated 28/25 and on perusal of the order in spite of sufficient opportunity is given not complied and hence impose the cost, and subsequently after the dismissal of the appeal cost was paid, and also this court granted time to comply with the same, and even in spite of it not complied and hence further cost of rupees 1,000 is imposed, and subsequently the cost is paid and also the office objections are complied, and hence I 1 of 25 is recalled. Post the matter for admission on date kodi
12.
12/12.
Serial number 12, Naveen Jain.
Here for appellate notice issue ಆಗಿದೆ ಡಿಲೇ ಇದೆ ತುಂಬಾ ತುಂಬಾ ದಿನ ಡಿಲೇ ಇದೆ ಒಂದು
ಏನ್ ಹೇಳಿ
ತುಂಬಾ ದಿನ ಡಿಲೇ ಇದೆ
ತುಂಬಾ ದಿನ ಡಿಲೇ ಇದೆ ಏನ್ ಮಾಡ್ಬೇಕು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ ಡಿಲೇನ ಹೇಳಿ
ಸೀನಿಯರ್ ಧಾರವಾಡ
1120 days ಸೀನಿಯರ್
ಧಾರವಾಡ ಕೇಸ್ ಅಲ್ಲಿ ಹೆಲ್ಡಪ್
ನೀವ್ ಯಾಕೆ ಬಂದ್ರಿ ಕೋರ್ಟ್ಗೆ ಓದಿದ್ರಾ ಅಯ್ಯನ ಅಯ್ಯ ಓದಿದ್ರಾ ಅಯ್ಯ ಓದ್ಲಿಲ್ವಾ ಸೀನಿಯರ್ ಧಾರವಾಡಕ್ಕೆ ಹೋದ್ರಿ ನೀವೇನ್ ಮಾಡಿರಿ ಹೇಳಿ ಟೈಮ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು ನೀವ್ ಯಾಕೆ ಓದ್ಲಿಲ್ಲ ಅಯ್ಯನಾ RA was dismissed in the year 2022 and FDP was filed by the plaintiff herein. In the FDP, there were negotiations being done for settlement. However, the matter was not settled between the parties. I submit that since the matter was being compromised between the parties, we have not taken any steps to file the appeal before the court. I submit that I am well advised with the legal aspects. I could take steps to file the appeal before this honorable court immediately on the disposal of the regular appeal. Arranging this on, sir. Yen reason? ಸೆಟ್ಲ್ ಆಯ್ತು ಅದಕ್ಕೋಸ್ಕರ ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂತ ಸೆಟ್ಲ್ ಆದ್ರೆ ಅಲ್ಲೇ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತಲ್ಲ ದಟ್ ಈಸ್ ಓನ್ಲಿ ರೀಸನ್ ಏನು ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ half share in the social properties and separate possession of their share concurrent pending ಎಲ್ಲ ನೀವೇ ಓದ್ಕೊಳ್ಳಿ ಅಂತ confirmed. Thoroughly. Heard the counsel appearing for the appellant on IA number 1 of 25. And there is a delay of 1120 days in filing the appeal. And counsel appearing for the appellant brought to notice of this court. Reasons are assigned in paragraph number 3 and 3, 4 and 5. And having perused the paragraph number 3, it is stated that RA was dismissed in the year 2022 and thereafter FDP was filed. And in the said FDP, there were negotiations. However, the matter was not settled between the parties. And in view of compromise talk between the parties, not taken any steps to file the appeal before the court. And since the matter was not settled, decided to file the present appeal after arranging money from the friends and relatives. Hence, delay has to be condoned. Having taken note of the reasons assigned in the affidavit, it is not their case that they are not having any knowledge about the judgment passed in RA. But only reason is stated that FDP was filed and they were negotiating but not settled. And no proper explanation to condone the delay of 1120 days. And each delay has to be explained and no sufficient cause is shown to condone the delay. And RA was disposed of on 5/4/22 and present appeal is filed on 28/7/25. And the reason assigned that they were negotiating cannot be a reason. Apart from that, this appeal is against the concurrent finding and the trial court granted half share in the social properties in favor of the plaintiff and the same is confirmed in the appellate court. And when such being the case, I do not find any ground to admit and frame I do not find any ground to condone the delay of 1120 days and hence IA is rejected. Consequently, second appeal is dismissed. ಆಯ್ತು ಹೇಳಿ ಸೀನಿಯರ್ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ ಅಂತ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಿರಿ ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಪ್ಯಾರಾ 3, 4, 5 ಎಲ್ಲ ನೀವೇ ಹೇಳಿದ್ರಿ ಅಂತ ಆರ್ಡರ್ ತಗೊಂಡೋಗಿ ತೋರಿಸಿ ನಿಮ್ ಸೀನಿಯರ್ ಏನಾದ್ರು ಬೈದ್ರೆ ನೆಕ್ಸ್ಟ್
ಅಭಿಷೇಕ್ ಸುಧಾರ್
dispensation of production of CC of judgment and decree passed in RE number 3 of 25 and OS number 67 of 19. ಹೇಳ್ರಿ ಏನಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೇಕು?
Lords,
What was the date of order?
I've applied for the certified copy, my lords. The urgency, my lord, is that the defendant, the respondent now, my lord, has put up stones and mud right across that road, my lords. I have no ingress and egress to my property.
Plaintiff have easement right over the B scheduled property by of necessity to ingress and egress. Is it a divergent finding?
Divergent findings. The trial court decrees it in my favor, my lords.
Hereby allowed. Set aside.
Yes, lords.
Heard on A number 1 of 25 for dispensation of production of CC of the judgment. Judgment was passed in the month of September.
I've applied for the my lords. What had happened, my lords? The respondent want to put the stones right across my road, my lords.
Whatever it may be, judgment was passed in the month of September.
I've applied for the certified copy, my lords.
On what date you have applied?
I have received it, my lords. I couldn't. The decree of the trial court is there, and also the REM, lords. I will find. I got it now. Maybe I procured the copy.
Now you are having copy.
I have the copy.
And then why you are seeking for dispensation?
That was filed at the time of filing, lords.
Now you can take submission, not pressing the IA.
Not pressing the IA.
Now you are having copy of judgment of both.
Both.
Submission madakkenu. Counsel for the appellant submits that they have obtained the certified copies of RA number 3 of 25 and OS number 67 of 19 and going to produce the same before the court today itself. And hence list this matter for admission on date code, madam.
Admission, lords. Such time they may not disturb me using that. That is the only road I have, lords.
12.
That is the only roads I have, lords. No precipitative action will be taken, lords. They are dumping the stones and.
Next week kodi.
512.
512. 512.
Such time they may not dump anything on the road.
Without reading the papers, I will not consider any matter for interim relief. I have given date 512. You come on 512. That's all.
Parted in admission 14. Girish MK, BS Prasad.
For the respondent in this case, my lord.
Last time, guidance value.
ನಮ್ಮ ಪಾರ್ಟಿ ಹತ್ರ ಕೇಳಿದೆ ಇಸ್ ಎ ಬ್ರದರ್ ಏನ್ ಕೊಟ್ಟರು ಒಳ್ಳೆ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗಲ್ಲ, ಈಗಾಗ್ಲೇ ತುಂಬಾ ಇಸ್ಕೊಂಡ್ಬಿಡಿ ಇದ್ದಿದ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಸೇಲ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಲಾಸ್ಟ್ ಮಂತ್ 3 months ಬ್ಯಾಕ್ ಮತ್ತೊಂದಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೋಸ್ಕರ ಒಳ್ಳೆ ಕೆಲ್ಸಕ್ಕೆ ಹೋಗೋದಾದ್ರೆ ಕೊಡಬಹುದಾಗಿತ್ತು, ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ.
ಏನಾಗಿದೆ ಡಿಕ್ರಿ ಆಗಿದೆ? ಏನಾಗಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್? ಡಿಕ್ರೀಡ್ ಕನ್ಫರ್ಮ್ಡ್. Plaintiff is entitled for specific performance of the contract. Defendants are directed to execute the sale deed.
ಆನ್ಸಿಸ್ಟರ್ ಪ್ರಾಪರ್ಟಿ ಉಳಿಸೋದಕ್ಕೋಸ್ಕರ ನಾವು ಪರ್ಚೇಸ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಲೋನ್ ತಗೊಂಡಿರ್ತಾರೆ, ಆ ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡೋಕ್ಕೋಸ್ಕರ he has lent the money.
ಅದೆಲ್ಲ ಆಗೋಯ್ತು. 2 ಕೋರ್ಟಲ್ಲಿ ಫೈಂಡಿಂಗ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಮೋಸ್ಟ್ಲಿ ಏನೋ ಸಮ್ ರೀಸನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಏನೋ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಏನೋ ಕೊಡಿ ಅಂತಂದ್ವಿ. ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಪ್ರಕಾರ ಏನಿದೆ? ಇದು ಎಷ್ಟಿದೆ ಪ್ರಾಪರ್ಟಿ? 1 acre 10 gunters. What was the sale consideration? 4 lakhs. ಎಲ್ಲಿರೋದು ಲ್ಯಾಂಡ್?
3,45,000
at the time of agreement.
4,31,500.
4,31,500 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕಂಪ್ಲೀಟ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. But that was paid to clear the loan. ಅದು
ಯಾವ್ದನ್ನ ಕ್ಲಿಯರ್ಲಿ ಲೋನ್?
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ
ಅದೇ ನೀವು ಲೋನ್ ಮಾಡಿದ್ದನ್ನ ಕ್ಲಿಯರ್ ಮಾಡಕ್ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಹೌದಾ? ಪ್ರಾಪರ್ಟಿ ಸೇಲ್ ಮಾಡಿ ಅಗ್ರಿಮೆಂಟ್ ಬರ್ಕೊಟ್ಟಾಗ ಲೋನ್ ಅಮೌಂಟ್ ವಾಸ್ ಪೆಂಡಿಂಗ್. ಹೌದಾ?
ಲೋನು ಬೇರೆಯವ್ರ ಹತ್ರ ಇದ್ದು, ಇವ್ರ ಹತ್ರ ಅಲ್ಲ.
ಯಾರ ಹತ್ರಲ್ಲೇ ಆಗ್ಲಿ ದುಡ್ಡು ನಿಮ್ ಲೋನ್ ಅವ್ರು ಕಟ್ಟಿದ್ದಾರೆ. ಹೌದಾ?
ಆದ್ರೆ ಪ್ರಾಪರ್ಟಿ ನಾನು ಅವರಿಗೆ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗ್ಲಿ ಮಾರ್ಟ್ಗೇಜ್ ಆಗ್ಲಿ ಮಾಡಿರ್ಲಿಲ್ಲ. ಇವರು ಇನ್ಫ್ಲುಯೆನ್ಸಿಂಗ್ ಅದು ನನ್ನ ಫೈಂಡಿಂಗ್. ನಾನು
ಕ್ಲಿಯರ್ ದಟ್ ದಿ ನೋಡ್ರಿ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ನೋಡ್ರಿ, ಫ್ರಮ್ perusal of the above direction it is clear that he knows Kannada language and he along with his wife can also read Kannada, and usually he put his signature only after reading the document, but according to him he and his wife have signed exhibit P1 without reading the contents of the document. This version of DW1 is not believable one. except oral evidence. The defendants have not produced any documentary evidence to prove their contention. The entire burden to prove that the sale agreement dated is nominal sale agreement and the said agreement is fraudulent one. But except oral evidence, the defendants have not produced any material to prove their contentions. This is the reasoning given by the trial court. The same is confirmed.
PW2 ಹೇಳ್ತಾರೆ ಆ ರೀತಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ನಡೆದಿರಲಿಲ್ಲ ಅಂತ. Just I will read the deposition of PW2. ಅವ್ರ ವಿಟ್ನೆಸ್ ಹೇಳ್ತಾರೆ, ಹಾಸ್ಟೆಲ್ ಆಗ್ತಾರೆ ಅವರು.
Exhibit P1. ಕಂದಾಯ ವಗರ ಏನೇ ಋಣಭಾರ ಇದ್ದಲ್ಲ ಸರ್ವೆ ಸ್ಕೆಚ್ ಮಾಡಿ ಪುಸ್ತಕವನ್ನು ಈ ಲಾಗಾಯ್ತು ನೀವು ನಿಮ್ಮ ಬರೀದಕ್ಕೆ ಹಾಜರು ಮಾಡಿ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಕ್ರಯ ನೋಂದಣಿ ಮಾಡೋಕೆ ನಾವು ಬರೆದಿದ್ದು ಕಾನೂನು ರೀತಿಯ ಸ್ವಸ್ತಿನ ಕ್ರಯಕ್ಕೆ ನಾವು ಸಿದ್ಧಪಡಿಸಿಕೊಳ್ಳಾಕಿ ನೀವು ಸಮಸ್ತ ಖರ್ಚು ವೆಚ್ಚ ಲಿಗಾಲನ್ನು ಹೊಣೆಗಾರರಾಗಿರುತ್ತೇವೆ. ಇದೆಲ್ಲ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಮತ್ತೆ
ರಿಲೆವೆಂಟ್ PW1 ಕ್ರಾಸ್ ಅಲ್ಲಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ವೈಯಕ್ತಿಕವಾಗಿ ಏನೇನು ವ್ಯವಹಾರ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ತಮ್ಮ ಆಸ್ತಿಯ ಹಂಚಿಕೆ ಸಂಬಂಧ, ಸಾಲ ಮತ್ತು ವ್ಯಾಪಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವ ರೀತಿ ಹಂಚಿಕೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕರಾರು ಪತ್ರದಲ್ಲಿ ಬರೆದಿರುವ ವಿಚಾರಗಳು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ನೋಂದಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಗೆ ನನ್ನ ವೈಯಕ್ತಿಕ ಕೆಲಸಕ್ಕೆ ಬಂದ ಸಮಯದಲ್ಲಿ ವಾದಿಯು ಸಹಿ ಹಾಕಿ ಎಂದು ಕೋರಿಕೊಂಡ ಮೇರೆಗೆ ನಾನು ಸಹಿ ಹಾಕಿದ್ದು, ಅದರಲ್ಲಿ ಇರುವ ವಿಚಾರಗಳು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ತಿಳಿಸಿರುವ ಅಂಶಗಳು ವಾದಿಯು ಬರೆಸಿದ್ದು, ಇದರಲ್ಲಿ ಇರುವ ವಿಚಾರಗಳು ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಇದು PW2 ಇವ್ರ ವಿಟ್ನೆಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿರೋದು. No one has supported.
Registered agreement ಇದು.
Registered agreement. I am not. Even my wife, this defendant's wife also signed it.
Then both of them, why they went to the sub-registrar office?
Yes.
Then why they went to the sub-registrar office? If they are not intending to sell the same.
Agreement to sell ಅಂತ ಹೇಳಿರಲಿಲ್ಲ. Mortgage ಅಂತ ಹೇಳಿ.
ಹಾಗಂತ ಎಲ್ಲಿದೆ?
ಈವನ್ ವಿಟ್ನೆಸ್ ಕೂಡ ಅದೇ ಹೇಳ್ತಾರೆ, ಏನು ವಿಚಾರ ನಡೀತು ಅವರವರಲ್ಲಿ ತುಂಬಾ ವಿಚಾರಗಳಿತ್ತು ಅಂತ ಹೇಳಿ. ಇಟ್ ವಾಸ್ ಕಮ್ ಅಂಡರ್ ಪಾರ್ಟಿಷನ್. ಅದ್ರ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. ನನ್ನ ಹತ್ರ ಇರೋದಿಷ್ಟೇ, ಇವ್ರು ಹೇಳೋದು ಇವಾಗ ಹೇಳೋದು ನಾಟ್ ಕರೆಕ್ಟ್. ಈಗ ನಾನು ಮತ್ತೆ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ. ಇದ್ದಿದ್ದೇ 1 ಎಕರೆ 10 ಗುಂಟೆ ನನಗೆ ಬಂದಿದ್ದ ಪಾರ್ಟಿಷನ್. ಅದು ಇಟ್ಸ್ ಹೈಲಿ ವ್ಯಾಲ್ಯೂಯಬಲ್ ಲ್ಯಾಂಡ್.
ಒಂದನೇ ಪ್ರತಿವಾದಿಯು ದುಶ್ಚಟಗಳಿಗೋಸ್ಕರ ಸಾಲ ಮಾಡಿ ಜಮೀನುಗಳನ್ನು ಭೋಗ್ಯ ಮಾಡಿದ್ದರೆಂದರೆ ಸರಿ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಸುಳ್ಳದಲ್ಲಿ ರಾಜಮಣಿ ಎಂಬವರಿಗೆ 3 ರಿಂದ 4 ಲಕ್ಷಗಳಿಗೆ ಜಮೀನನ್ನು ಭೋಗ್ಯ ಮಾಡಿದ್ದರು. ನಾನು ಸದರಿ ಭೋಗ್ಯವನ್ನು ಖುಲಾಸೆ ಮಾಡಲು ಒಂದನೇ ಪ್ರತಿವಾದಿಗೆ ಹಣ ನೀಡಿದ್ದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ದಿನಾಂಕ 28/7 ಭೋಗ್ಯ ಖುಲಾಸೆ ಆಗಿರುತ್ತದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಹಾಜರಿದ್ದು ಹಣ ಕೊಟ್ಟು ಖುಲಾಸೆ ಮಾಡಿರುತ್ತೇನೆಂದರೆ ಸರಿ. ನಿಮ್ದೇ ಸಜೆಷನ್. ನೀವೇ ಅವನಿಗೆ ಕ್ರಾಸ್ ಮಾಡುವಾಗ ಸಜೆಸ್ಟ್ ಮಾಡಿ ಭೋಗ್ಯ ಏನಾಗಿತ್ತು ಆ ಭೋಗ್ಯ ಕ್ಲಿಯರ್ ಮಾಡಕ್ಕೆ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ.
ಅದೇ ಭೋಗ್ಯಕ್ಕೆ ಕೊಟ್ಟಿದ್ದು, ನಾಟ್ ಫಾರ್ ಸೇಲ್.
ಭೋಗ್ಯ ಖುಲಾಸೆಗೆ ರೀ. ಮೊದ್ಲೇ ಭೋಗ್ಯ ಆಗಿತ್ತು ರಾಜಮಣಿ ಅನ್ನೋರಿಗೆ. ಹೌದಾ? ಅದನ್ನ ಭೋಗ್ಯವನ್ನ ಬಿಡಿಸ್ಕೊಟ್ಟವನೇ ಇವನು. ಅವಾಗ ನೀವು
ಅದನ್ನೇ ಇನ್ನೊಬ್ರು ವಿಟ್ನೆಸ್ ವಾಟ್ ವಾಸ್ ಸೆಡ್
ಭೋಗ್ಯವು ನೋಂದಾಯಿತ ಭೋಗ್ಯ ಪತ್ರ ಆಗಿರುತ್ತೆ. ಸದರಿಗೆ ದಾಖಲಾತಿ ಭೋಗ್ಯ ಪತ್ರ ಆಗಿರುವುದಿಲ್ಲ ಎಂದು ಕ್ರಯದ ಪರವರು ಆಗಿರುವ ರಾಜಮಣಿಯವರು ಮಾತ್ರ ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡ್ತಿದೆ ಎಂದು ಸರಿ. ಕ್ರಯ ಕರಾರು ಸಾಲದ ಭದ್ರತೆಗೆ ದಾಖಲಾತಿ ಮಾಡಿಕೊಟ್ಟು ಜಮೀನನ್ನು ರಾಜಮಣಿಯವರಿಗೆ ಒಂದನೇ ಪ್ರತಿವಾದಿ ವಹಿಸಿದ್ದರು ಎಂದರೆ ಸರಿ. ನಾನು ಬೇರೆಯವರು ಜಮೀನನ್ನು ಸಾಗುವಳಿ ಮಾಡಿ ನಮಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಎಂದು ನಾನೇ ಒಂದನೇ ಪ್ರತಿವಾದಿಗೆ ಹಣ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಇನ್ ಆರ್ಡರ್ ಟು ಪ್ರೂವ್ ದಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದಿ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್, ದ ಪ್ಲೇಂಟಿಫ್ ಹ್ಯಾಸ್ ಎಕ್ಸಾಮಿನ್ಡ್ ಒನ್ ವಿಟ್ನೆಸ್ so and so clearly deny the government's in this affidavit so and so.
Page 47 ಒಂದು ಸ್ವಲ್ಪ ಇಂಟರ್ನಲ್ ಪೇಜ್ 47 ನ ಒಂದೇ ನಿಮಿಷ ಒಂದು ಪ್ಯಾರಾ ಓದ್ತೀನಿ. ನಾನು 10ನೇ ತರಗತಿಯವರೆಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿರುತ್ತೇನೆ. ನನಗೆ ಕನ್ನಡ ಓದಲು ಬರೆಯಲು ಬರುತ್ತದೆ. ಈ ದಾವೆಯ ವಾದಿ ನನಗೆ ಅಣ್ಣನಾಗಬೇಕು. ನಾನು ವಾದಿಗೆ ದಾವಾ ಆಸ್ತಿ ಕುರಿತು ಕ್ರಯಪತ್ರವನ್ನು ಮಾಡಿಕೊಟ್ಟಿದ್ದೆ ಎಂದರೆ ಸಾಕ್ಷಿ ನಾನು ಆ ರೀತಿ ಕ್ರಯಪತ್ರ ಮಾಡಿಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ವಾದಿಯಿಂದ ಸಾಲ ಪಡೆದಿದ್ದು ಆ ಕುರಿತು ಕ್ರಯಪತ್ರವನ್ನು ಮಾಡಿಕೊಟ್ಟಿದ್ದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು ಸದರಿ ಕ್ರಯಪತ್ರವನ್ನು ಓದದೆ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ನನ್ನ ಹೆಸರಿನಲ್ಲಿ 1 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನಿರುತ್ತದೆ. ಕ್ರಯಪತ್ರದಲ್ಲಿ ಎಷ್ಟು ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಿದ್ದೀರಿ ಎಂದರೆ ಸಾಕ್ಷಿ ನಾನು ಮಾರಾಟ ಮಾಡಿರುವುದಿಲ್ಲ, ನಾನು ಬೇರೆಯವರಿಗೆ ಆಸ್ತಿಯನ್ನು ಭೋಗ್ಯ ಮಾಡುತ್ತಿದ್ದೆ. ಆಗ ವಾದಿ ನನಗೆ ಭೋಗ್ಯಕ್ಕೆ ನೀಡು ಎಂದು ತಿಳಿಸಿದ್ದರಿಂದ ವಾದಿಗೆ ಭೋಗ್ಯಕ್ಕೆ ನೀಡಿರುತ್ತೇನೆ. ನಾನು ಸರ್ವೆ ನಂಬರ್ 73ರ 1 ಎಕರೆ 10 ಗುಂಟೆ ಬೇರೆಯವರಿಗೆ ಭೋಗ್ಯಕ್ಕೆ ನೀಡುತ್ತಿದ್ದೆ. ಅದನ್ನು ವಾದಿ ಸದರಿ ಜಮೀನನ್ನು ಭೋಗ್ಯಕ್ಕೆ ಪಡೆದಿರುತ್ತಾರೆ. ವಾದಿ ದಾವಾ ಜಮೀನನ್ನು ನನಗೆ ಭೋಗ್ಯಕ್ಕೆ ನೀಡು ಎಂದು ದಾಖಲೆಗೆ ಸಹಿ ಪಡೆದಿರುತ್ತಾರೆ. ನಿಶಾನೆ P1ರಲ್ಲಿರುವ ಸಹಿಗಳು ನನ್ನ ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯದು ಆಗಿರುತ್ತದೆ. ನಿಶಾನೆ P1ರ ಖರೀದಿದಾರರಾದ ವಾದಿಯ ಸಹಿ ಕೂಡ ಇದೆ ಎಂದರೆ ಸರಿ. ದಾವಾ ಆಸ್ತಿ ನನ್ನ ತಂದೆಯಿಂದ ನನಗೆ ಬಂದಿರುತ್ತದೆ. ನಿಶಾನೆ P1ರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 24 P/12ರಲ್ಲಿ 5 ಗುಂಟೆ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 73ರಲ್ಲಿ 1 ಎಕರೆ 5 ಗುಂಟೆ ಎಂದು ನಮೂದಾಗಿದೆ ಅಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ನಾನು ಭೋಗ್ಯಕ್ಕೆ ನೀಡಿದ್ದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಅಂದ್ರೆ ಡ್ಯೂರಿಂಗ್ ದಟ್ ಟೈಮ್ ಇಟ್ ವಾಸ್ ಅಂಡರ್ಸ್ಟುಡ್ ಬಿಕಾಸ್ 4,30,000 ಅವತ್ತಿಗೆ ಇದು 20 ಲಕ್ಷ ಜಮೀನ್ ಸ್ವಂತ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ. ಐ ಆಮ್ ನಾಟ್ SR ವ್ಯಾಲ್ಯೂ ಮೋರ್ ದೆನ್ 4 lakhs.
ಈಗ ಎಷ್ಟಿದೆ SR? ಅವತ್ತಿನ ದಿವಸಕ್ಕೆ ಎಷ್ಟಿದೆ SR ವ್ಯಾಲ್ಯೂ?
3,37,000 ಇತ್ತು ಸುಮ್ಮನೆ. ಒಂದ್ ನಿಮಿಷ ಇನ್ನೂ ಹೇಳ್ತೀನಿ, ಒಂದೇ ನಿಮಿಷ. ಪೇಜ್ 1 ನಲ್ಲಿ
ಈಗ ನೀವು ಕೊಟ್ರಲ್ರಿ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ,
ಅದ್ರೊಳಗೆ ಇವತ್ತಿನ ವ್ಯಾಲ್ಯೂ 22,50,000 SR ವ್ಯಾಲ್ಯೂ.
ಇವತ್ತಿನ ವ್ಯಾಲ್ಯೂ ಬಿಡ್ರಿ, ಅವತ್ತಿಂದ ಹೇಳ್ರಿ.
ಅವತ್ತಿಂದು 8,25,000 ಭಾಗ ಆಯ್ತು. ತರಿ ಬಂದು 3,45,000.
ನಿಮ್ದು ಯಾವ್ದು ತರಿ ಲ್ಯಾಂಡ್?
ತರಿಲಿ ತೋರಿಸಿದ್ದಾರೆ, ಬಟ್ ಭಾಗ ಆಯ್ತು. ಅದು ಅಡಕೆ ತೋಟ ಇದೆ, ಇವ್ರೆ ಅಡಕೆ ತೋಟ ಅದು. ಈ ಪಾಣಿಯಲ್ಲಿ ಚೇಂಜ್ ಆಗಿಲ್ಲ ಅಷ್ಟೇ. 8,25,900 ರೂಪಾಯಿ ಇತ್ತು.
ಈಗ ನೀವು ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಎಷ್ಟಿರೋದು
ಇಷ್ಟೇ? 4,35,000.
4,31,500 ಮಾತ್ರ ಕೊಟ್ರದ?
ಅಷ್ಟೇ.
ಬಾಕಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ?
ಬಾಕಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಈ 4,31,500 ಯಾರ ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ? ನಿಮ್ಮ ಪ್ರಕಾರ ಸೇಲ್ ಇರೋದೇ 4 ಲಕ್ಷಕ್ಕಲ್ಲ?
ಅಲ್ಲ, 4,35,000ಕ್ಕೆ ಫುಲ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
4,35,000ಕ್ಕೆ
4,35,000ಕ್ಕೆ 4,31,500 ರೂಪಾಯಿ.
$4,31,500 ಏನಕ್ಕೆ ಅಂತ ಕೊಟ್ಟಿದ್ದು?
ಈ ರಾಜಾಮಣಿ ಅನ್ನೋರಿಗೆ ಭೋಗ್ಯ ಮಾಡಕ್ ಕೊಟ್ಟಿದ್ದು. ಅದನ್ನ
ಕ್ಲಿಯರ್
ಮಾಡಕ್ಕೆ ಬೇರೆಯವ್ರು ಬಂದ್ಬಿಡ್ತಾರೆ ಈ ಜಾಗಕ್ಕೆ.
$4,31,500.
ಸಮ್ ಅದರ್ ಪರ್ಸನ್ ವಿಲ್ ಕಮ್ ಟು ದಿಸ್ ಲ್ಯಾಂಡ್ ಅಂತ ಇದೆಲ್ಲ
ಪ್ರಸಾದ್.
ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ ಒಂದು
ಮ್ಯೂಟ್ ಆಗಿದೆ ನೋಡಿ, ಮ್ಯೂಟ್ ಆಗಿದೆ.
Guidelines value is 3,45,000. Out of this amount, Ballard, each and every time he has taken money. He's a own brother, and he is selling the property. And only for the SR value, showing SR value, is shown as 3,41,000.
ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಅಷ್ಟಿತ್ತು, ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು?
3,45,000 ಗೈಡ್ಲೈನ್ಸ್ ವ್ಯಾಲ್ಯೂ ಇತ್ತು ಅವಾಗ.
ಆಯ್ತು, 3,45,000 ಗೈಡೆನ್ಸ್. ವಾಟ್ ವಾಸ್ ದಿ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ?
ಅದಕ್ಕಿಂತ ಕ್ಯಾಶ್ ಅಣ್ಣ ತಮ್ಮ ಆಗಿದ್ರಿಂದ ಅವ್ರ ಅಡ್ಮಿಷನ್ ಬರುತ್ತೆ. ಅವ್ರ ದುಶ್ಚಟ ಆಯ್ತು.
ನೀವು ಕೂಡ ಅಡ್ಮಿಷನ್ ಮಾಡಿರೋದು ಅದೇನೆ. ಮೊದ್ಲು ರಾಜಮಣಿ ಅವರಿಗೆ ಮಾರ್ಟ್ಗೇಜ್ ಆಗಿತ್ತು, ಅದನ್ನ ಕ್ಲಿಯರ್ ಮಾಡಕ್ಕೋಸ್ಕರ ದುಡ್ಡು ಕೊಟ್ಟಿರೋದು ಅಂತ. 4,31,500.
ಅಷ್ಟಲ್ಲ, ಅಷ್ಟ ಅಮೌಂಟ್ ಅಲ್ಲ.
ಎಷ್ಟು ಕೊಟ್ರಿ?
This sale deed, my lord, shows that, my lord, is 4,31,500 because it's a SR value. They are shown the SR value. Out of that amount, my lord, they are already given. Even then, this admission given.
ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ 4,31,500 ಕೊಟ್ಟಿರೋದು.
Yes, my lord. That agreement, as per the agreement. As per the agreement.
ನಿಮ್ಮ ಪ್ರಕಾರ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಎಷ್ಟು ನಿಮಗೆ ಮಾರಕ್ ಒಪ್ಕೊಂಡಿದ್ದು?
ಸೇಲ್ ಅವಾಗ 8.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ನಮ್ಮ ಪಾರ್ಟಿ ಹೇಳ್ತಾ ಇರೋದು. 8.5 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ. ಬಟ್
ಕೊಟ್ಟಿದ್ದ ದಾಖಲೆ ಏನಿದೆ?
ದಾಖಲೆ ಏನಿಲ್ಲ. ದಾಖಲೆ ಏನಿಲ್ಲ. ಬಿಕಾಸ್
8.5 ಲಕ್ಷ ತೋರಿಸಿ ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ತೋರ್ಸಕ್ ಏನಾಗಿತ್ತು ಆ 8.5 ಲಕ್ಷನ?
Lordship knows, my lord, each and every person shows in agreement lesser value because
ಸೇಲ್ ಡೀಡ್ ಆದ್ರ ನೀವ್ ಹೇಳೋ ಮಾತನ್ನ ಸೇಲ್ ಡೀಡ್ ಯಾರ ಕೇಳೋಣ. ಯಾಕೆಂದ್ರೆ ನೀವು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಅಲ್ಲಿ ವ್ಯಾಲ್ಯೂ ಅದ್ರ ಮೇಲೆ ಕೊಡ್ಬೇಕು. ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ತೋರ್ಸಕ್ ಏನು? ವಾಟ್ ವಾಸ್ ದ ಪ್ರೈಬಿಷನ್?
ಇಟ್ಸ್ ಎ ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್. ದಟ್ಸ್ ವೈ. ಅವರ ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ ಐ ಡೂ ಅಗ್ರಿ ಮೇಲೆ. ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ ವಿ ಹ್ಯಾವ್ ಟು
ಹೋಗ್ಲಿ. ಬಾಕಿ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ? ರಸೀಟ್ ಇದೆಯಾ?
ಬ್ರದರ್ಸ್ my lord, that is the reason, my lord. ಬ್ರದರ್ಸ್ even
ಅವ್ರ ಪ್ರಕಾರ 8.5 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ಇದಿಷ್ಟೇ ಕೊಟ್ಟಿರೋದು. ಆ ರಾಜಮಣಿ ಕೊಟ್ಟಿದ್ದು ನನಗಿರೋದೇ ಇದೊಂದೇ ಜಮೀನು. ಅವ್ರ ಹತ್ರ ಜಾಸ್ತಿ ಇದೆ ಆಕ್ಚುಲಿ ನನಗೆ.
ಆಯ್ತು, ನಿಮ್ PW2 ನೇ ಹೇಳ್ತಾನಲ್ಲ ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ, ನಂಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ, ಕಂಟೆಂಟ್ಸ್ ಗೊತ್ತಿಲ್ಲ, ಏನು ಗೊತ್ತಿಲ್ಲ, ನಾನು ಅಲ್ಲಿ ಹೋಗಿದ್ದೆ, ಅವ್ರು ಸೈನ್ ಹಾಕಿದ್ರು, ಸೈನ್ ಹಾಕ್ದೆ ಅಂತ.
ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ ಓನ್ಲಿ
ರಿಜಿಸ್ಟರ್ಡ್ ಅಗ್ರಿಮೆಂಟ್ ಇರ್ಬೋದ್ರಿ. What is the necessity of taking the signature of an agreement?
Page number 44, my lord, trial court give a finding.
ಏನು ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳ್ರಿ ಈಗ?
ಅವ್ರೊಂದು ಅದೇ ಒಂದ್ ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಕೊಟ್ರೆ ನಾನು.
ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಅಂದ್ರೆ ಎಷ್ಟು ನೀವು ಕೊಡ್ಬೇಕಾಗಿರೋದು, ಅವರಲ್ಲ.
ಅವತ್ತಿನ ಬೆಲೆಗೆ 20 ಲಕ್ಷ ಇತ್ತು, 4 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಒಂದು 5 ಲಕ್ಷ ಕೊಟ್ರೆ ನಾವು ಇದ್ ಮಾಡ್ತೀವಿ.
ನೀವಿನ್ನ ನಿಮ್ಗೆ ಮತ್ತೆ 5 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಅಂತನಾ ಕನ್ಫರ್ಮೇಶನ್ಗೆ?
ಅದನ್ನ ಹೇಳಿದೀನಿ, ಅವ್ರು ಮಾತಾಡಿದ್ದಾರೆ. ಈಗ ಈ ತರ
ನಾನು ಕೇಳಿದೆ, ಎಷ್ಟೇ ಕೊಟ್ರು ಅದು ಒಳ್ಳೆ ಉಪಯೋಗಕ್ಕೆ ಹೋಗಲ್ಲ. ತಮ್ಮ ಎಷ್ಟು ದಿವಸ ಸಹಾಯ ಮಾಡಿದೀವಿ,
ಬೇಡ ನನ್ ಮಕ್ಳಿಗೆ ಕೊಡ್ಲಿ, ನನಗ್ ಕೊಡೋದು.
You keep the amount in FD. ಆಯ್ತು, keep the amount in FD in the name of children, minor children.
ನಾನು ಒಂದ್ಸತಿ ನಮ್ಮ ಪಾರ್ಟಿ ಕೇಳಿ ನೋಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರೆ
ಇನ್ನೊಂದೇನು ಬರೀ ಎಲ್ಲಾನು ಬರೀ ಮಾರಾಟ ಮಾಡೋದ್ರಲ್ಲ ಇದಾನೆ ಎಲ್ಲಾನು ಅವನು. ಅದಕ್ಕೆ
ಎಲ್ಲ ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ ದುಶ್ಚಟಗಳಿಗೆ ಹೋಗ್ತಾ ಇದೆ ಅಂತ.
ಆಯ್ತು, whatever the amount you are going to give, let there be an order to keep the amount in FD in the name of minor children.
My party will ask.
ಆಯ್ತು, ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
Next week any date for that.
Totally. Both council submits that there is an element of settlement and hence list this matter. Next Wednesday kodi madam. 312 no sitting. 412
admission matter 15 Udita Ramesh SV Giridhar.
Should I need some more time?
Last time also you sought time 4 weeks, other side objected, 3 weeks time was granted. Kodi order sheet kodi. I remember I read the order sheet also.
Listed for the first time.
Matter may be passed
in view of the submission, learned counsel for the respondent is granted 3 weeks time to send on.
They sought for 4 weeks.
Respondent is a resident of Kerala. I am communicating through the council there in Kerala. I was not sleeping well.
Totally. Respondent counsel again seeks time.
Same submission was made on the last minutes. May be taken up on Friday minutes. We are ready for the admission. Or past our minutes. We are go ahead with the argument.
Admission ಏನ್ ಬರುತ್ತ್ರಿ? ಏನು ಕೇಳಿದಿರಿ ನೀವು? ಆಲ್ರೆಡಿ ಪ್ರೊಬೇಟ್ ಅಷ್ಟೇ, ಎವಿಡೆನ್ಸ್ ಹೋಗ್ಬೇಕು ಅಷ್ಟೇ. ನಾಟ್ ಫೈಲ್ಡ್ ಆಗುತ್ತೆ, ಎವಿಡೆನ್ಸ್ಗೆ ಹೋಗುತ್ತೆ.
Posted for evidence. Objection. Maybe take. My lords, last time also same submission was made, my lords.
Already 25 matter. First time ಅವರು ಅಪಿಯರ್ ಆಗಿರೋದು. ಯಾವಾಗ ಹಾಕಿದ್ ನೀವು ವಕಾಲತ್ತು?
I entered appearance on the 16th of October.
16/10.
Yes.
ಮತ್ತೆ respondent counsel seeks time. Finally 2 weeks time granted to file statement of objections. List this matter on. ಎರಡು ವಾರ ಬಿಟ್ಟು ಕೊಡಿ ಮೇಡಮ್. 12.
Any date before that, my lords? Any date before that, my lords?
Okay.
Some urgency, my lords.
What is the urgency, re? Petition was filed in 25. He appeared in October. Let him file statement of objections.
Yes,
last time also you made submission. That's why I considered 3 weeks.
Yes,
he sought 4 weeks.
Much obliged.
16 C.B. Shivkumar, M. Shiva Prakash.
I appeal to the petitioners, my lord. Seek for a week's accommodation, my lord.
Why you are again seeking time, madam?
Senior is not.
Is there Shiva Prakash ilva? Senior?
Senior is not.
Totally. Counsel for the appellant filed the cost. ಅಲ್ಲ ಏನು ಕಾಸ್ಟ್ ಹಾಕಿದೀವಿ ಮೇಡಮ್? ಅದು
ಅಲ್ಲೋ ಆಗುವಾಗ IML ಕಾಸ್ಟ್ ಹಾಕಿದ್ವಿ.
IML ಅದು ರೀಕಾಲಿಂಗ್ ಇರಬೇಕು. ಈಗೇನ್ ಮತ್ತೆ ಕಾಸ್ಟ್ ಹಾಕಬೇಕು. 24 RP. How long we have to keep the RP pending, madam? What is the ground for RP ಹೇಳಿ? Having taken note of the said submission and also not pursued the matter diligently in the interest of justice. ಇನ್ನೊಂದ್ಸರಿ ಡಿಸ್ಮಿಸ್ ಆಗಿರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ. ಅದೇ ರಿಕಾಲ RP ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು ಅನ್ಸುತ್ತೆ ಮೇಡಮ್. ಹೌದಾ? ತೊಗೊಳ್ಳಿ. In spite of.
2 days time is
No madam. On cost of rupees 5,000 ಮತ್ತೆ ಕೊಡ್ತೀನಿ ಡೇಟ್. Review petitioner counsel again seeks time and on perusal of the records it discloses that earlier also RP was dismissed and the same was recalled by imposing cost of rupees 2,000 and in spite of it counsel for the petitioner is not pursuing the matter, again seeks time and hence on dismissal illa cost ಏನು ಮಾಡಬೇಕು ಹೇಳಿ? And hence Urgent on cost of rupees 5,000 payable at the registry. List this matter on. Heli, madam.
2 weeks.
2 weeks. 12. Yes, sir. Court ಓದ್ಕೊ ಬರ್ಬೇಕ್ರಿ ನಿಮ್ಮ RP petition ನ second time dismissal.
70. Siddharth Suman.
Siddharth Suman.
In this case, we're informed there's some settlement. We're informed last night there's some settlement also.
Last time?
There was some settlement talks, I believe, Malaj. If that's not.
ಇಲ್ಲ ಇಲ್ಲ ಆ ತರ ಏನಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಡಿ ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time ಅಂತ ಇದೆ.
Malaj, in that case it may be passed over, Malaj.
Learned counsel for the appellant seeks time ಅಂತ ಇದೆ.
Please, Malaj, after that we are informed that there's certain settlement talk, Malaj.
Settlement ಏನ್ ಟ್ಯಾಕ್ಸ್ ಏನ ಮಾತಾಡಿದ್ರೇನ್ರಿ?
It may be passed over there.
ಮೊದಲು ಮಾತಾಡಿತ್ತು.
ಮೊದಲು
Yes.
Settlement not reported ಅಂತ ಇದೆ ರೀ.
Please, Malaj, after that.
26/9 ರಲ್ಲಿ.
Malaj, after that we are informed. In that case may be passed over.
Pass over ಅಷ್ಟೇ.
80. AV ಗಂಗಾಧರಪ್ಪ.
Dismissed. No partial partition confirmed. ಹೇಳಿ.
Kindly go to page 100A.
100?
A. That is the genealogical tree. From Natsegowda is the propositor. He had 3 sons by name Hanmaya, Tumkuraya and Ramaya. The other 2 daughters were married even much prior to 1950 and they have died. They do not have any right in the property. Now, suit for partition, Hanmaya died and this Kumbaya is plaintiff number 1.
The LRs of Hanmaya have filed the suit.
They have filed the suit for partition and separate position. Then Tumkuraya's first son Natsimurthy, he has filed the written statement admitting that there has been no partition in the family and properties are liable for partition. It's only dependent number 2, 3, 4. They are the contesting part. As far as Ramaya is concerned, his sons are also admitted.
Narasimha Murthy says that no partition.
No partition. Ramaya's.
But others, what is their defense?
They say that there has been partition long back about.
Already a partition.
Yes. Now the trial court held. May I draw the kind attention of this honorable court, the finding of the trial court. Please go to page 75.
75.
Among them, Hanmantaya, Hanmaya, Tumkura and Ramaya are the children and Lakshmama and Doddasarsama are the 2 daughters. It is also not in dispute that it can be gathered from the document produced by either side. The said family has ancestral and they were given the joint at Ragumba, Kota, during the lifetime of Natsegowda. Thereby the present plaintiffs were the sons of first son Hanmaya have approached this court seeking partition and separate position of their 1/3 share. In this aspect of the matter, the contesting defendants who have contended that there is already an oral partition about 50 to 60 years between their father and between father of plaintiff and Ramaya. But in this aspect of the matter, the brother of defendant 2 to 7, that is defendant number 1, though he was remained expert in the suit, he has appeared before the court and gave evidence on behalf of plaintiff as PW2, and the LRs of defendant number 8, one Krishnappa has also given evidence as PW2, and they have supported the case of the plaintiff and contended that there has been no partition in the family. But the contesting defendants number 2 to 7 who have contended that there is already a partition and the memorandum of oral partition prepared was lost. But in order to establish there is already a partition in the properties, parties are acted up, except producing number of documents to show the various transactions of purchase made by Tumkuraya and Ramaya and some mutations between the sons of Tumkuraya and between the sons of Ramaya. Nothing has been produced before the court to show that there was a partition between the sons of Natsegowda. Thereby, in order to ascertain there is a partition between the members of the joint family, there should be clear evidence before the court. The documents produced by either parties will show that Tumkuraya has acquired lot of property during his lifetime by the purchase and also by grant. Even defendant number 8, Ramaya, has also purchased some property during his lifetime, and all the documents by those produced either it is standing in the name of Tumkuraya and his son and Ramaya and his son. Nowhere the names of either father of the plaintiff or the plaintiff has been mentioned. But taking defense that there is already a partition between them about 50 to 60 years back, and thereby the question of existence of land.
Idaಯ್ತು, no partition ಆಯ್ತು,
No
but
partition.
reason was
No,
given.
the reason for dismissal is that some of the properties which are situated in Brahmasandra, which are the properties of Hanmaya's wife and Hanmaya's mother-in-law, they have not been included in the suit for partition. Therefore, the suit for partial partition is not maintainable.
Hanumaya's wife
and her mother.
Her mother. ಎಲ್ಲಿದೆ ಅದು? ಆ ರೀಸನ್ ಎಲ್ಲಿದೆ? ಆ ರೀಸನ್ಸ್ ಎಲ್ಲಿದೆ ಅಂದೆ?
The reasons are when we go to page 80.
Page
80.
80.
Yes.
Third
line. However, the contesting defendants have also contended suit has been filed in collision with defendant number 1 and defendant number 8, thereby suit by the plaintiff is not maintainable. In this aspect of the matter, the plaintiffs have replied filing rejoinder to the defense statement filed by defendant 2 to 7 and 8, and he has disclosed that the property acquired by Tumkure during the business, apart from suit properties and the properties acquired by defendant number 1, who is the son of Tumkure, and the properties acquired by Ramaya, that is defendant number 8, and those properties have not been included in the suit, which is also admitted by PW1 during the course of cross-examination. And also in the rejoinder that Tumkure and Ramaya and also the father of plaintiff has independently acquired some property, and those properties have not been included in the suit, and even all the properties which have been acquired are sites properties from Tumkur City Municipal Corporation, and they have sold their property independently. Therefore, as rightly argued by the counsel for the contesting defendant, that the suit for partial partition is not maintainable, though the plaintiff has proved before the court that there is no partition in the family and the joint family is in existence, have utterly failed to show to the court that he has included all the properties of the members of the joint family, that is the property acquired by Amaya, Tumkuraya and Ramaya thereby. I am of the considered opinion that the plaintiffs have failed in their attempt to show to the court that they have included all the properties of the family in collision with defendant number 1, though he has acquired so many properties from Tumkuraya, has kept silent and supported the plaintiff and Ramaya, defendant number 8, though he has acquired some property which is not included in the claim, and he has also claimed share in the suit property, will make it clear that there is a clear collusion of plaintiff, defendant number 1 and defendant number 8. Under these circumstances, plaintiffs are not entitled for the claim in the case. With these observations, I proceed to hold issue number 2 in the affirmative and proceed to pass the following order. Suit of the plaintiff is hereby dismissed. Now, the appellate court, in its judgment, starting from the discussion of the evidence, went on finding fault with the plaintiff and ultimately confirmed the judgment and decree passed by the trial court without going into the question whether there has been partition or no partition. And this is how the learned judge proceeds. Can we go to page 34? Page 34.
So, heard the appellant counsel and counsel for the respondent is absent. Having perused the material on record, the trial court dismissed the suit on the ground that suit for partial partition is not maintainable. In coming to the conclusion that properties which have been acquired in the name of 3 sons of what is the propositor's ಹೆಸರೇನು? Narasegowda were not made as parties, but it is emerged that sons Hanumaya, Tumkuraya and Ramaya, all of them have purchased the property independently
and have sold the property.
And ಎಲ್ಲರೂ ಸೇಲ್ ಮಾಡವರ?
ಎಲ್ಲರೂ ಸೇಲ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನು ಕೊಂಡ್ಕೊಂಡಿದ್ರು ಎಲ್ಲಾನು ಸೇಲ್
ಮಾಡಿದ್ರು. City Municipal Corporation allotted some sites, and those properties have been sold by all the 3.
All the 3.
Yes, all the 3.
And also they have sold the respective properties. And when such being the case, when the property is not available for partition, question of coming to the conclusion that partial partition is not maintainable appears to be erroneous, and first appellate court also reiterated the same in the appeal, and when such being the case, matter requires reconsideration. Admit the following substantive question of law arises for the consideration of this second appeal, whether both the courts below have committed an error in dismissing the suit only on the ground that the suit is not maintainable for partial partition, in spite of there is a evidence that the properties which have been acquired by the sons of Narsegoda were already sold, and in spite of it, such conclusion is erroneous. Whether both the courts have committed an error in dismissing the suit, even though comes to the conclusion that there was no any material to show that there was a partition among the sons of Narsegoda, and in spite of the said finding, committed an error in not granting the relief of partition as claimed, and such finding is erroneous as against the material available on record, and the same amounts to perversity. Records are already received and no need of filing of any paper book.
Not to alienate the properties or create third party interest.
Earlier anaritta
Earlier only ಏನು ಇದ್ದಿಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಬರ್ಲಿ ಎಲ್ಲ ಇದಾರಲ್ಲ ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ. ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್ 12/12.
19 Kumar Kher, Sunil Kumar Patel.
My lord, respondent, my lord. Last date of hearing, I was instructed that there would be respondent number 3 to 6 would give wakalat to me. But now they don't want to contest because, and they were also remained absent before the first appellate court. In fact, this matter is the first appellate court has passed a 10-line order confirming the dismissal of the suit. The lordship expressed that it would be a matter for remand. I took time to file wakalat on behalf of R3 to R6.
The counsel appearing for the R1 to ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗಿದ್ದು ಫಸ್ಟ್
R1 and 2 they are the contesting
1 and 2.
Yes sir.
Submits that respondent number 3 to 6 are not interested to prosecute the matter since they were also not represented in the first appellate court.
They remained absent,
and hence the said submission is taken note of. ಹೇಳ್ರಿ.
In this matter, Lordship kindly consider some dates and events.
Dates and
events.
ಅದು ಆಮೇಲೆ ನೋಡೋಣ. ಡೇಟ್ಸ್ ಅಂಡ್ ಈವೆಂಟ್ಸ್ ರೀಸನ್ಸ್ ಹೇಳಿ ಫಸ್ಟ್.
The reason, my lord.
The case of the parties is stated in the above para, no need to repeat. Most of the facts are not disputed. The trial court has properly appreciated the materials on record and rightly come to the conclusion that plaintiff has got half share in the suit item number so and so properties. Discussion badvenri ಒಂದು appeal ಅಲ್ಲಿ. This is like an original suit also. RA is nothing but a original suit. That is settled law also.
Order 41 rule 33 please.
31 33 in extraordinary circumstances.
Here my lord.
But early at least ಏನ್ ಎವಿಡೆನ್ಸ್ ಇದೆ ಏನು ಅಂತ ಡಿಸ್ಕಸ್ ಮಾಡ್ಬಿಡುವ. one page order ರಿಮೈಂಡ್ ಮಾಡೋಣ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್.
Remand in the trial court. May I request to matter may be remand for the trial court for this reason.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಗೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಅದನ್ನ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಇಫ್ ನೀಡ್ಸ್ ಟು ರಿಮ್ಯಾಂಡ್ ದಿ ಮ್ಯಾಟರ್ ಟು ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವ್ರು ಮಾಡಬೇಕು, ನಾನ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಅದನ್ನ ನೀವು ಅಲ್ಲಿ ಕೇಳ್ಕೋಬೇಕು, ಮ್ಯಾಟರ್ ರಿಕ್ವೈರ್ಸ್ ರಿಮ್ಯಾಂಡ್ ಅಂತ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನಾನ್ ಸಿಟಿಂಗ್ ಇನ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಐ ಕೆನಾಟ್ ಡೈರೆಕ್ಟ್. ಏನಾಗಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡವ್ರೆ?
ಫಾದರ್ ಡಾಟರ್ ಅಂಡ್ ಸನ್ ಇಸ್ ದ ಪಾರ್ಟಿ.
ಆಯ್ತು.
ದಿ ಫಾದರ್ died on 7/12/2012. Return statement 5 2018
ಆಯ್ತು.
After 7 years 5 months
ಆಯ್ತು.
saying that certain properties are the self-purpose property.
ಆಯ್ತು.
So who has to say these are the properties are self-purpose property?
ಯಾರ್ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿರ್ತಾರ ಅವ್ರು ಹೇಳ್ಬೇಕು.
ಈ son has filed a return statement.
ಏನಂತ?
Certain properties which are acquired by the father is the self-purpose property. Taking into consideration of that return statement, the trial court has come to a conclusion some properties are self-purpose property. Therefore, the plaintiff is
ಅದನ್ನ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ನವರು ಈಗ ರೀಸನ್ಸ್ ಕೊಟ್ಟು ಮಾಡಬೇಕು. ನಾನ್ ಮಾಡಕ್ಕಲ್ಲ. ನಾನ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಕುತ್ಕೊಂಡು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Keep it open all the contention ಅಂತ ಹೇಳಿ ತಾವು ಮಾಡಿ.
Time bound.
ಆ ಟೈಮ್ ಕೊಡೋಣ, ಟೈಮ್ ಬೌಂಡ್ ಮಾಡೋಣ.
Yes, yes.
ಅಪೀಲ್ ಯಾವ ವರ್ಷದ್ದು?
Where there is an interim order was in operation.
ಏನ್ ಮಾಡೋಣ, ನಾವು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ಗಳು 1 page ಆರ್ಡರ್ ಬರೀತಾರೆ ಅಂದ್ರೆ ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ, ಅದು ಈಸ್ ಎ ಡೈರೆಕ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್, ಒಂದೇ ಪೇಜ್.
ಅದೇ ಪೇಜ್ ಇಲ್ಲ, ಅದು 10 lines.
10 lines.
The trial court has properly appreciated the materials on record and rightly comes to the conclusion that plaintiff has got half share in suit item number so and so by meets and bounds in the ancestral properties of herself and defendant number 3. The self-acquired properties of the father of the plaintiff was disposed of by way of gift deed during his lifetime. I do not find any reason. Is a reason?
Gift deed, where there was a prohibitory order was in effect.
Heard the appellant counsel and also the counsel appearing for the respondent. Having heard both the counsel, the reasoning given by the first appellate court appears even not looked into the material on record. The first appellate court is a statutory appellate court to consider both pleadings and also the evidence and appreciate the evidence available on record, and the same is not done. This court would like to extract the paragraph number 14 in confirming the judgment of the trial court by the first appellate court, which reads as follows. Having read this order, the first appellate court committed an error in simply confirming the order without any consideration of pleadings, evidence available on record, and not exercise the scope as provided under Order 41 Rule 31, and hence matter requires reconsideration by the first appellate court, and it is nothing but in a casual manner disposed of the first appeal, and hence matter requires to be remitted back to the first appellate court to consider the same in accordance with law. In view of the discussions made above, I pass the following order. The impugned order passed in RA number 125 of 2019 is set aside and matter is remitted back to the first appellate court to consider and dispose of the same in a time bound period. The parties are directed to appear before the first appellate court on 19/12/2025 without expecting any notice from the first appellate court. The first appellate court is directed to dispose of the same within a period of 4 months from 19/12/2025. The records are ಬಂದಿದೆಯಾ? The registry is directed to ಬಂದಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಮೋಸ್ಟ್ಲಿ. ಬಂದಿಲ್ಲ ಅಲ್ಲ?
ಬಂದಿಲ್ಲ.
Keep open all the contention. Keep open all the contention.
ಅದು ಇದ್ದೇ ಇರ್ತದ್ರಿ.
Continuation of suit.
ಅಪೀಲ್ ಮಾಡೇ ಇಲ್ಲವಲ್ಲ? ಆಯ್ತು.
Continuation of suit, my lord.
ಅಷ್ಟೇ. Original.
They have law provides for all the
ಫಸ್ಟ್ ಅಪೀಲ್ ಈಸ್ ಲೈಕ್ ಎ ಒರಿಜಿನಲ್ ಸೂಟ್ ಇದ್ದಂಗೆನೆ, ಎಲ್ಲಾನು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು, ಮಾಡೋದೇ ಇಲ್ಲ. ಆಯ್ತು. ದಿ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಈಸ್ ಡೈರೆಕ್ಟ್, ಅದನ್ನ ಹೇಳಿದ್ನಲ್ಲ ಆರ್ಡರ್ 41 ರೂಲ್ 31 ಅಂತ, ಮತ್ತೇನ್ ಹೇಳ್ಬೇಕು ಅದನ್ನ? ದಿ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಟ್ರೀಟ್ ದಿ ಅಪೀಲ್ ಆಸ್ ಒರಿಜಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ and decide the issue involved between the parties, and contentions of the respective parties are kept open. Aita?
Anil Reddy S. Jeevan Kumar BS.
Appearing for respondent number 1 and 9 to 11.
A suit for partition, my lordship. In the trial court, in the OS, I have not received any summons, my lordship. In the RA, I have received summons and appeared myself and filed our objections, my lordship. After which I brought to the notice of this court, saying that there is a 2 items. I had claim of 2, totally 4 items, my lordship. In that, my claim was put forth for item 2 items, saying that one is bought by my father.
Original suit ಅಲ್ಲಿ?
Original suit is decreed, my lordship.
ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿಲ್ವಾ?
No, my lordship. My presence was not there in the original.
Not there ಅಂತಂದ್ರೆ ಏನಾಯ್ತು, ಸರ್ವಿಸ್ ಆಯ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ ಫಸ್ಟ್.
No, it's not served for me, my lordship. I explained ex parte, my lordship.
In spite of service of summons, they are not appeared.
ಹೌದಾ?
ಹೌದು ಸರ್.
ಏನಾದ್ರು ಇದೆಯಾ ಆ ತರ ಏನಾದ್ರು?
ಬಂದಿಲ್ಲ.
ಅಬ್ಸರ್ವೇಷನ್ ಏನಾದ್ರು ಇದೆಯಾ ಅದರಲ್ಲಿ?
Observation it is there.
ನೀವು ಎಷ್ಟನೇವರು ಅಪೀಲ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ನಾ?
I am appearing for
ನೀವು ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ನಾ?
No, yeah. And the trial court, I am the defendant number 2, my lordship.
ಅದೇ ಹೇಳ್ತಾ ಇರೋದು ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಹೌದಲ್ಲ?
Yes, my lordship.
notice go after service of summons defendant number 1 has appeared, but the defendant number 2 to 7 were not appeared and they placed ex parte antidiyala.
But my clients are informed that they have not received my lordship.
Hmm.
Now I brought to the notice.
ಆಯ್ತು ನೀವು ಕೊಡಿ ಏನಾದ್ರು ಇದ್ರೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ.
ಅಲ್ಲ, first appellate court in the first appellate court we appeared, we brought to the knowledge of the court and we filed an objections and we have also produced certain documents, my lordship.
ಏನಾಯ್ತು ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನ್ ಮಾಡಿದ್ರು?
I would like to take you.
ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ನಿಮ್ ಕಂಟೆನ್ಷನ್?
Yeah, kindly go to the page number 38.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಾ?
Page number 38, my lordship.
ನಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೇನ್ರಿ ನೀವು ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗ್ಲಿ?
Yes, my lordship.
ಏನಂತ?
I filed my objections and also brought certain documents to the knowledge of.
ಅದೇ ಆಯ್ತು, ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ಡರ್ 41 ರೂಲ್ 27 ಹಾಕಿದೀರಾ?
ಹೌದು my lordship.
ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸಿ.
Here page number 38, my lordship.
Whether the defendant number 1 made out grounds ನಿಮ್ದು ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಅಪ್ಲಿಕೇಶನ್? Article 6 rule 17 of CPC for amendment and application under 41 rule 27 of CPC for additional evidence. ಹಾ, ನೀವ್ ಹಾಕಿಲ್ವಲ್ರಿ? ಎಲ್ಲೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ?
Yeah, my lordship. Kindly page number 36, my lordship. The application under
36.
Yeah, page number trial court.
ಎಲ್ಲ ಬಿಡ್ರಿ, ನೀವು ನಾಟ್ ಇನ್ ಮಾರ್ಕೆಟ್. ಎಲ್ಲಿದೆ ಹೇಳಿ? 36 ಅಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 3
under 6 rule 17.
ಅದೆಲ್ಲ ಡಿಫೆಂಡ್ ನಂಬರ್ 1 ಫೈಲ್ ಮಾಡಿರೋದ್ರಿ. ಯು ಆರ್ ಡಿಫೆಂಡ್ ನಂಬರ್ 2.
No, my lordship.
ಹೆಂಗಾಗ್ಬಿಟ್ಟೆ ನಾವು ಓದ್ಕೊಬಂದು ನಿಮಗೆ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬೇಕು.
In between,
ಏನ್ ದುರಂತ.
my lordship, in between defendant number has died, my lordship, then I become the respondent number 1 in the
point
appeal,
number
my
3 ನಲ್ಲಿ application filed
And
under order 6 rule 17 filed by defendant number 1 who was defendant number 2 ಅಂತ ಇದೆ.
ಅಲ್ಲ, respondent number is respondent number 1 before first.
my lordship, then I'll become the respondent number 1 in the appeal. I'll become the respondent number 1 in the appeal, my lordship.
ಅಪೀಲ್ ಅಲ್ಲಿ ಆಯ್ತು.
Appeal respondent number 1, my
ಆಯ್ತು.
lordship.
2
In
to
the
6
trial I am the respondent number 2.
ಕ್ಲೈಮಿಂಗ್ ಶೇರ್ ಅಂಡರ್ ವೆಂಕಟರಮಣಪ್ಪ.
Yes, my lordship.
ಹೌದಾ?
ಹೌದು, my lordship.
ವೆಂಕಟರಮಣಪ್ಪ ಯಾರು?
My father, my lordship.
ಅವ್ರಿಗೂ ಅವರು ಅದೇ ತಾನೆ?
No, no, my lordship.
ಮತ್ತೆ
this suit is filed by my aunties, my lordship.
No, my lord. The children of one
I
of
am the grandfather of Kuttappa, my lordship. He is the original proprietor of the land, my lordship. My aunties has been filed a suit. So he has got 5 children, my lordship.
My lord,
And one
76 they have produced family tree.
76
my lord.
page 76 ಅಲ್ಲಿ.
Page 76.
ಆಯ್ತು. 74 ಹೇಳಿ.
ಕುಟ್ಟಪ್ಪ is the ancestor.
Yes, my lordship.
ಅವ್ರಿಗೆ ಮುನಿತಾಯಮ್ಮ, ವೆಂಕಟಮ್ಮ, plaintiff number 1 and 2, ವೆಂಕಟರಮಣಪ್ಪ.
ಈ plaintiff number 1 and 2 ಇರ್ ಮುನಿತಾಯಮ್ಮ and ವೆಂಕಟಮ್ಮ
and children of ಮುನ್ಷಾಮಪ್ಪ. This is son of ಮುನ್ಷಾಮಪ್ಪ. ಮುನ್ಷಾಮಪ್ಪ ತೀರೋಗ್ತಾರೆ. ಮುನ್ಷಾಮಪ್ಪ ತೀರೋಗ್ತಾರೆ ಮೇಲ್ ಮೆಂಬರ್. ಅವರ ಹೆಂಡತಿ ಮತ್ತೆ ಮಕ್ಕಳು ಕೂಡ plaintiffs.
ಅವರು plaintiffs.
ಆಯ್ತು. So he is claiming that under oral partition in the year 1993 there was oral partition. ಇವರು ಪಾಪಣ್ಣ ಬಂದು ವೆಂಕಟರಮಣಪ್ಪನ ಮೊದಲನೇ ಮಗ. ಪಾಪಣ್ಣ ವೆಂಕಟರಮಣಪ್ಪ ತೀರೋಗ್ತಾರೆ. ಪುಟ್ಟಪ್ಪನ ಮೇಲ್ ಮೆಂಬರ್ ಮೊದಲನೇ ಮಗ.
ಆಯ್ತು.
ಪಾಪಣ್ಣ. His claim is that in respect of item number.
ಈಗ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 ಯಾರು ಇರಲ್ಲ, ಅವನ ಹೆಸರೇನು?
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 2 is the ಪಾಪಣ್ಣ.
ಅವನೇ ಪಾಪಣ್ಣ. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಯಾರು?
ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ವೆಂಕಟಮ್ಮ ತೀರೋಗ್ತಾರೆ.
ವೆಂಕಟಮ್ಮ ಅಂದ್ರೆ ಅವ್ರ ತಾಯಿ. ಇವನ್ D2 ಆಯ್ತಾ?
ಈಗ ಏನಾಗಿದೆ, ಐಟಮ್ ನಂಬರ್ 2 ಬಗ್ಗೆ, ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ನಂಬರ್ 2 ಬಗ್ಗೆ
ಕೊಟ್ಟಿರಲಿಲ್ಲ. ಟ್ರಯಲ್ ಕೊಟ್ಟರು, ಅಪಲೇಟ್ ಕೋರ್ಟಲ್ ಮತ್ತೆ
ಅಪಲೇಟ್ ಕೋರ್ಟಲ್ ಕೊಟ್ಟರು. ಈಸ್ ಕ್ಲೈಮ್ ಇಸ್ ದಟ್ ಈ ಎಲ್ಲಮ್ಮ ಇದಾರಲ್ಲ ಮುನ್ಷಾಮಪ್ಪನ ಹೆಂಡತಿ, ಅವ್ರು 94 ಅಲ್ಲಿ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು. ಸೊ ಆ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಆಗಿತ್ತು, ಓರಲ್ ಪಾರ್ಟಿಷನ್. 18.25 ಗುಂಟೆ ಈ ಎಲ್ಲಮ್ಮನಿಗೆ ಬಂದಿತ್ತು. ಆ ಎಲ್ಲಮ್ಮನ್ ನನಗ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಇವರು ಕೇಸು. ಈಗ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ. ಈ 94 ಅಲ್ಲಿ ಒಂದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ನ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಒಂದು ಸೂಟ್ ಹಾಕೋತಾರೆ, ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಸೂಟ್. ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಸರ್ವಾಗಲ್ಲ, ಎಲ್ಲಮ್ಮನ್ ಹೋಗಲ್ಲ, ಪಾರ್ಟಿ ಇದು ಡಿಕ್ರಿ ಆಗುತ್ತೆ. ಡಿಕ್ರಿ ಆಗ್ಬೇಕಾದ್ರೂ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ ಏನಂತಂದ್ರೆ they have not produced any document in the name of Ellamma anta first instance alli the court made observation before passing judgment. ನೀವು ಎಲ್ಲಮ್ಮನ ಹೆಸರಲ್ಲಿ ಇರೋಂಥದ್ದು ಪಾರ್ಟಿಷನ್ ಆಗ್ಲಿ ಅಥವಾ ಎಲ್ಲಮ್ಮನ ಹೆಸರಲ್ಲಿ ಇರೋಂಥದ್ದು ಯಾವುದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಬೈ ದಟ್ ಟೈಮ್ ದಿ RTC ಸ್ಟ್ಯಾಂಡ್ಸ್ ಇನ್ ದಿ ನೇಮ್ ಆಫ್ ಕುಟ್ಟಪ್ಪ. ಸೊ 1,05,000 ರೂಪಾಯಿ ನಾನು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರ ಶೇರ್ನ ಅಂತೇಳಿ ಎಲ್ಲಮ್ಮನ್ನು ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾಳೆ ಅಂತೇಳಿ ದೇ ಫೈಲ್ಡ್ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್. ಅದು ಡಿಕ್ರಿ ಆಗುತ್ತೆ. ಡಿಕ್ರಿ ಆದ್ಮೇಲೆ ಕೋರ್ಟ್ ಸೇಲ್ ಮಾಡ್ಕೋತಾರೆ. ಅದನ್ನ ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ತಗೊಂಬಂದು ಹಾಕಿದ್ದಾರೆ, ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿಲ್ಲ ಅನ್ನೋದು ಅವ್ರ ಕೇಸ್. That is their case. I am disputing that I have disputed in the meantime, my lord, 711 YSL ಏನು ಆರ್ಡರ್ ಆಯ್ತು, they have not challenged it. Till date they have not challenged that decree. Appeal ಅಲ್ಲಿ ಬಂದು they have filed application for ಅದು ಏನು ಫಸ್ಟ್ ಇದಾಗ್ತಾರೆ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತಾರೆ.
They have not filed any appeal.
ಅಪೀಲ್ ಕ್ರಾಸ್ ಸಬ್ಜೆಕ್ಷನ್ಸ್ ಗೆ ಮತ್ತೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಕೇಳ್ತಾರೆ. ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದನ್ನ ಹೇಳಲ್ಲ. By that time when the matter was posted for arguments, appeal, ಆ ಟೈಮ್ ಅಲ್ಲಿ ಬಂದು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊನೆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಡ್ರ್ಯಾಗ್ ಮಾಡ್ತಾರೆ, ಕೊನೆ ತನಕ ಡ್ರ್ಯಾಗ್ ಮಾಡ್ತಾರೆ. ಕೊನೆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಬಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು, ನಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ, ಮತ್ತೆ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಬೇಕು, ನನಗೆ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗೋದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಬೇಕು ಅಂತ ಹೇಳಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕ್ತಾರೆ. The honorable court observed that already partition suit has been decreed, you are not challenged that decree. Until suit has been decreed. Concurrent findings. Earlier ಏನು ಒಂದು ಸೂಟ್ ಬಗ್ಗೆ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು, ಅದನ್ನ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ ಒನ್ ಆಫ್ ದಿ ಪ್ಲೈಂಟಿಫ್ಸ್. ಆಮೇಲೆ ಅರ್ಲಿಯರ್ ಏನು ಹೆಣ್ಮಕ್ಳಿಗೆ ಆ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಏನಿತ್ತು, ಈಕ್ವಲ್ ಶೇರ್ ಇಲ್ಲ ಅನ್ನೋದು ಅವ್ರ ಮುಂಚೆನೆ ತಂದೆ ತೀರೋಗಿದ್ರು ಅಂತ ಹೇಳಿ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ. ಬಟ್ ಅಪೆಲೇಟ್ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅದು ಆಗೋಷ್ಟೊತ್ತಿಗೆ ಜಜ್ಮೆಂಟ್ ಬಂದಿರುತ್ತೆ ಆನರಬಲ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್, ದೇ ಆರ್ ಆಲ್ಸೋ ಹ್ಯಾವಿಂಗ್ ಈಕ್ವಲ್ ರೈಟ್ಸ್ ಅಂತ ಹೇಳಿ. ಸೊ ದಿ ಆನರಬಲ್ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಪಾಸ್ಡ್ ದಿ ಜಜ್ಮೆಂಟ್ ಬೈ ಡಿಕ್ರೇಯಿಂಗ್ ದಿ ಸೂಟ್ ಫಾರ್ ಆಲ್ ದಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟೀಸ್. This is the case.
ಇದು ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್? ಇಲ್ಲಲ್ಲ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಅಲ್ರಿ, ಫಸ್ಟ್ ವಿ ಶುಡ್ ನೋ ವೆದರ್ ದೇರ್ ವಾಸ್ ಎ ಸರ್ವಿಸ್ ಎಗೇನೆಸ್ಟ್ ಯು ಆರ್ ನಾಟ್. ಫಸ್ಟ್ ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸೋಣ, ಟ್ರಯಲ್ ಕೊಟ್ಟು ಎಲ್ಲ ಬರ್ಲಿ, ಆಮೇಲೆ ನೋಡೋಣ ನಿಮ್ ಕಂಟೆನ್ಷನ್ ಏನಿದೆ, ಆಮೇಲೆ ನೋಡೋಣ. ಬರ್ಲಿ, records ಬರ್ಲಿ. First of all, you did not appear before the trial court and contest the matter. One thing, in first appellate court also you have not challenged the judgment and decree passed by the trial court. Hodala?
I'll take
in the meantime
one judgment.
Judgment alla amel nodana, records ಬರ್ಲಿ ಅಂದ್ರೆ.
In the meantime I have challenged that expert judgment which they have obtained specific relief. ಅದು miscellaneous pending ಇದೆ.
Miss ಅಲ್ಲಿ ಇದೆ.
First appellate court has rejected my contention, saying that
call for records,
not filed a cross objection.
Call for records of both the courts. List this matter on date code, madam. 5/6 5/1
published
26
21 G Narayan Rao.
Ilva told this appeal was listed before this court on ಕೆಲಸ ಕೊಡ್ರಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಅಷ್ಟೇ, ಸ್ಟೇಟ್ ಕಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀವಿ. This matter was listed on 11/11/25 and in spite of matter was called twice, none appears on behalf of the appellant. However, this court in the ends of justice one more opportunity is given to the counsel for the appellant and also made it clear that if the learned counsel for the appellant doesn't appear on the next date of hearing, the appeal will be dismissed for non-prosecution. And in spite of the same, the counsel appearing for the appellant is not present before the court and hence appeal is dismissed in view of the order dated 11/11/25 for non-prosecution. 22.
This case appeal for defendant's appeal business. The trial court
dismissed, will cancelled, sale deed executed, reversed. Call for records. ಮತ್ತೆ ಯಾರು ನೋಟಿಸ್ ಒಳಗೋರು ಇದಾರಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ನೀವು ಅಲ್ದಲ್ಲೇ ಬೇರೆಯವ್ರು ಯಾರು ಇದಾರಾ?
ಯಾರಿಲ್ಲ ಸರ್.
ಅಪೀಲ್ ಅಲ್ಲಿ ಯಾರಿಲ್ಲ, ನೀವು ಒಬ್ರೇನಾ? ಒಬ್ರೇನೆ. ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ call for records and list the matter on 6/1/26. Divergent pending ಇದೆ.
We are in possession of the property. Suit for possession ಕೇಳಿರೋದು.
Possession ಕೇಳಿದ್ರೆ ಹೌದ್ರಿ, ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು.
ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು.
ಒಂದು ನಿಮಿಷ. Let's kindly fix it. 70 admit ಆದ್ರೆ ಮಾಡ್ಬಿಡಿ ಸರ್. para 17 of the trial court order, Lordship, ಏನಿದೆ?
ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬರಲಿ ನೋಡ್ಕೊಂಡು ಮಾಡೋಣ ಅಷ್ಟೇ.
ಅದು ಏನ್ ಮಲಡ್ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಈಸ್ proof of execution of the will
ಹೌದು
is also applicable to revocation of the will. That is the question. ಅಷ್ಟೇ
ವಿಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದೀವಿ ಅಂತ ಮಾಡಿ ಆಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿ ಏನೋ ಮಾಡಿದ್ದಾರೆ
ಅಷ್ಟೇ.
ಸೇಲ್ ಡೀಡ್ ಇಸ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್, ವಿಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ, ಹೌದಲ್ಲ?
Proof of will is admitted, then revocation has to be proved like that of proof of will. ಅದೇ same principle.
Cancellation of will and also execution of the sale deed. If cancellation is not in accordance with law, then sale deed will not.
Will execute ಮಾಡಿ.
ಆಯ್ತು, ರೆಕಾರ್ಡ್ಸ್ 61.
Appear for appear.
ಮರಿಯಪ್ಪ.
Appear for appearance.
ಇದು ಅಷ್ಟೇ. Call for records. Notice ಯಾರು respondents ಇದಾರ ನೋಡಿ ಮೇಡಮ್.
ಇದಾರೆ ಸರ್.
ಒಬ್ರೇನಾ? ಒಬ್ರೇ respondent. Call for records. List this matter for admission on along with records on 26 6/1/26. 24 ವಕಾಲತ್ ಹಾಕ್ಬೇಕು ನೋಡಿ. ಲೋಡ್ ಮರಿಯಪ್ಪ, ನಿಮ್ದು ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆ, 90 days ಆಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, for applies ಮಾಡಿ. Applies ಮಾಡಿ.
ವೀರಯ್ಯ ಹಿರೇಮಠ, counsel ವೀರಯ್ಯ ಹಿರೇಮಠ is directed to file ವಕಾಲತ್ since caveat is lapsed.
24
ಬಟ್ ಅವ್ರೇನ್ ಬರ್ತಾರ ಇಲ್ಲ, ನೋಟಿಸ್ ಮಾಡೋದು ಬೆಟರ್ನಾ?
ಕಂಡೀಷನ್ ನೋಟಿಸ್ ಮಾಡಿ.
ದಟ್ ಈಸ್ ಬೆಟರ್. ಮತ್ತೆ ಅವತ್ತಿನ ದಿವಸನೂ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ ಅಲ್ಲ, ತಗೊಳ್ಳಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಿನ್ಸ್ caveat is lapsed ಅಂತ ಹಾಕ್ಬಿಡಿ. And in the meanwhile, registry is directed to get the records and list this matter for admission on 6/1/26 along with records. 24 SS Parikshit. ಇದು ಸೇಮ್ ಕೊಡಿ. This matter was listed on 11/11/25. ಸೇಮ್ ಮಾಡ್ರಿ ಮೇಡಮ್. ಈಗ ಹಿಂದಿಂದ ಹೇಳಿದ್ನಲ್ಲ ಡಿಸ್ಮಿಸಲ್, ಅದೇ ರೀತಿ ಡಿಸ್ಮಿಸಲ್.
25 here Balraj.
Non filing of receipt for having paid the cost.
Respondent. Caveat.
Junior counsel sought time twice in the morning session, that is when the matter was called page wise, and also when the matter was reached for admission and this court declined to the time and directed to assist the court. In the afternoon session there is no representation on behalf of the appellants, hence given to the counsel for the appellants. Pass over madiri, barlilla andre pass over, dismiss ಮಾಡೋಣ.
26 Syed Pir Ullah Shah Qadir.
Syed Pir Ullah Shah Qadri.
Your Lordship, suit for specific performance. Respondents.
Divergent finding. Call for records.
Your Lordship, there is execution petition filed. It is posted on 4th of December. IA number 1 state. The disputed.
Heard the appellant counsel and last time why you are absent? Why you are absent?
I was admitted.
Appellant counsel absent, urgent, huh?
Health reasons I was admitted.
Now you are seeking for an interim order.
Due to my health reasons I could not appear.
Good. Enayt madam? Heard on IA number 2 of 23 and on perusal of the records when the suit is filed for the relief of specific performance, the trial court directed to refund the amount of rupees 80,000 with 9% interest. And the same is challenged before the appellate court, and appellate court granted the relief of specific performance with a direction to execute a sale deed by receiving an amount of rupees 1,20,000. And now counsel would immediately contend that already execution petition is filed to obtain the sale deed and the same is pending and date is given on 4/12/2025. And in view of the said submission, the execution petition is stayed till next date of hearing. Issue notice against the respondent and call for records. List the matter on 6/1/25. 26.
27 Vikasyam.
ಇಲ್ಲ pass over.
28 SV Prakash. Vasant Kumar came.
This honorable court is
ಕಾಸು ಕಟ್ಟಿದ್ದೀರಾ? ಕಟ್ಟಿದಿರಿ, ಹೇಳಿ. What is the error in directing you to execute the sale deed?
Two aspects. One is that there was an understanding and intended to sell the survey number 50 property bearing survey number 15. But in the alleged agreement mentioned as survey number 13.
13.
ಅದು rain fed land.
Rain fed land.
13 is the wetland.
ಬಟ್ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರಕಾರ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಯಾವ್ದು ಮೆನ್ಷನ್ ಮಾಡಿರೋದು?
13. 13.
ಯಾವ್ದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿರೋದು? 13.
13.
ಮತ್ತೆ ನಿಮ್ ಪ್ರಕಾರ 50 ಹೆಂಗ್ ಬರುತ್ತೆ?
50 ಅಲ್ಲ 15.
15. 15 ಹೇಗ್ ಬರುತ್ತೆ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಜರ್ ಮಾಡಿದ್ದೇನೆ ಅಂತ ಹೇಳಿ.
ಈಗ ಸರ್ವೆ ನಂಬರ್ 13 ಇದೆಯಾ ಹೋಗ್ಲಿ?
13 ಇದೆ.
ಮತ್ತೆ
15 ಇದೆ. ಬಟ್ ಥಿಂಗ್ ಇಸ್ ದಟ್ ಮೇಲೆ that is a rain fed land.
ಆಯ್ತು.
And this one is the wetland.
ಯಾವುದು?
30.
ಸರ್ವೆ ನಂಬರ್ 13.
30.
ನಿಮ್ಮ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಏನಂತ ತೋರಿಸಿದಿರಿ? ಕುಷ್ಕಿ ಅಂತ ತೋರಿಸಿದಿರಾ ಅಥವಾ ತರಿ ಅಂತ ತೋರಿಸಿದಿರಾ?
ನನ್ನ ಹಸ್ಬೆಂಡ್ ಏನು ಮಾಡ್ಕೊಂಡ್ರು
ಅದಂಗ ಆಗ್ತದೆ. ಈಗ ವೈಫ್ ಡಿಫೆನ್ಸ್ ಇದು. ಮತ್ತೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ?
Later we have filed the written statement. And also we make a submission that refund may be the justiciable.
ನಿಮಗೆ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಇದೆಯಾ ಇಲ್ಲ?
ಬೇರೆ ಅದೇ ಒಂದು ಎಕರೆ ಇದೆ.
ಈ ಲ್ಯಾಂಡ್ ಬಿಟ್ರೆ ಬೇರೆ ಲ್ಯಾಂಡ್ ಇಲ್ವಾ?
ಇನ್ನೊಂದು ಎಕರೆ ಇದೆ.
ಇದು ಅಲ್ದಲ್ಲ? ಸರ್ವೆ ನಂಬರ್ 15ರಲ್ಲಿ ಅದೇನಿರೋದು? ಡ್ರೈ ಲ್ಯಾಂಡಾ?
ಡ್ರೈ ಲ್ಯಾಂಡ್.
ಅದೆಷ್ಟಿದೆ?
ಒಂದು ಎಕರೆ.
ಇದು 39 ಗುಂಟೆ. ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ 39 ಗುಂಟೆ ತೋರ್ಸಾರ, 1 ಎಕರೆ ತೋರ್ಸಾರ? ಅಲ್ಲಿಗೆ ಸೇಮ್ ಸರ್ವೆ ನಂಬರ್ 13 ಅಂತ ಆಯ್ತು.
ಒಂದು ವಿಟ್ನೆಸ್ ಸಪೋರ್ಟ್ಸ್
ಏನ್ರಿ?
ವಿಟ್ನೆಸ್ ಆಲ್ಸೋ ಸಪೋರ್ಟ್ಸ್ ದ ಸೇಮ್ ಔಟ್ ವಿಟ್ನೆಸ್
ಸಪೋರ್ಟ್ಸ್ ದಿ ಸೇಮ್. ಸರಿ, ಏನ್ ಅವ್ರೇನ್ ಹೇಳ್ತಾ ಇರೋದು? ನಮ್ಗೆ ಅದೊಂದು ಎಕರೆ ಡ್ರೈ ಲ್ಯಾಂಡ್ ಬಿಟ್ರೆ ಬೇರೆ ಲ್ಯಾಂಡ್ ಇಲ್ಲ ಅಂತ.
My husband was the tailor. He is no more now. I become the widow.
ಅಂದ್ರೆ ಹಸ್ಬೆಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್.
not all the family members execute. All the family members, his wife, his children,
ಎಲ್ಲರೂ ಸೇರೆ ಬರ್ಕೊಟ್ಟವ್ರೆ.
ಹೌದು.
ಈಗ ಅವನು ಇಲ್ಲ. It is very difficult to
ಓನ್ಲಿ ಹ್ಯುಮ್ಯಾನಿಟೇರಿಯನ್ ಗ್ರೌಂಡ್. ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಂಡು ಏನೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಅಂದೇನಿಲ್ಲ.
Even you filed an execution petition. It was not completed. Sale deed was executed.
ಸೇಲ್ ಡೀಡ್ ನಿಮ್ ಪರವಾಗಿ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಮತ್ತಿದೇನ್ರಿ? ವಾಟ್ ಇಸ್
23 ಅಲ್ಲಿ ಆಗಿತ್ತು.
23 ಅಲ್ಲಿ. ಇದು ಅಪೀಲ್ ಹಾಕಿರೋದು 23 ಅಲ್ಲಿ.
ಹೌದು.
ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಆಗಿರೋದು ಯಾವಾಗ?
Produce 22/9/2023 ಅಲ್ಲ. 22/9/2023.
ನಿಮ್ಮ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆದ ತಕ್ಷಣ ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಸ್ಕೊಂಡವ್ರೆ. ನಿಮ್ಮ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು 5th day of July 23. ಅವ್ರು ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಸ್ಕೊಂಡವ್ರೆ. ನೀವು ಅಪೀಲ್ ನ ಅಕ್ಟೋಬರ್ ಹಾಕಿದಿರಿ.
ಅಲ್ಲ,
ಕೋರ್ಟ್ ಆಗಿರುತ್ತೆ. ಥ್ರೂ ಕೋರ್ಟ್. ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಸೇಲ್ ಡೀಡ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಇಬ್ರು ಮಾತಾಡಿನ್ಬೋದಿತ್ತು. ಈಗ ಸೇಲ್ ಡೀಡ್ ಆಗೋಯ್ತು. ವಾಟ್ ಇಸ್ ದೇರ್?
I'm enjoying. Illa possession. Sale deeds have been put in possession through court, man. Court commissioner. I'm growing the crops there. She disturb ಮಾಡ್ತಿದ್ರು ಅವ್ರೇನ್ ಮತ್ತೆ.
This matter is listed for admission. ಹೇಳಿ ಏನು?
ಪಾಸ್ ಓವರ್ ಮಾಡಿದ ಕ್ಲಾಸ್ ಹಾಕಿ
ಕೇಳಿ ನೋಡಿ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, ಅದಕ್ಕೇನಿಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಾಡಮ್ ತಗೊಳ್ಳಿ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ.
Suit for strict performance. Suit is dismissed. Appeal is set aside, my lord. Defiant appeal, my lord. I contest, my lord. Suit agreement is dated. I property in mortgage, my lord, in favor of the husband of the plaintiff. Suitor unto, my lord. That purpose, my lord, created document, my lord. Trial court, para number 23, 33. Clear limitation and readiness. Suit is dismissed.
Heard the appellant counsel and also the counsel appearing for the respondent. And present second appeal is filed against the divergent finding. The trial court dismissed the suit for specific performance and the same is reversed. In coming to the conclusion that trial court committed an error in dismissing the suit and granted the relief of specific performance, and there is a divergent finding. And hence matter requires reconsideration. Admit the following substantive question of law arises for the consideration of the second appeal. Whether the first appellate court committed an error in coming to the conclusion that trial court erroneously dismissed the suit for specific performance. In coming to the conclusion that agreement is not proved, and also the plaintiff was not ready and willing to perform his part of contract
Kindly fast manner.
and not entitled for the relief of specific performance.
ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಹೋಗಿತ್ತು ಮೇಡಮ್. ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡಿದ್ದು ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ. ಮೀಡಿಯೇಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ ಮೇಡಮ್.
ವಾಪಸ್ ಬಂತಲ್ಲ ಅದೇನ?
ಅದೇ ಮೇಡಮ್, ಬಟ್ ಡೇಟ್ ಗೊತ್ತಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ವಿ ಮೆಮೋ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ, ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಮೇಡಮ್.
ಅಲ್ರಿ ಮೀಡಿಯೇಷನ್ ಫೇಲ್ಡ್ ಅಂತ ಬಂದಿದೆ.
ಮೀಡಿಯೇಷನ್ ಫೇಲ್ಡ್ ಆಗಿದೆ, ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ.
ರಿಸೀವ್ಡ್ ಆಸ್ ನಾಟ್ ಸೆಟಲ್ಡ್ ಅಂತ ಬಂದಿದೆ.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್.
ಆರ್ಗ್ಯುಮೆಂಟ್
ಪ್ಲೀಸ್
ಏನಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್? ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡಿದ್ವಿ ಅಷ್ಟೇನೆ. ಏನಾಯ್ತು ಮೇಡಮ್?
ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಮಾಡ್ತೀವಿ ಮೇಡಮ್.
Specific performance and committed an error in reversing the judgment of the trial court for the relief of specific performance. Records are received. No need of filing of paper book. List the matter for final hearing on 12/12.
Already execution file madam. Court commissioner
Execution ಹಾಕಿದಾರ?
court commissioner warrant also issued madam.
Totally. Heard on IA number 1 of 24. And in view of divergent finding, and this court also admitted the appeal and framed substantive question of law, the proceedings initiated by the respondent before the trial court for execution of decree is stayed till next date of hearing.
MB Chandrachud, PB Sidramaya.
Kindly pass our senior set up in another court, Your Lordship.
ಅಲ್ರಿ ಇದರಲ್ಲಿ ಕನ್ಫರ್ಮೇಶನ್ ಅಲ್ಲಿ ಮಾಡಿಫೈಡ್ ಅಂತಾರೆ.
ಹೌದು, ಏನು ಇಲ್ಲ,
ಏನು ಇಲ್ಲಲ್ಲ,
ಏನು ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಓನ್ಲಿ ಎಕ್ಸೆಪ್ಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್
ಐಟಮ್ ನಂಬರ್ 1 ಗೆ
ಈಕ್ವಿಟಬಲ್ ಶೇರ್ ಆಫ್ D2 ಇನ್ ದಿ ಶೇರ್ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಅಂತ ಮಾಡವ್ರೆ. ಬಟ್ ದಟ್ ಈಸ್ ಓನ್ಲಿ ಕನ್ಫರ್ಮೇಶನ್ ಅಷ್ಟೇ.
ಕನ್ಫರ್ಮೇಶನ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕನ್ಫರ್ಮ್ಡ್ 1/4.
ಅದರಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 1 ಅಷ್ಟೇ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು. ಅದರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಅಕ್ಸೆಪ್ಟೆಡ್, ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅಕ್ಸೆಪ್ಟೆಡ್, ರಿಲೇಶನ್ಶಿಪ್ ಅಕ್ಸೆಪ್ಟೆಡ್, ಈಕ್ವಿಟಬಲ್ ರಿಲೀಫ್ ಕೊಟ್ಟವ್ರು ಅವ್ರಿಗೆ. ಇನ್ನೇನು ಉಳಿದಿಲ್ಲ,
ಏನಿಲ್ಲ. ನೋಡೋಣ ಪಾಸ್ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ. ಅಲ್ಲ, ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ನವರು ಮಾಡಿಫೈಡ್ ಅಂತ ಮಾಡ್ತಾರೆ. ಮಾಡಿಫೈಡ್ ಅಲ್ಲೂ ಏನು ಇಲ್ಲ ನೋಡಿದಾಗ.
ಈಕ್ವಿಟಬಲ್ ರಿಲೀಫ್ ಕೊಡ್ತಾರೆ
ಎಕ್ಸೆಪ್ಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಈಕ್ವಿಟಬಲ್ ಶೇರ್ ಅಂತ ಆಫ್ D2 ಇನ್ ದಿ ಪ್ಲೇಸ್ ಆಫ್ D1.
ಅದಕ್ಕೆ ಬೆನಿಫಿಟ್ ಮಾಡಿಕೊಟ್ಟವ್ರು ಅವ್ರಿಗೆ ಅಷ್ಟೇ.
31
H ದೇವೇಂದ್ರಪ್ಪ.
ಇಲ್ವಾ ಪಾಸ್ ಅವರು?
32 SP ಲೀಲಾಧರ್, P ಪ್ರಕಾಶ್.
ಇನ್ಮೇಲೆ ಮೇಡಮ್ ಈ ಪಾಸ್ ಓವರ್ ಆದವ್ರಿಗೆಲ್ಲ ಕೊಡೋದು ಬೇಡ ಅವಕಾಶ. ಮಧ್ಯಾಹ್ನ ಮೇಲೆಲ್ಲ ಫೈಲರ್ ಹಿಂಗ್ ತಗೊಳ್ಳೋಣ. ಅಡ್ಮಿಷನ್ಸ್ ಮಧ್ಯಾಹ್ನವ್ರಿಗೆ ಎಷ್ಟಾಗುತ್ತೋ ಅಷ್ಟು ಅಡ್ಮಿಷನ್ ಮಾಡೋದು. ಪಾಸ್ ಓವರ್ ಆದವರೆಲ್ಲ ಮತ್ತೆ ಬಂದು ಮಧ್ಯಾಹ್ನ ಮಾಡೋದು ಬೇಡ. ಫೈನಲ್ ಇಯರಿಂಗ್ ರೀಚ್ ಆಗ್ತಿಲ್ಲ ಅದಕ್ಕೆ. 32 1/6 plaintiff and third defendant. D4 to 6 are half plus 1/6 modified as 1/4 in first appellate court.
Yes sir. In this case your RCP.
But partition is confirmed.
Partition is confirmed. Trial court order confirmed.
Howdu?
Decree modified.
Aste. What is the error in modification?
Modification your RCP. As per the internal page 47 your RCP see that.
Genealogical entry ಇದೆಯಾ?
ಇದೆ, internal page 47.
47.
The appellants are the sons of children of Ramanna.
47.
Yes. The Devannaya having 4 children for us.
Devannaya having 4. Devamma, Sanniramma, Ramanna, Jayamma.
Devamma died.
Devamma died. No issues, sir? No issues.
No issues. Different number 1 and 2 issues will be.
ಇದಾರ
ಸರಿ
ನಿಮ್ಮ ತೋರ್ಸಲ್ಲ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವರು ದೇವಮ್ಮ ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ ಅಂತ ಮಾತ್ರ ತೋರ್ಸವ್ರೆ.
what the court says you
ಅವ್ರಿಗೆ ಮಕ್ಳಿದಾರ?
yes
Different number 1 and 2.
1 and 2 ನಾ?
1 and 2.
ಕರೆಕ್ಟಾ?
Correct.
ಆಯ್ತು. D1 and D2.
D3 present. Sannirama second daughter. We are
Sannirama second daughter, third defendant.
We are the children of Ramanna. That is the defendant number 4, 5 and 6. And Jayamma is the plaintiff, the fourth daughter of Davanna.
Jayamma is the plaintiff.
Yes, sir.
4 share ಆಗಬೇಕಷ್ಟೇ. ಕರೆಕ್ಟ್ ಮಾಡೋಲ್ಲ 1-4.
Jayamma at the time of filing of suit itself is died.
Maybe she died, but she has left her LRs.
They are the LRs at the time of filing the suit.
ಮತ್ತೆ
They are the
1-4 ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡವ್ರೆ. ಬಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ತಪ್ಪು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ತಪ್ಪಾಗಿ ಮಾಡವ್ರೆ. That is modified in appeal.
Trial court has passed the order relying upon the
earlier judgment
proposition.
Earlier
proposition.
Is it your contention that already there was a partition? No, ಆತರ ಏನೋ ಡಿಫೆನ್ಸ್ ಇದೆಯಾ ನಿಮ್ದು?
ಇಲ್ಲ. Already, but before partition, property is sold.
ಯಾವ್ದು ಸೇಲ್ ಆಗಿದೆ?
Item number 3 and 4 ಸೇಲ್ ಆಗಿದೆ.
ಯಾರು ಸೇಲ್ ಮಾಡಿರೋದು?
ಯಾರು ಡಿಫೆಂಡ್ ನಂಬರ್ 4, 5 and 6.
4, 5 and 6. 4, 5 and 6 ಶೇರ್ ಅವ್ರಿಗೆ ಯಾರು ಪರ್ಚೇಸರ್ ಯಾರು ಇದ್ದಾರೋ ಅವ್ರಿಗೆ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ.
4, 5 and 6 ಸೇಲ್ ಮಾಡಿದ್ರು.
ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿರೋದು?
ಸೇಲ್ ಮಾಡಿದ್ದು
ಅವ್ರನ್ನ ಪಟ್ಟಿ ಮಾಡೋರ ಪರ್ಚೇಸರ್ನ?
ರಂಗಸ್ವಾಮಿ ಡಿಫೆಂಡ್ ನಂಬರ್ 9.
ಅವ್ರನ್ನ ಮಾಡ್ದಂಗಿಲ್ಲ.
9 to 12. 9 to 12.
ಮಾಡೋರ?
ಮಾಡಿ.
9th ಡಿಫೆಂಡ್
ಪ್ರಕಾಶ್ ರಂಗಸ್ವಾಮಿ.
HR ರಂಗಸ್ವಾಮಿ.
ಮಾಡಿ.
ಒಬ್ರೇನಾ? ಅವ್ರಿಗೆ ಆ ಶೇರ್ ಹೋಗುತ್ತಷ್ಟೇ. ಡಿಫೆಂಡೆಂಟ್ ಶೇರ್ ಏನ್ ಬರುತ್ತೋ ಈಗ ಆಲ್ರೆಡಿ ಸೋಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ.
ಬಿಫೋರ್ ಪಾರ್ಟಿಷನ್
he can plead for equity.
Before suit filed your worship.
ಆಗ್ಲಿ ಬಿಫೋರ್ ಆಗ್ಲಿ. Plaintiff is not a party to the sale. ಹೌದಾ?
Plaintiff
and the same is not binding. Next.
The honorable court take into consideration Pulavati case your worship.
Pulavati ಇಲ್ಲ.
Trial court has been made.
Pulavati ಹೋಯ್ತಲ್ಲ.
Vineet Sharma case your worship. So far the property is not available on the date of filing of the suit. And it has been sold by joint family.
Joint family members ಎಲ್ಲರೂ ಇದ್ರೆ ಮಾತ್ರ. ಯಾರೋ ಇಬ್ರು ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ಇದನ್ನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
What I am submitting to your worship.
ನಿಮ್ಮ substantive question of law ಏನ್ ಫ್ರೇಮ್ ಮಾಡಿದಿರಿ ಹೇಳಿ?
Substantial question of law your worship.
Whether the trial court has appreciated the facts.
Yes.
Decision declaring 1/6 share in the scheduled property, taking into consideration of the admitted fact of the defendant number 1 to 8. Whether the defendant number 4 to 6 is entitled for half share in respect of father's property and 1/6 share in the scheduled property.
Yes.
Whether the first appellate is justified in interfering with judgment and decree without sustaining the reasons. Whether the first appellate court has come to the conclusion as whether plaintiff is entitled for partition is answered in affirmative and point number 2 to 4 are is negative. ಅಷ್ಟೇನಾ? ಆಯ್ತು ತೊಗೊಳ್ಳಿ. How do the appellant counsel and also the counsel appearing for the respondent? But first appeal ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ದು? plaintiff ಏನಾ?
Plaintiff ಅಲ್ಲ ಡಿಫೆಂಡೆಂಟ್.
ಯಾರು ಡಿಫೆಂಡೆಂಟ್? ನೀವೇನಾ ಅಥವಾ?
Fourth defendant.
Fourth defendant.
Yes.
ನೀವು ಫೈಲ್ ಮಾಡಿಲ್ಲ?
ಹೌದು.
ನೀವು fourth?
4 to 6 defendant.
4 to 6 ಏನಾ? ಅಪೀಲು ನಿಮ್ದೇನೆ?
ಅಪೀಲ್ ನಮ್ದು.
ನಿಮ್ದೇನೆ ತಗೊಳ್ಳಿ. ಅಪೀಲು ನಿಮ್ದೆ, ಸೆಕೆಂಡ್ ಅಪೀಲು ನಿಮ್ದೆ.
ಸೆಕೆಂಡ್ ಅಪೀಲ್. ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರು, ಡಿಗ್ರಿನ ಮಾಡಿಫೈ.
ಅದೇ ಡಿಗ್ರಿ ಮಾಡಿಫೈ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ. ಮಾಡಿಫೈ ಏನಿಲ್ಲ, 1/4 ಮಾಡಿದ್ರು ಅಷ್ಟೇ. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 1/6 ಮಾಡಿರೋದು ತಪ್ಪು ಅಂತ.
Quantum has been
ಅಷ್ಟೇ.
changed.
Only apportionment is modified ಅಷ್ಟೇ. ತಗೊಳ್ಳಿ. How do the appellant counsel and also the counsel appearing for the respondent? The plaintiff, the factual matrix of case of plaintiff before the trial court while seeking the relief of partition and separate possession, it is contended that social properties are the ancestral and joint family properties, and hence he is entitled for a share over the social property. And defendant number 4 appeared and filed the written statement contending that suit is barred by limitation. And hence the trial court framed the issues and allowed the parties to lead evidence. The plaintiff got examined herself as PW1. And got marked the document exhibit P1 to P21. On the other hand, defendant number 4 examined herself as DW1 and got marked the document of exhibit D2, and other defendants have not led any evidence. The trial court, having considered both oral and documentary evidence, met the issues framed by the trial court and comes to the conclusion that suit share properties are the ancestral and joint family properties, and also suit is not barred by limitation as contended by defendant number 4, and granted 1/6 share and also held that defendant number 4 to 6 are entitled for half share with 1/6 share. And also comes to the conclusion that mother was passed away prior to 9/9/25, and defendant number 1 and 2 are not having any right over the suit share property. And also held that sale made by the defendant number 4 in respect of item number 1 in favor of defendant number 6 to 12 not binds the plaintiff. The same is challenged by the defendant number 4 to 6 by filing an appeal before the appellate court. And appellate court, considering grounds urged in the appeal memo, formulated the point whether the trial court justified in holding that plaintiff is entitled for a partition, and whether the trial court was justified in decreeing the suit holding that as on 2005 Devannaya was not alive. As such, the plaintiff is entitled for notional partition in the suitable properties, and whether the cross objection filed by the plaintiff is in time, and whether judgment and decree requires interference. And first appellate court, having reassessed both oral and documentary evidence, comes to the conclusion that trial court was justified in holding that plaintiff is entitled for a share over the property, and other point for consideration is answered as negative. And having reassessed both oral and documentary evidence available on record, modified the judgment in decree of the trial court in coming to the conclusion that plaintiff and the defendant number 3, being the daughters of late Devanna, they are entitled for 1/4 share each in all the suitable properties by meets and bounds. And likewise, defendant number 1 and 2, being the sons of late Devamma, together entitled for 1/4 share in the suitable properties. And defendant number 4 to 6, being the daughters of late Ramanna, they together entitled for 1/4 share in all the suitable properties, and granted equal share in respect of the original children of original propositors. And hence being agreed by the concurrent finding, present second appeal is filed by the defendant number 4 to 6. The main contention of the counsel appearing to the appellant before this court is that both the courts have committed an error in considering the suit of the plaintiff for partition, and first appellate court also not justified in interfering with the judgment and decree of the trial court and erroneously modified the same. The appellate court committed an error in answering the point number 2 to 4 as negative, and committed an error in answering the point number 1 as affirmative, and hence this court has to frame substantive question of law. Per contra, the counsel appearing to the respondent would vehemently contend that the trial court referring the Pulavati case granted 1/6 share, but in view of the judgment of apex court in the case of Vinit Sharma, rightly granted 1/6 share, and hence it doesn't require any interpretation, and modification is also in accordance with law. Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that one propositus Devannaya is the head of the family and he was having 4 children, and fourth one is daughter who filed the suit for claiming partition and made her sister children as defendant number 1 and 2 and her sister as defendant number 3 and her brother children are defendant number 4 to 6, and hence there is no dispute between the parties with regard to the relationship between the parties. It is also not in dispute with regard to the fact that property belongs to the family, and counsel appearing for the appellant would submit that defendant number 4 to 6 have already sold the property, but the plaintiff is not the party to the said sale deed. And when such being the case, the trial court and appellate court considered the material available on record in proper perspective, since the share of the plaintiff was not given and she was also not a party to any alienation, and the same not binds the plaintiff, and the same is also observed by the trial court while passing an order. And though the trial court committed an error in apportioning the share, but appellate court modified the same and rightly apportioned the same as 1/4. And when such being the case, when the question of law and also the facts were considered by both the courts, I do not find any error and also any perversity in the finding of trial court and appellate court in granting the share in favor of the plaintiff, and hence no ground is made out to admit and frame substantive question of law, and hence not a case for invoking section 100 of CPC.
2 ಐಟಮ್ ಮಾತ್ರ ಉಳ್ಕೊಂಡಿದೆ, ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಸೇಲ್ ಆಗೋದು. 14 ಗುಂಟೆ ಒಂದು 8 ಗುಂಟೆ ಮಾತ್ರ ಉಳ್ಕೊಂಡಿದೆ.
ಅಲ್ಲಿ FDP ನಲ್ಲಿ ಬಂದಾಗ ಅವ್ರು ಕ್ಲೈಮ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಅವರು ಕ್ಯಾನ್ಸಲೇಷನ್ ಸೇಲ್ ಇಡೋ ಡಿಗ್ರಿ ಕೇಳಲೇ ಇಲ್ಲ. ಅಲ್ಲ, ಸೂಟಲ್ಲಿ
ಕ್ಯಾನ್ಸಲೇಷನ್ ಬರೋದೇ ಇಲ್ಲ. ಬೀಡಿಂಗ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಅಂದ್ರೆ ಮುಗಿದೋಯ್ತು.
ಅದನ್ನು ಕೇಳಿದೆ,
ಅದು ರಿಲೀಫ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಅಂತ
ಕೇಳಿದ್ದಾರೆ.
ಹೇಳಿ ಯಾರು? ಹಾ
ಎರಡರಲ್ಲಿ ಎಷ್ಟು ಮ್ಯಾಟರ್ ನಡೀತು. ನಮ್ಮ 20 ಎಷ್ಟು ಮ್ಯಾಟರ್
ಆಯ್ತು.
ಯಾವ್ದು ಅಕೌಂಟ್
ಕೊಟ್ಟವ್ರ ಫೇವರಬಲೇಷನ್ ಆಗಿದೆ, ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟವ್ರ. ಥರ್ಡ್, this court wide order dated 23/9/25 in respect of R2, R3, R5 to 7 as held sufficient but are absent and opportunity given to represent through counsel, but in spite of that opportunity they did not choose to engage any counsel ಅಂತ ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಹಾಕೋಬಿಡಿ ಅಷ್ಟೇ. ಅಲೋ ಆಗಿದೆ ಅಲ್ಲ ಮೊದಲೇ ಹೇಳಿ ಸಫಿಶಿಯಂಟ್ ಮಾಡೇ ಅಲ್ವಾ? And consequently a number 2 of 24 for impleading is allowed. The appellant counsel is directed to amend the cast title. ಬೇಕಾಗಿಲ್ಲ, no need of amending the cast title since they were already brought on record.
We represent only the respond number 1, my lord. Respond number 1 plaintiff.
ನೀವು ಒಂದಿಗೆ ಮಾತ್ರ ಅದು R1 ಅಂತ ಹಾಕೊಳ್ಳಿ. heard the respondent number 1 ಅಂತ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ.
33 previous Sidramaya, SV Prakash.
Plaintiff second appeal. Suit is for specific performance. Trial court has decreed the suit. First appellate court has set aside and
refund ಗೆ ಮಾತ್ರ ಮಾಡಿದ್ದಾರೆ.
The first appellate court has come to conclusion that the market value of the property exceeds the agreement without having any document and any evidence on behalf of the respondent. And they are having a business with the loan transaction with the PW2 witness. But in fact, PW2 has admitted that even now we are having a separate business transactions with the defendants. The agreement is proved, it is a registered agreement. Signatures were admitted, and we have issued the legal notice. They have not replied to the legal notice. Under these circumstances, my lord,
heard the appellant counsel and also the counsel appearing for the respondent, and there is a divergent finding with regard to the claiming of relief of specific performance, and at the first instance trial court granted the relief of specific performance and the same is reversed in the appeal, directing to refund an amount of rupees 2 lakh with 10%, and hence matter requires reconsideration. Admit the following substantive question of law arises for the consideration: whether the first appellate court committed an error in reversing the finding of trial court, directing to refund an amount of 2 lakh with 10% instead of relief of specific performance as directed by the trial court.
paper book may be dispensed, my lord.
Filing of paper book is dispensed, and list the matter for final hearing on 12/12.
34 Kumara KG.
Plaintiff appeal, my lords, concurrent finding. Suit for declaration and injunction, my lords. The trial court and my lords first appellate court has passed an order might giving findings that, my lords, the plaintiff vendor does not have ownership of 29 guntas, my lords. He has purchased the land of 29 guntas, but my lords, as per the CW2, who is the court commissioner, was appointed by the court, he has given the report that, my lords, they have purchased the excess land of 6.5 guntas.
Go to paragraph number 15 of the trial court judgment.
Please, my lords. ಅದೇ ತಪ್ಪಾಗಿರೋದು.
ಕಮಿಷನರ್ ಇಬ್ರು ಫಸ್ಟ್ ಒಂದ್ಸರಿ ಆಯ್ತು,
ಫಸ್ಟ್ ಕಮಿಷನರ್ ರಿಜೆಕ್ಟೆಡ್,
ಅದಕ್ಕೆ ತಕರಾರು ಹಾಕಿದ್ರಿ,
ಅದು ರಿಜೆಕ್ಟ್ ಆಯ್ತು. ಸೆಕೆಂಡ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಷ್ಟೇ
ಆಯ್ತು.
Lords, the 15 as my lords said, aforesaid the second commissioner by name Nagaraju was got examined as CW2 and 2 documents were marked, though his exhibit C5
through him
exhibit C5 and C6 as per the report and evidence of this witness, the vendor of the plaintiff, though as a documents had ownership of 29 guntas, as per documents he has ownership of 29 guntas. In factuality had possession of 6.5 guntas lesser land. This was the report. As per the report, the land bearing survey number 263 is measuring 22.5 guntas as against the revenue entries of 29 guntas. So 29, the revenue entries was disclosed that he has ownership of 29 guntas, but he said 20, our actual possession 22.5 guntas. He has later, he has specifically deposed that the sale deed is in excess of 6.5 guntas against the survey documents. Thus, it is clear transpires that the vendors of the plaintiff did not have the right to alienate the property in excess as claimed by the plaintiff. So the plaintiff's vendor has no right to sell the property excess of 22 of guntas. The court opinion that the plaintiff has failed to prove his possession over the suitable property in its entirety without there being any possession, without the property being in existence, and the plaintiff cannot claim his ownership over the suitable property. As such, this court of
ರಿಲೀಫ್ ಕ್ಲೇಮ್ ಮಾಡಿರೋದು ಎಷ್ಟಕ್ಕೆ?
ನಾವು 8 ಗುಂಟ ಅಷ್ಟೇ 8 ಗುಂಟ ಅಷ್ಟೇ ಕ್ಲೈಮ್ ಮಾಡಿರೋದು.
8 ಗುಂಟನ?
ಅದರಲ್ಲಿ ನಾನು ಐ ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ರಿಮೈನಿಂಗ್ 10 ಗುಂಟಾಸ್ ವಿತ್ ಮೀ, 8 ಗುಂಟಾಸ್ ವಿತ್ ಮೈ ವೈಫ್.
ನೀವು ಕೊಂಡ್ಕೊಂಡಿದ್ದು ಎಷ್ಟು ನಿಮ್ಮ ವೆಂಡರ್ ಇಂದ?
As per 1992 sale deed, I have purchased 29 guntas.
29 ಗುಂಟಾಸ್.
ನಾನು 8 ಗುಂಟಾಕ್ಕೆ ಸೂಟ್ ಹಾಕ್ತೀನಿ ಬಿಕಾಸ್
ಆಯ್ತು, ನೀವು ಎಷ್ಟು ಸೇಲ್ ಮಾಡಿರಿ ಹೇಳಿ?
ನಾನು 10 ಗುಂಟಾಸ್ ಸೇಲ್ ಮಾಡಿದ್ದೀನಿ, 8 ಗುಂಟಾಸ್ ನನ್ನ ವೈಫ್ ಹತ್ರ ಇದೆ.
10 ಗುಂಟಾಸ್ ಸೇಲ್ ಮಾಡಿದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ ಇನ್ನು ನಿಮ್ಗೆ 21 ಗುಂಟ ಇರಬೇಕು. 21
ಗುಂಟ ಇರಬೇಕು. ಅದರಲ್ಲಿ 8 ಗುಂಟೆ ನನ್ನ ಹೆಂಡತಿ ಹೆಸರಲ್ಲಿ ಇದೆ.
ಎಷ್ಟು?
8 ಗುಂಟೆ. ಅದು ಡಿಫರೆಂಟ್. ನಾವು ಮೆಲಾಟ್ಸ್
ಡಿಫರೆಂಟ್ ಅಂತಂದ್ರೆ ಅದು ಸೇಲ್ ಡೀಡ್ ಪರ್ಚೇಸ್ ಮಾಡುವಾಗ ಏನ್ ಮಾಡಿದ್ರಿ? ಇಬ್ಬರ ಹೆಸರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಮಾಡಿದಿರಾ?
ಇಲ್ಲ.
ವೈಫ್ ಹೆಸರಿಗೆ ಹೆಂಗ್ ಹೋಯ್ತು 8 ಗುಂಟೆ?
ಅದು ಮತ್ತೆ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. ಈವನ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಆಕ್ಚುಲಿ ಸರ್ವೆ ನಂಬರ್ 263 ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು 263 ಅಲ್ಲ, 262/3 ಅದು.
ಅದೇನಾರಾಗ್ಲಿ ನಿಮ್ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಹೇಳ್ರಿ.
29 ಗುಂಟಾಸ್.
29 ಗುಂಟಾಸ್ ಯು ಹ್ಯಾವ್ ಪರ್ಚೇಸ್. ಬಟ್ ಆಕ್ಚುಲಿ ಆ ಸರ್ವೆ ನಂಬರ್ ಇರೋದು 22 ಗುಂಟೆ.
ಅದು ಯಾವಾಗ ಹೇಳೋದು? ಆಫ್ಟರ್ ಆಲ್ ಮೆಲಾಟ್ಸ್ ದೇರ್ ಆರ್ 4 4Ds were done, there are separate numbers were given, but the court
ಆಯ್ತು. ಈಗ ನೀವು 8 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿದ್ರಿ, ನಿಮ್ ವೈಫ್ ಹೆಸರಲ್ಲಿ
10 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿ ಸೈಟ್ ಆಗುತ್ತೆ.
10 18 ಆಯ್ತು.
10 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿ ಸೇಲ್
ವೈಫ್ ಹೆಸರಲ್ಲಿ 8 ಗುಂಟೆ ಆಯ್ತು. 18.
ಅದರಲ್ಲಿ ರಿಮೈನಿಂಗ್ 8 ಗುಂಟೆ ನನ್ನ ಹತ್ರ ಇದೆ. ಸೊ ದಿ ಮುನ್ಸಿಪಾಲಿಟಿ
8 ಗುಂಟೆ ಇಲ್ವಲ್ಲ, ಈಗ ಸರ್ವೆ ಮಾಡಿದಾಗ ಬರೀ ಇರೋದೇನ 4.5 ಗುಂಟೆ.
ಅದೇ 6 ಗುಂಟೆ ಅಂತ ರಿಮೈನಿಂಗ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಬಟ್ ಸ್ಟಿಲ್ ನನಗೆ ಅಷ್ಟು ಬರ್ಲಿ, ಅದು 4 ಗುಂಟೆ ಮತ್ತೆ ಉಳ್ಕೊಳ್ಳುತ್ತೆ ನನಗೆ. ರಿಮೈನಿಂಗ್ 18 ಗುಂಟೆ ಆದ್ರೂನು ಅವ್ರು ಹೇಳೋದು 22 ಗುಂಟೆ ಅಂತ. 8 ಗುಂಟೆನೂ ಡಿಸ್ಮಿಸ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಐ ಆಮ್ ಸೀಕಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ದಿ ಕೋರ್ಟ್ ಸೆಡ್ ಎಂಟೈರ್ 8 ಗುಂಟೆ ಇಲ್ಲ, ಅಲ್ಲಿ ಯು ಆರ್ ದಿ ಲೆಸ್ಸರ್ ಪೊಸೆಷನ್ ಇದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವಾಗ ಅಟ್ಲೀಸ್ಟ್ ಲೆಸ್ಸರ್ ಪೊಸಿಷನ್ ಆರ್ಡರ್ ಮಾಡಬಹುದಿತ್ತು. ಮೆಲಾಟ್ಸ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ, CW2 ಎವಿಡೆನ್ಸ್, ಇದನ್ನ ಓದ್ಬಿಡ್ತೀನಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಮೆಲಾಟ್ಸ್ ಹಿ ಅಡ್ಮಿಟ್ಸ್ ದಟ್ ಐ ಆಮ್ ಇನ್ ಪೊಸೆಷನ್ ಆಫ್ ಸಮ್ ಲ್ಯಾಂಡ್ ಇನ್ ಅದರ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಮುನ್ಸಿಪಾಲಿಟಿ ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾರೆ. ಮೆಲಾಟ್ಸ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ರಿಪೋರ್ಟ್.
ಮುನ್ಸಿಪಾಲಿಟಿ ಬೇರೆ ರೋಡ್ ಮಾಡಿದಾರಾ?
ಮುನ್ಸಿಪಾಲಿಟಿ ನಮ್ ಜಾಗದಲ್ಲಿ ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದಟ್ ವಾಸ್ ದ ರಿಪೋರ್ಟ್ ಮೆಲಾಟ್ಸ್. ಕೈಂಡ್ಲಿ ಸಿ ದಿ ರಿಪೋರ್ಟ್ ಮೆಲಾಟ್ಸ್. CW2 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವ್ರು ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಅದನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ರೆ ಇನ್ ಡೀಟೇಲ್?
ಅದನ್ನ ಏನು ಹೇಳೇ ಇಲ್ಲ. ಸೇಮ್ ಫಸ್ಟ್ ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಬರೀತಾರೆ ಅದನ್ನೇ ಬರೀತಾರೆ. ಮತ್ತೆ ಸರ್ವೆ ನಂಬರ್ಸ್ ಎಲ್ಲ ರಾಂಗ್ ಆಗಿ ಹೇಳ್ತಾರೆ. ನಂದು ಕ್ಲೈಮ್ ಇರೋದು
ಫರ್ದರ್ ನೋಡಿ ಪ್ಯಾರಾ 36 ಅಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಫ್ CW2 and sketches for exhibit C6 clearly indicate that vendor of the plaintiff was in possession of 22 guntas in serve number so and so.
ಅದೇ 22 ಗುಂಟ ಅಂತ ಬರೀತಾರೆ. ರಿಮೈನಿಂಗ್ ಇದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳಲ್ಲ. ಅದು ಸರ್ಟನ್ ಸ್ವಲ್ಪ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದನ್ನ ಏನು ಹೇಳೋದೇ ಇಲ್ಲ ಅವರು.
ಹೋಗ್ಲಿ, ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಈಗ ನಿಮ್ ಪೊಸಿಷನ್ ಎಷ್ಟಿದೆ ಅಂತ ಇಷ್ಟು ಅಂತ
ಹೇಳಲ್ಲ. ಅದನ್ನೇ
ತೋರಿಸಿಲ್ಲ.
ಅದನ್ನ ತೋರಿಸಿಲ್ಲ. ಮೆಲಾಟ್ಸ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದಿ CW2 ಅದರಲ್ಲಿ ಇದೆ, ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೋತಾರೆ, ಮತ್ತೆ ಅದನ್ನ ತೋರಿಸಿಲ್ಲ.
ನೀವು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ರೆ 8 ಗುಂಟೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನೋ ದಾಖಲೆ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
ಅದೇ ಅವರು 29 ಗುಂಟೆ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ. ದೇರ್ ಆರ್ ಸೇಲ್ ಡೀಡ್, ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ, ಮುಟೇಷನ್ ಇದೆ, ಎಲ್ಲ ಇದೆ. ಅದಾದ್ಮೇಲೆ 10 ಗುಂಟೆನ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಕನ್ವರ್ಷನ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ದಿ ಪರ್ಚೇಸರ್ ಹೂ ಪರ್ಚೇಸ್ ದಿ ಲ್ಯಾಂಡ್ ಫ್ರಮ್ ಮೀ, ದಿ ಪ್ಲೈಂಟಿಫ್, ದೇ ಹ್ಯಾವ್ ಕನ್ವರ್ಟೆಡ್ ದಿ ಲ್ಯಾಂಡ್, ದೇ ಹ್ಯಾವ್ ಸೋಲ್ಡ್ ಇಟ್ ಟು ದಿ ಅದರ್ ಡಿಫೆಂಡೆಂಟ್ಸ್.
RTC ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ತೋರಿಸ್ತಾ ಇದಾರೆ?
29 ಗುಂಟಾಸ್.
29 ಗುಂಟಾಸ್ ಅಲ್ಲಿ ನೀವು ಸೇಲ್ ಮಾಡಿದಿರಲ್ಲ.
ನನಗೆ 28 ಗುಂಟಾಸ್ ಸೇಲ್ ಮಾಡ್ತಾರೆ. RTC
ಅದಾದ್ಮೇಲೆ ಈಗಿಂದ ಹೇಳ್ಬೇಕು ನೀವು. ಆಸ್ ಆನ್ ದ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸೂಟ್
8 ಗುಂಟಾನೇ ಇದೆ
2006 ಅಲ್ಲಿ.
Yes my lords, kindly see the RTCs my lords. Exhibit P3 MRO ಆಗುತ್ತೆ 8 ಗುಂಟಾಗೆ. ನನಗೆ
ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಹೋಗಿ ನೋಡೋಣ ಎವಿಡೆನ್ಸ್ ಗೆ.
ನಾಗರಾಜು CW2 ನಾಗರಾಜು
ವಕೀಲೆ ಅಲಿನೇಷನ್ ಇರಬೇಕು. ಅದು ಆಗಿರೋದಕ್ಕೆ ನಾನು
ಅಲ್ಲಿ ಫಸ್ಟ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಇದರಲ್ಲಿ CDEF ಎಂದು ನಾನ್ ಅಲಿನೇಷನ್ ಆಗಿರೋ ಆಸ್ತಿ ಅಂದ್ರೆ ನಿಜ, ಅನ್ಯಕ್ರಾಂತ ಆಗಿರೋದ ಆಸ್ತಿಯಲ್ಲಿ ರೋಮನ್ ಅಂಕಿಗಳ ರೀತ್ಯ 9 ಎಂದು ಗುರುತಿಸಿರುತ್ತದೆ. ನಿಶಾನೆ 5ರಲ್ಲಿ CDEF ಎಂದು ಗುರುತಿಸಿರುವ ಆಸ್ತಿ ದಾವಾ ಆಸ್ತಿ ಆಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಪೂರ್ವ ಶೆಟ್ಟಿರವರು ತಾವು ರತ್ನಮ್ಮ ಎಂಬುವರಿಗೆ ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ 1 ಗುಂಟೆ ಜಾಮನ್ನು ಮಾರಾಟ ಮಾಡಿರ್ತಾರೆ. ಈ ಬಗ್ಗೆ ದಾಖಲೆ ಇಲ್ಲ. ಆ 1 ಗುಂಟೆ ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ ಸೇರಿಕೊಂಡಿದೆ. ನಾನು ರೋಮನ್ ಅಂಕಿ 9ರಲ್ಲಿ ಗುರುತಿಸಿದ ಜಾಗದಲ್ಲಿ ಜಯರಾಮ್ ಬಿನ್ ನಂಜೇಗೌಡ ಖಾಲಿ ನಿವೇಶನ ಇರುತ್ತದೆ. ನಾನು ರೋಮನ್ ಅಂಕಿ 10ರಲ್ಲಿ ಗುರುತಿಸಿರುವ ಜಾಗದಲ್ಲಿ ಧನಲಕ್ಷ್ಮಿ ಕೋಮ್ ಇರುತ್ತದೆ. ನಾನು ರೋಮನ್ ಅಂಕಿ 11ರಲ್ಲಿ ಗುರುತಿಸಿರುವ ಜಾಗದಲ್ಲಿ ರಾಮಶೆಟ್ಟಿ ನಿವೇಶನ ಇರುತ್ತದೆ. ನಾನು ನಡೆಸಿರುವ ರತ್ನಮ್ಮ ಕೋಮ್ ಖಾಲಿ ನಿವೇಶನ ಇರುತ್ತದೆ. ಮಾರಾಟ ಮಾಡಿದ 1 ಗುಂಟೆ ರೋಮನ್ ಅಂಕಿ 12ಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟದಾಗಿರುತ್ತೆ. ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ ಉಳಿದ ಪೂರ್ವ ಸೆಟ್ಟರ್ ಹೆಸರಿನಲ್ಲಿ ರೋಮನ್ ಅಂಕಿ ನೀವ್ ಎಷ್ಟನೇ ಪ್ರತಿವಾದಿ?
ಅಲ್ಲ ನಾನು ಪ್ಲೈಂಟಿಫ್.
ನೀವೇ ಪ್ಲೇಂಟಿಫ್?
ಹೌದು.
ಹಾ,
ಇವಾಗ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಮ್ ಜಾಗದಲ್ಲಿ ಸ್ವಲ್ಪ ರೋಡ್.
ನೀವೇ ಪ್ಲೇಂಟಿಫ್ ವಿಚಾರಣೆ ಮಾಡಿಸಿದ್ರಲ್ಲ, ಅವಾಗ ಏನ್ ಹೇಳ್ಸಿದ್ರಿ? ಹೋಗ್ಲಿ ಅಲ್ಲಿ ಏನು ಮಾಡಿಲ್ಲ, ನೀವು ಬರೀ ಮಾರ್ಕ್ ಮಾಡಿಸಿದ್ರಿ. ಎಕ್ಸಿಬಿಟ್ P5 P6 ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಆನ್ಸರು? ನೀವು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದೀರಿ ಅಂತ ನೀವು ಕಮಿಷನರ್ನ ವಿಚಾರಣೆ ಮಾಡಿದಾಗ ಎಲ್ಲಿ ಕೇಳಿದಿರಿ ಅವರಿಗೆ?
ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಸೆಕೆಂಡ್
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್
ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ ಉಳಿದೆಲ್ಲ ಪುರುಷರ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ. ಉಳಿದ ಫಸ್ಟ್ ಲೈನ್ ಅಲ್ಲೇ ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ
ಉಳಿದಿದ್ದೆಲ್ಲ ಪರ್ವ ಶೆಟ್ಟರ್ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ.
ಅಲ್ಲಿ ಅಂಕಿ 12 ಇರುದಿಲ್ಲ.
12 ಅನ್ಯಕ್ರಾಂತ ಆಗಿಲ್ಲದ ಪ್ರದೇಶದಲ್ಲಿ
ಅದು ಬಿಟ್ಟು ಉಳಿದೆಲ್ಲ ಪೂರ್ವ ಶೆಟ್ಟಿ ಇದ್ರಲ್ಲಿ ಇರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ಹೆಸರಲ್ಲಿ ಇರುತ್ತದೆ. ರೋಮನ್ ಅಂಕಿ 9, 10, 11, 12.
ಆಯ್ತು, ನೀವು ಎಲ್ಲಿ ಎಲಿಸಿಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಿ ಅವನಿಂದ? ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ ಚೀಫ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲೂ ಹೇಳ್ಸಿಲ್ಲ ನೀವ್ ಎಷ್ಟಲ್ಲಿ ಪೊಸಿಷನ್ ಇದೀರಿ ಅಂತ. ಸರ್ವೆಗೆ ರಿಪೋರ್ಟ್ ಹಾಕಿದಾಗ ಸೆಕೆಂಡ್ ರಿಪೋರ್ಟ್ಗೂ ನೀವು ತಕರಾರು ಹಾಕಿದಿರಿ. ಆ ತಕರಾರು ಬಗ್ಗೆ ಎಲ್ಲಿ ಕೇಳಿದಿರಿ? ಕಮಿಷನರ್ ಹತ್ರ ನೀವೇ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದು ವಿಟ್ನೆಸ್?
ಮಾಡಿದ್ರೆ ಬಟ್ ಅದ್ರ ಬಗ್ಗೆ ಕೇಳಿಲ್ಲ. ಬಟ್
ಅಲ್ಲ, ಮುಖ್ಯ ವಿಚಾರಣೆ ನ್ಯಾಯಾಲಯದಿಂದ ವಾದಿ ಪರ ಶ್ರೀಮತಿ LV ಅವರಿಂದ ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಿರಿ ಅವರಿಗೆ. ಎಲ್ಲಿ ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದ್ರಿ ನೀವು?
ಅದೊಂದೇ ಇರೋದು. ಉಳಿದ
ನೀವು ಎಲ್ಲಿ ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದಿರಿ? ಏನು ಇಲ್ಲ.
they have not asked my lords. The remaining land is at least 22 ಅಲ್ಲ 18
unless you prove the exact possession, that too what is the extent. Question of granting the permanent injunction.
Now as per the documents my lords, I have got ownership my lords over 29 guntas. ಅದರಲ್ಲಿ 6 ಗುಂಟೆ ಅಂತ ಎಕ್ಸೆಸ್ ಅಂತ ಹೇಳಿದ್ರು ಅದು ಇನ್ನು ಉಳಿದಿರೋದು ನನಗೆ 2 ಗುಂಟೆ ಮತ್ತೆ ಇರುತ್ತೆ.
ಉಳಿದಿದ್ದು ಎಲ್ಲಿದೆ ಅನ್ನೋದನ್ನ ಐಡೆಂಟಿಫೈ ಆಗಬೇಕಲ್ಲ ನಿಮಗೆ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಕೊಡಕ್ಕೆ.
ಈವನ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಆಲ್ಸೋ my lords not identified.
ಮತ್ತೆ ನೀವು ಕೇಳಿಲ್ಲಲ್ಲ ಅಟ್ಲೀಸ್ಟ್. ನೀವು ಕಮಿಷನರ್ಗೆ ಸ್ಕೆಚ್ ಕೊಟ್ಟು ಎಷ್ಟರಲ್ಲಿ ಇದಾರೆ ಪೊಸಿಷನ್ ಅಂತ ನಿಮ್ಮ ಮೆಮೊ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅನ್ನ ನಿಮ್ಮ ಕಮಿಷನರ್ಗೆ ಕೇಳಬೇಕಿತ್ತು, ನೀವು ಅದು ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಇದು ಕೋರ್ಟ್ ಅಷ್ಟೇನೆ ಸರ್ವೆ ನಂಬರ್ 162
ಹಾ ತೊಗೊಳ್ಳಿ. This matter is listed for admission. I heard the counsel appearing for the appellant.
Let's kindly see my
second appeal ಇದು ನಿಮ್ಮ scope is very limited.
I'll make my lords both kindly see my plaint my lords.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನು? ಕಮಿಷನರ್ ಪ್ರಕಾರ 22.5 ಗುಂಟೆ ಇದ್ರೂನು ಮಾರಿರೋದೇ 10 ಗುಂಟೆ ಎಲಿನೇಷನ್ ಮಾಡಿ ಬಾಕಿದೆಲ್ಲ ಇನ್ 8 ಗುಂಟೆ ನನ್ನ ವೈಫ್ ಹೆಸರಲ್ಲಿ ಇದೆ, ರಿಮೈನಿಂಗ್ 4.5 ಗುಂಟೆ ಕೊಡ್ಬೇಕಿತ್ತು ಅಂತ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್. ಈವನ್ ಇನ್ ಅಸ್ಯೂಮಿಂಗ್ ದಟ್ lesser the extent of possession.
My lords, I have purchased my lords, my vendor purchased the land in the year of 1948 for 29 guntas my lords. Till 92 no dispute with respect to the 29 guntas. 92 I have purchased 29 guntas. In my name the artist is one letter.
ನೋಡ್ರಿ, ಈಗ ಇಬ್ರು ಕಮಿಷನರ್ ಹೋಗವ್ರೆ, ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡವ್ರೆ, ಇಬ್ರು ರಿಪೋರ್ಟ್ ಅಷ್ಟೇನೆ
ಹೇಳ್ತಾರೆ ಆಲ್ರೆಡಿ ರೋಡ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಂತ.
ಮತ್ತೆ
ನಿಮ್ ಜಾಗದಲ್ಲಿ ರೋಡ್ ಆಗಿದೆ, ರಿಮೈನಿಂಗ್ ಸ್ವಲ್ಪ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ರೋಡ್ ಆಗಿದ್ರೆ ನೀವು ರೋಡ್ ಮಾಡದವ್ರಿಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳಿದಿರ? ನೀವು ಅಕ್ವಿಜಿಷನ್ ಆಗಿದೆಯಾ?
ಇಂಜೆಕ್ಷನ್ ಕೇಳ್ತಾರೆ. ಮೈ ಪಾಯಿಂಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್ಸ್ 8 ಗುಂಟಾಸ್ ರಿಮೈನಿಂಗ್ ಗೆ ನನ್ನ ಹೆಸರು ಖಾತಾನೂ ಆಗಿದೆ, ಆರ್ಟಿಸಿನೂ ಕೂತಿದೆ.
ಬಟ್ ಅಲ್ಲಿ ಇಲ್ಲಲ್ರಿ, ಆಕ್ಚುಯಲ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಅದೇ ಹೇಳ್ತೀನಿ ಸರ್. ಅದ್ರಲ್ಲಿ
ಈಗ ನಿಮ್ಗೆ ಇಂಜೆಕ್ಷನ್ ಕೊಟ್ರೆ ನೀವು ಹೋಗಿ ಬೇರೆ ಕಡೆ ಜಾಗದಲ್ಲಿ ಮಾಡ್ಕೊಂಡ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಮಾಡಕ್ಕಲ್ಲ.
ಇಂಜೆಕ್ಷನ್ ಅಲ್ಲ, ನಾನು ಇರೋ ಜಾಗಕ್ಕೆ ನನಗೆ ಡಿಕ್ಲೇರೇಷನ್
ಕೇಳ್ತಾ ಇರೋದೇ ಇಂಜೆಕ್ಷನ್ ರೀ.
ಅಲ್ಲ ಡಿಕ್ಲೇರೇಷನ್ ಇಂಜೆಕ್ಷನ್.
ಹೌದು, ಮತ್ತೆ ಅಲ್ಲಿ ಬೇಕಲ್ಲ, ಇರ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ ನಾನು ರಿಮೈನಿಂಗ್ ಅಟ್ ಲೀಸ್ಟ್ ರಿಮೈನಿಂಗ್ ಜಾಗಕ್ಕೆ my lords they admits that my lord there was a road.
ಯಾವುದು ಅನ್ನೋದು ಐಡೆಂಟಿಫೈ ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
ಅದೇ ಪೊಸಿಷನ್ ಐಡೆಂಟಿಫೈ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. when my lords court
unless you establish the possession.
My lords, when the court commissioner was appointed my lords he went to the spot my lords. He
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಗೆ ನಿಮ್ಗೆ ಏನ್ ಬೇಕು ಅನ್ನೋದ ಮೆಮೊ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ನೀವು ಕೊಡಬೇಕು ಅವರಿಗೆ. ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಏನ್ ಆನ್ಸರ್ ಮಾಡಿದಾರೆ ಮಾಡಿಲ್ಲ ಅನ್ನೋದು ನೀವು ಹೇಳಬೇಕು. ಅದನ್ನ ನೀವು ಕೇಳಬೇಕು. ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡುವಾಗ ಕಮಿಷನರ್ನ ಎಲ್ಲಿ ಕೇಳಿದಿರಿ?
ಕೇಳಿಲ್ಲ, but
ಮತ್ತೆ?
he's not answered.
ಕೇಳಿಲ್ಲ ನಾವೇನ್ ಬರೆಯಕ್ಕಾಗುತ್ತೆ ಇಲ್ಲಿ?
ಮತ್ತೆ ಕೋರ್ಟ್ ಎರಡು ಕೋರ್ಟ್ ಸರ್ವೆ ನಂಬರ್
ನೋಡ್ರಿ ಕುಮಾರ್, ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್.
ವೇಸ್ಟ್ ಮಾಡ್ತಿಲ್ಲ my lords, the court has wrongly said that
ನೀವು ಬೇಕಾದ್ರೆ ಅಲ್ಲಿ ಉಳಿದಿರೋ ಲ್ಯಾಂಡಿಗೆ ಮತ್ತೊಂದು ಲಿಬರ್ಟಿ ಕೊಡ್ತೀನಿ, ಹಾಕ್ಸ್ಕೊಂಡು ಸರ್ವೆ ಮಾಡಿಸ್ಕೊಂಡು ಯು ಕ್ಯಾನ್ ಕ್ಲೈಮ್ ಫಾರ್ ದಿ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜಂಕ್ಷನ್.
that liberty my lords, I only seeking that liberty.
That is only liberty. Told. Heard the appellant counsel and heard the appellant counsel. This matter is listed for admission. This appeal is filed against the concurrent finding. The factual matrix of case of the plaintiff while seeking the relief of declaration and permanent injunction in OS number 139 of 2006. It is contended that the plaintiff is the owner of the social property that is more fully described in the schedule, that is 8 kuntas of land. And also he is in possession of the social property and defendants are interfering with possession of the social property. And defendant 1 was placed ex parte. Defendant number 2 to 5 appeared and filed their objections, contending that plaintiff had no right to alienate the social property and also not in possession of the property. And it is contended that defendant number 1 formed road long back and electric poles have been erected. And plaintiff has filed a false suit with larger extent and hence he is not entitled for the relief. The trial court, having considered both oral and documentary evidence available on record, comes to the conclusion based on the report of the commissioner, since 2 commissioners were appointed and the first one was rejected and second one was also filed the report and the same is objected by the plaintiff, but his contention was not accepted, and comes to the conclusion that plaintiff has not made out any ground to reject the commissioner report. The trial court, having considered the evidence of CW2, who is the commissioner, and also the report of exhibit C5 and C6, is very clear that though as per the documents ownership is about 29 guntas in all, but in factuality 6.5 guntas possession is less than total extent of land of 29 guntas. The land is measured, the land bearing survey number 263 is measuring 22.5 guntas as against the revenue entries of 29 guntas. And also he has specifically deposed that sale deed is in excess of 6.5 guntas as against the survey documents. And hence it clearly transpires that vendor of the plaintiff did have the right to alienate the property in excess as claimed by the plaintiff. And hence plaintiff has failed to prove his possession over the social property in its entirety. Stop. Without there being any possession, comma, without the property being in existence, comma, the plaintiff cannot claim his ownership over the social property, and hence answered the issue number 1 as negative and also answered the issue number 2 as negative with regard to the interference is concerned. And so also comes to the conclusion that plaintiff is not entitled for the relief of declaration and permanent injunction by referring the judgment of Anantula Sudhakar case and dismiss the suit of the plaintiff. Being agreed by the said judgment and decree, an appeal is filed in RA 5033 of 22, and appellate court, having considered the grounds which have been urged, formulated the point whether the findings of the trial court that plaintiff has failed to prove his ownership and possession over the suitable property, and whether the trial court committed in holding that plaintiff has failed to prove alleged interference and the suit itself is not maintainable, and whether it requires interference. The first appellate court, having reassessed both oral and documentary evidence in keeping the grounds which have been urged, rightly comes to the conclusion that the trial court findings that plaintiff has failed to prove his ownership and possession as affirmative, and so also with regard to the interference, no such interference, answered the point as affirmative and other two points answered as negative. And appellate court also, while coming to such a conclusion, taken note of both oral and documentary evidence, as well as in paragraph number 30, taken note of that in order to measure and identify the properties, court commissioner were appointed, and two commissioners were appointed, and subsequent commissioner also examined as per CW2, and it is the definite evidence of PW1 that he is the owner in possession of the social property by virtue of the registered sale deed dated 28/8/1992. But the defendants have categorically denied the title and possession over the social properties. And it is the claim of the plaintiff that he is in possession in terms of Exhibit P3. But court commissioner who has been appointed has given the report in terms of Exhibit P5 and 6, C5 and 6. And Exhibit C5 is the sketch prepared by the court commissioner. The report of the court commissioner would show that though the vendor of the plaintiff had ownership to the extent of 29 guntas, but in fact he was in possession only 22.5 guntas, but he cannot convey more than what he was possessed. And also taken note of C5 and C6 that Bhaira Shetty and his family members did not have any right to alienate excess land as claimed by the plaintiff. And also it is the definite evidence of CW2 that only 22.5 guntas in survey number 263 is in existence.
ಅದೇ ತಪ್ಪು ಮಾಡಿರೋದು ಅವರು 263 ಅಂತ ಹೇಳ್ಬಿಡ್ತಾರೆ.
And also it is the contention of the plaintiff that defendants have enclosed the property and taken possession of 6.5 guntas covered in the sale deed of himself and his wife. But no such land in existence to the extent of 8 guntas of land in survey number 263 as claimed by the plaintiff. And plaintiff has failed to prove his exclusive possession over the 8 guntas of land. And hence, conclusion of the trial court with regard to the possession as well interference is not an erroneous finding. And also appellate court taken note of the principles laid down in the judgment of Anantula Sudhakar case. When the relief of possession has not been claimed by the plaintiff to the suit, and hence the trial court is justified in holding that plaintiff suit in the present form is not maintainable, and confirm the judgment of the trial court. Being agreed by the said finding, the present appeal is filed, and it is the main contention that first appellate court committed an error in justifying, committed an error in dismissing the appeal, in confirming the judgment of the trial court. And both the courts committed an error in holding that plaintiff is not in possession, even though sale deed dated 24/2/1992 is not disputed by the defendant respondent. And when the sale deed discloses the ownership, ought not to have dismissed the suit for declaration and possession. And hence this court has to admit and frame substantive question of law. Having heard the appellant counsel and also the pleading of the plaintiff before the trial court and also the contention of the defendant, and considering the issues involved between the parties and both oral and documentary evidence, And though plaintiff claims the declaration and possession in respect of 8 guntas of land is concerned, and the court commissioner who has been examined second time, or who has been appointed as commissioner second time, has been examined as CW2, and his evidence is also very clear that the extent of land only 22 and a half guntas, not 29 guntas as mentioned in the revenue entries. And also the same was taken note of in paragraph number 15, that vendor cannot convey more than what he was in possession. And hence, even there was a sale deed, and when there was a shortfall of possession to the extent of land which was conveyed, and when there was no possession and existence of the property, and rightly trial court dismissed the suit in paragraph number 15, making an observation. And appellate court also, on reassessing both oral and documentary evidence, particularly taking note of evidence of CW2, as well as the sketch exhibit C5 and report as per exhibit C6, clearly indicate that vendor of the plaintiff was in possession of only 22 and a half guntas. And hence, in paragraph number 34 and 35 and 36 in detail discussed. And so also taken note of principles laid on the judgment of Anantala Sudhakar case, and comes to the conclusion that when the property was not in existence and also not in possession, question of granting the relief of declaration and permanent injunction doesn't arise, and taken note of both question of fact and question of law. And when such being the case, and also when there is no any perversity in the finding of both the courts, I do not find any ground to invoke section 100 of CPC, and hence there is no any merit in the second appeal. However, the claim of the appellant plaintiff is that he may be given liberty to file a fresh suit for seeking the relief, identifying the property which is in his possession after getting the survey report, and seek an appropriate relief. And hence the said liberty is given as sought.
ಅಲ್ಲಿ
With this observation, second appeal is disposed of.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫಸ್ಟ್ ಅಪ್ಡೇಟ್ ಕೊಟ್ಟು ಎರಡೂ 263 ಅಂತ ಹೇಳ್ಬಿಡ್ತಾರೆ ಸರ್ವೆ ನಂಬರ್. ಆಕ್ಚುಲಿ ಸೂಟ್ ಎಲ್ಲ ನಡೆಯೋದು 262/3 ಗೆ. ಅದೊಂದು ಅದು 262/3 ಅದು ಆಕ್ಚುಲಿ
262/3,
ಅದು
ಬಟ್ ನಾಟ್ 263 ನಾ.
ಅದೊಂದು ಅದೊಂದು
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೂ 260
ಎಲ್ಲ ಕಡೆನೂ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಕಡೆನೂ
262/3 ನೇನಾ.
ಅದಾದ್ಮೇಲೆ ಸರ್ವೇನೂ ಅದೇ ಹೇಳ್ತಾರೆ. ಬಟ್ ಇದ್ರ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಕಡೆ
ಸರ್ವೇಯರ್ ಸರ್ವೆ ಮಾಡಿದಾಗ ಎಷ್ಟು ಮಾಡೋದು ಕಮಿಷನ್?
262/3 ಮತ್ತೆ 1 BHC ಅಂತ ಕೊಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ
ಅವರು.
ಇಲ್ಲಿ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಮೇಲ್ಗಡೆ ಹೇಳ್ಬಿಡಿ. The council would submit that the actual survey number is 262/3 and not 263, but there was an error while referring the same by the trial court and also the appellate court, and hence the same is treated as 162/3 as mentioned in the sale deed.
Please.
35 SP Prakash.
Records ಬಂದಿದೆ.
Is suit for injunction, divergent finding. The present appeal is by the defendant. Trial court dismissed this suit, holding that they failed to prove the possession as well as the ownership. However, the first appellate court, relying upon the two photographs, reversed and decreed the suit. And even the trial court has observed in para 60, in page number 65, the brother of the present plaintiff had also filed similar suit in respect of the suit property. He failed. Married. There are 60 in page number 65. The present case title and position of the property is west to the forest department, and the said forest department is in digital position of the plain schedule property. However, the plaintiff has failed to prove her better title over the plain schedule property by adducing cogent evidence. D7 RDC pertaining to the survey number 49 make it very clear that the plain schedule property comes within the state forest. D8 is the postal letter dated so and so, wherein it is clearly disclosed that they refuse to grant plain schedule property situated in 7 number 49 in favor of any person in the said village, because the said property comes within the state forest and therefore they have no power to allot the same. Exhibit D6, this is the relevant. Is the judgment passed in OS number 145 by 2016 dated so and said suit filed by brother of Mr. Viresh Achar, who is the present plaintiff, that is N. Kumar, against one Timmappa, pertaining to plain schedule property, and therein also has sought for permanent prohibitory injunction claiming the plain schedule property is a joint family property and he is the owner of the same by virtue of Panchayat Parikatu. The defendant therein also taken similar contention and denied the case of the brother of Viresh Achar, contending that the state property comes within state forest. Therefore, the Honorable Judge and the General Court.
ಆಯ್ತು, ಈಗ ರಿಲೀಫ್ ಗ್ರಾಂಟ್ ಮಾಡುವಾಗ ಏನ್ ರಿಲೈ ಮಾಡಿದ್ದಾರೆ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಎಕ್ಸಿಬಿಟ್ P4
8 and 9
ಅಲ್ಲ, ಎಕ್ಸಿಬಿಟ್ P4 ಏನು?
ಎಕ್ಸಿಬಿಟ್ D4
ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು, ರಿವರ್ಸ್ ಮಾಡಿದ್ರು, ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರು, ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ರಿಲೈ ಮಾಡಿದ್ರು ಅಂತ ಕೇಳಿದೆ.
Para 33 my lord. Exhibit P8 and 9.
33.
Ink page number 43. Para 33.
Now the very photographs produced by the plaintiff which exhibit P8 and 9 itself depicts the damage caused to the portion of the coconut leaves roof of the plaintiff. Further, learned counsel for the defendant by cross-examination, PW1 has posed question. Who gave interference with was stated on that on it is defendant who interfered with the peaceful position of the plaintiff.
Actually, this is survey number 49 in entirety. It is a forest land matter. Endorsement also given by the forest department.
So,
my lords, para 29 may be seen, my lords.
29 of first appellate court.
Of the first appellate court, my lords. There, my lords, on the 17th page, my lords, next page, the defendant, fourth line, the defendant has not produced a single document to show that the suit scheduled property and the property mentioned in the written statement are one and the same. When admittedly plaintiff is in possession of property which comes to forest department, then the best course left open with the forest department to take possession of the alleged enclosed portion through legal process and not otherwise. It is settled position of law that a person in possession can be evicted only by due process of law. Hence, even a rightful owner cannot eject him by force. They claim a different property, my lords, not the property which is the plain schedule, my lords. That is the finding given by the first appellate court.
So, how did the appellant counsel and also the counsel appearing for the respondent? And on perusal of the record, there are divergent finding. At the first instance, suit was dismissed and the same was reversed by the first appellate court. And hence, there is a divergent finding. Matter requires reconsideration. Admit. The following substantive question of law arises for the consideration of the second appeal. Whether the first appellate court committed an error in reversing the finding of the trial court in coming to the conclusion that plaintiff has established the possession and if the property belongs to the forest department and the said department has to take the possession of the alleged encroached portion through due process of law. That is the only subject.
Yes.
Substantive question of law. Records are received. No need of filing of paper book.
Book may be dismissed.
Post the matter for final hearing on 12/12.
36.
Mohan Chandra. Records ಬಂದಿದೆಯಲ್ಲ ತೋಡಿ. Having perused the records, there is a divergent finding of dismissal of suit by the trial court and in appellate court partly allowed, and though confirmed the relief of declaration dismissing the same but granted permanent injunction, and the same is challenged before this court by the defendant. Having perused the divergent finding, matters requires reconsideration. Admit following substantive question of law arises for the consideration. Whether the first appellate court is justified in partly allowing the appeal and granting the relief of permanent injunction on the basis of evidence of PW1, relying upon oral evidence as against the documentary evidence. And he said reversal amounts to perversity. Records are received. List the matter. Filing of paper book is dispensed. List the matter for final hearing on 12/12.
37. SR Shri present.
Not plaintiff's second appeal. Not suit for declaration and injunction. Declaration and possession, Lord. Suit is dismissed, so also the appeal. But OS 41 of 2004 was filed on 24/5/2004. Lord, suit is dismissed on 3/8/2017. RA filed on 12/9/2017. Disposed on 18/4/2024. Lord, A scheduled property, Lord, the plaintiff's father purchased by way of sale by a sale deed dated 25/7/1977. The defendants, Lord, encroached the property to an extent of 11 cents, that is Schedule B. The survey number is 241/8. Lord, 1 acre 90 guntas, 90 cents. That was purchased under the sale deed dated 25/7/1977. Lord, another encroacher was there who encroached and OS 57/2000 was filed against the another encroacher. Lord, RA that is also dismissed. RA 43 of 2010 was filed. And as against that, my Lord, RSA 958 of 2015 is filed. Lord, that is admitted by this honorable court. The same grounds, my Lord, this is filed. That is 30 guntas that was encroached. This is 11 guntas in respect of same survey number. The substantial question that is framed in the other RSA is, in the light of admission by the defendant that the plaintiff had purchased land bearing 241/8, whether the trial court and appellate court could have refused the decree of declaration. But same substantial question would arise in this, because the defendant, Lord, he admits the sale deed, my sale deed. ಒಂದು ನಿಮಿಷ ಇದೆ ನೋಡಿ.
Go to para 25, page 25. ಇದು paragraph number 25 of the trial court order.
Please. From the recitals of Exhibit P1, D2, it is very clear that the land purchased by plaintiff is situated in a different place than now shown in the plaint and Exhibit P3 and 4. It is also important to note that the plaintiff had made attempts to rectify the description found in Exhibit P1. disregard PW1 in exhibit D3 as admitted. The ಜಮೀನಿನ ಚೆಕ್ಕುಬಂದಿ ಸರಿ ಇಲ್ಲ, ಅದನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಬೇಕೆಂದು ದಾವಾ ಹಾಕಿದ್ದೆ. ಅದು ವಿರಾಜಪೇಟೆಯ ಅಪರ ಸಿವಿಲ್ ಜಡ್ಜ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಕಿದ್ದೆ. ಅದು ವಜಾ ಆಗಿದೆ. ಅದರ ವಿರುದ್ಧ ಅಪೀಲ್ ಹಾಕಿದ್ದೇನೆ. My lord, please come to the admission in the written statement, please. Admission in the written statement.
Records ಇದೆಯಾ madam?
Please come to page 65, my lord.
ನೀವು ಈ ಪ್ಯಾರಾ ಓದೋದಿಲ್ಲ ಪೂರ್ತಿ, ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ
ಓದ್ ಯಾಕೆ ಅಲ್ಲಿಂದ ಬೇರೆ ಕಡೆ ಹೋಗ್ತೀರಿ?
ಅಲ್ಲ
3 ಸೆಂಟೆನ್ಸ್ ಓದ್ಬಿಟ್ಟು ಮುಂದೆ
ಅಲ್ಲ, ಇದಕ್ಕೂ ಅದಕ್ಕೂ ಕಾಂಟ್ರರಿ ಇದೆ ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
ನೋಡಿ ಮುಂದೆ ಹೋಗಿ.
ಆಯ್ತು.
ಇನ್ ದಿಸ್ ರಿಗಾರ್ಡ್ PW1 ಅಡ್ಮಿಟ್ ಮಾಡಿಲ್ಲ, ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮಾಡಿ ಅಟೆಂಡ್ ಮಾಡಿದೆ, ಅದಾಗ್ಲಿಲ್ಲ, ಸೂಟ್ ಇದೆ ಅಂತ ಆಯ್ತು.
Further exhibit DA38 which is the
Therefore,
judgment.
the boundaries mentioned in exhibit D1 remains as it is. ಹೌದಾ? Moreover, it is not the case of plaintiff that even though boundaries are shown erroneously, he has purchased land as shown in exhibit P3 and P4. The admissions of plaintiff both in the present suit and in OS number 57 of 2000, which is marked at exhibit D3.
OS 57 the RSA pending ಇದೆ.
Plaintiff has purchased the land as shown in exhibit P1, which was in possession of his vendors as shown in exhibit D2.
Lord, the very same OS 57 of 2000, insofar as that Lord RA 43 of 10 was filed, as against which RSA 958 of 15 is filed. That is substantial question is also framed in connected matter. Page 65 ಗೆ ಬನ್ನಿ ದಯವಿಟ್ಟು. ಪೇಜ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 3, page 65. Page 65 paragraph 3.
ಅದೆಲ್ಲ ಪ್ಲೀಡಿಂಗ್ಸ್ ರೀ.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ, ಪ್ಲೀಡಿಂಗ್ಸ್ ಏನೆ. The defendants have filed the written statement and admitted the plaintiff has purchased survey number 241/8. Once they say it is purchased, there is no question of discrepancy of schedule. They admit the
ಬೌಂಡ್ರೀಸ್ ಬೇರೆ ಇದೆಯಲ್ಲ,
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ.
ಅವ್ರು ಹೇಳೋದಲ್ಲ, ರೆಕಾರ್ಡ್ ನೇ ಕಂಪೇರ್ ಮಾಡಿರೋದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು. ಇರೋ ಬೌಂಡ್ರಿನೇ ಬೇರೆ, ನೀವು ಕೇಳ್ತಿರೋ ರಿಲೀಫೇ ಒಂದ್ ಪ್ರಾಪರ್ಟಿಗೆ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗುತ್ತೆ?
ಅವರ ವೆಂಡರ್ ಮೇಲೆನೆ ನಾನು ಡಿಗ್ರಿ ಕೂಡ ತಗೊಂಡಿದ್ದೀನಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಯುವರ್ ಆನರ್, ಮೈ ಲಾರ್ಡ್, ಮೈ ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 32 ಫಾರ್ ಎ ಮೊಮೆಂಟ್.
Page 32 of the first appellate court order.
First appellate court order. ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಫಸ್ಟ್ ಲೈನ್ ಇಂದಾನೆ 1A Mohammed Kutti unlawfully trespassed into the southern side of Schedule A property, removed the fence, coffee plants and encroached 30 cents of land in Schedule A property. The plaintiff resisted the encroachment. However, he could not prevent him. And on 16/4/82, the plaintiff filed a suit in OS 101 of 1982 against Mohammed Kutti for the relief of declaration and possession. The said suit was decreed on 18/12/1982. Based on the decree passed in OS 101/1982, the plaintiff filed execution petition number 19/1983 and obtained possession of said 30 cents of land in survey number 241/8 from Mohammed Kutti. Thereafter, the plaintiff has been in exclusive possession and enjoyment of 30 cents of land and he cultivated the coffee. My lord, all these things, my lord, show that there is no discrepancy in so far as schedule. The very same survey number. Now this is a different extent. Out of 1 acre, 90 cents. Next page, center, page number 33, central birth. Fourth line, I think fourth line. In the last week of September 2001, the defendants have unlawfully trespassed into the northern side of Shoot A schedule property, removed the fence and encroached 11 cents of land in the northern side of A schedule property. This is B schedule property. Now what the court says is the commissioner is appointed in the other suit, that is OS 57 of 2000, and this is not binding on the present defendant. ಅಷ್ಟೇ ಅವ್ರು ಹೇಳೋದು. Issue number 3 is the defendant seeks adverse possession. Page number 27, issue number 3.
Commissioner report ಏನು?
Commissioner report encroachment ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Commissioner report mark ಮಾಡಿಸಿದ್ರಾ?
ಮಾರ್ಕ್ ಮಾಡಿದೆ.
ಏನದು?
One second. P3 and P4.
ಏನದು? Commissioner report?
P3 and P4.
P3 and mark ಆಗುತ್ತೆ. Commissioner examine ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, ಅದು ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿರೋದು. ಆ ಬೇರೆ ಕೇಸ್ ಅಲ್ಲಿ OS 57
ಕೇಸ್
ಅದನ್ನ ಇದಕ್ಕೆ this is not binding ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ says.
ಮತ್ತೆ ಅದನ್ನ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಈ ಕೇಸಲ್ಲಿ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಅಪಾಯಿಂಟ್ ಆಗಿಲ್ಲ. ಪೇಜ್ 81 ಗೆ ಬನ್ನಿ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು. ಪೇಜ್ 81
ಎಲ್ಲಿ ಬಂದ್ರು ಅಷ್ಟೇ.
ಅಲ್ಲ, in view of principle laid down in the above said ruling, exhibit P4 can be considered as a piece of evidence on behalf of plaintiff. Paragraph 20, page 81. Whether it is binding on the defendant who is not a party in OS 57 of 2000, in whose absence the commissioner, the sketch was prepared is a different matter. Now, please come to page 32, para 13. ಇವರ ವೆಂಡರ್ಸ್ ಮೇಲೆ ಫೈಲ್ ಮಾಡಿರೋದು, ಇವರ ಪ್ರಿಡಿಸಿಸರ್ಸ್ ಮೇಲೆ ಅದನ್ನ ಫೈಲ್ ಮಾಡಿರೋದು ಆ ಸೂಟು OS.
ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ ನೋಡಿ, ಇವನ್ ಪ್ಯಾರಾ 21 ಅಲ್ಲೂ. In this background, whether plaintiff has acquired the title and possession over the plain A scheduled property as described in the plain A scheduled property is crucial aspect. If the plaintiff has acquired the title and possession as described in the plain A scheduled property, then only the plaintiff can be declared as owner of plain A scheduled property, and it can be held that defendants have encroached the land which was in possession of plaintiff based upon its title.
This is totally contrary to the written
document
statement
produced by the plaintiff, which is the basis for the title of plaintiff, assumes importance. The description of the property purchased under Exhibit P1 is crucial to locate its situation. According to Exhibit P1, the property purchased by plaintiff is as follows: east by Virajpete Tallicherry Public Road, west by Baputi's land, north by the property of one Muthu, south by Village Road of survey number 241. That means east and south ಎರಡು ಕಡೆ ರೋಡ್ ಇದೆ, ಎರಡು ಕಡೆ ಮಾತ್ರ ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ಸ್ ಇದೆ. If this description of property in Exhibit P1 is appreciated by comparing with Exhibit P3, then it is very clear that the land purchased by the plaintiff is not in existence in the place as shown in Exhibit P3. On the other hand, the land purchased by the plaintiff exists towards north, survey number 241/9, abutting to Virajpet Tallicherry Road, or in the place where survey number 241 bar itself exists as shown in Exhibit P3. Exhibit P1 is the sale deed dated 25/7/1979 under which plaintiff purchased land from its owner, Matthew and Annamma Matthew. In this regard, it is pertinent to note that PW1 in the cross examination has admitted that Matthew ಹಾಗೂ ಅನ್ನಮ್ಮನವರ ಕ್ರಯಪತ್ರ ನೋಡಿದ್ದೇನೆ, ಅದು ನಿಶಾನೆ D2 ಎಂದು. ನನ್ನ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಎರಡು ಬೌಂಡ್ರಿಗಳು ಸರಿ ಇಲ್ಲ, ಬಾಕಿ ಎಲ್ಲ ಸರಿ ಇದೆ. These are the admission. ನನಗೆ ಕೊಟ್ಟ ಜಮೀನು ಮ್ಯಾಥ್ಯೂ ಮತ್ತು ಅನ್ನಮ್ಮನವರ ಸ್ವಾಧೀನ ಇತ್ತು. Therefore, even though PW2 state that two boundaries in the sale deeds are not correct, it is not pleaded in the plaint. Further, he has stated that the land purchased by plaintiff was in the possession of his vendors. The plaintiff, for the best reason known to him, has not produced the title deed of his vendors. However, the defendant has produced a certified copy of the sale deed of vendor of plaintiff, which is marked as Exhibit D2. Exhibit D2 is the certified copy of the sale deed executed by Koruppu, so and so. The boundaries of property purchased by vendors of plaintiff is clearly described in the schedule sale deed which reads as follows. Ilu kuda
What happens is, over a period of time, it was purchased in the year 1977.
Haudu.
There will be some discrepancies because, my lord, there are change of hands from one person to one person. For a moment, please come to page 71, paragraph 11. Paragraph 11, page 71. Just take 1 minute. Even though the defendants have admitted the plaintiff has purchased so and so from Matthew and Annama, my sale deed is not at all disputed. One side, my lord, they admit my sale deed. Other side, my lord, they say we are in adverse possession. It goes contrary. My substantial question is also same, my lord. They claim adverse possession. If once they claim adverse possession, they must admit my ownership. They admit my ownership.
ಅದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ರಿ, ಅದಕ್ಕೂ ಅವ್ರಿಗೂ ರಿಲೀಫ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ, ಕರೆಕ್ಟ್. ಅವ್ರ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅವ್ರ ಅಡ್ವರ್ಸ್ ಪೊಸೆಷನ್ ಅಂತ.
ಪ್ಲೀಡಿಂಗ್ ಎಲ್ಲ ಹೇಳ್ತಾರೆ, ಬಟ್ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಎ ಪ್ರೂಫ್.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಾನು ಸೇಲ್ ಡೀಡ್ ಒಪ್ಕೊಳ್ತಾರೆ. ಅಲ್ಲಿ ಟೈಟಲ್ ಒಪ್ಕೊಂಡ್ಮೇಲೆ ಡಿಕ್ಲರೇಷನ್ ಕೊಡ್ಬೇಕಾಗತ್ತ ಅವರು. ಅವ್ರೇನು ಬೇರೆ ಎಲ್ಲ ಏನು ಡಿನೈ ಮಾಡ, ಟೈಟಲ್ ಅಂದ್ರೆ ಅವ್ರೇನು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್, ಶೆಡ್ಯೂಲ್ ತಪ್ಪು ಅಂತ ಎಲ್ಲೂ ಹೇಳಲ್ಲ.
ನಿಮ್ದ ಅಡ್ಮಿಷನ್, ನನ್ನ ಜಾಗದಲ್ಲಿ ಮನೆ ಕಟ್ಟಿ ಬಾಬು
ಓರಲ್ ಅಡ್ಮಿಷನ್ ಐ ಆಮ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್.
ಅಬೂಬಕರ್ ವಾಸ
ಅಲ್ಲ,
ಮಾಡ್ತಿದ್ದಾನೆ.
ಓರಲ್ ಅಡ್ಮಿಷನ್ ಇದೆ,
ಬಾಬು
ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ಪೀಕ್ಸ್.
ನಾನು ನೇಮಿಸಿ ಕೊಟ್ಟಿದ್ದೆ, ಈ ದಾವೆಗಳ ಪ್ರತಿವಾದಿಗಳ ತಂದೆ ಸೋನ್ಸೋ ನ್ಯಾಯವಾಗಿ ಅಕಲದ ನೋಟಿಸ್ ಕಳಿಸಿದ ಡಿಸಾರ ಎಂದು ಕುರಿಸಲಾಯ್ತು. ದಟ್ ಯು ಆರ್ ನಾಟ್ ಇನ್ ಪೊಸಿಷನ್ ಆಲ್ಸೋ.
ಅಲ್ಲ, ನಾನ್ ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತಾನೆ ನಾನು ಪೊಸೆಷನ್ ಸೂಟ್ ಹಾಕಿದ್ದೀನಿ. ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಪೊಸೆಷನ್ ಸೂಟ್.
ಬಟ್ ನಿಮ್ ಟೈಟ್ಲೇ ಸರಿ ಇಲ್ಮೇಲೆ ಏನ್ ಮಾಡೋದು? ಟೈಟ್ಲ್ ಅಲ್ಲಿ ಇರೋದೇ ಒಂದು ಬೌಂಡ್ರಿ, ನೀವು ಹಾಕಿರೋ ಒಂದು.
ದಯವಿಟ್ಟು ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ನೋಡಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
ಎಲ್ಲ ನೋಡಾಯ್ತು.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ನೋಡಿ, ಫುಲ್ ಗ್ರೂಪ್ ಪೂರ್ತಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ದಿ ಡಿಫಿಕಲ್ಟಿ.
ನಿಮ್ ಸೇಲ್ ಡೀಡ್ಗುನು ನಿಮ್ ವೆಂಡರ್ ಸೇಲ್ ಡೀಡ್ಗುನು ತಾಳೆನೇ ಆಗಲ್ವಲ್ರಿ? That's what the trial court comes to a conclusion that same is not tallies anta. You also made an attempt to rectify the same, but you are unsuccessful. You are unsuccessful.
Unfortunately, my lord, all of them, they have encroached the portion.
Trial court in detail discussed the material and record.
Respondents, my lord, the entire community, my lord, they have encroached my land. Other than these two RSS, my lord, 3 more RSS were filed. Notices are already ordered in that.
Notice overly ನೋಡಿ ಏನಿಲ್ಲ. Trial court in depth considered your oral evidence, documentary evidence, everything.
Please
issue notice.
Right.
And call for records already ಇದೆಲ್ಲ, issue notice.
38.
ಸೇಮ್ ಹೋಗಿ ಬರ್ಲಿ. ಯಾವುದು 61 ಎಂ ಮಹೇಶ್ವರಪ್ಪ. ಡಿಲೇ 911 days. ಹೇಳಿ ಫಸ್ಟ್ ಡಿಲೇಗೆ.
I am not a party to the proceedings in OS number.
OSL not a party na?
I am not a party in OS number.
RNally?
RNally ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ಲ, ಆಬ್ಸೆಂಟ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ನಾಟ್ ಸರ್ವ್ ಆಗದಲ್ಲ ಆಬ್ಸೆಂಟ್ ಅಂತ ಹೆಂಗ್ರಿ ತೋರ್ಸಕ್ಕಾಗುತ್ತೆ?
ಆತರ
Have you produced any document before the court to show that
no ಇಲ್ಲ,
notice has not been served anta?
Information only at the time of execution proceedings. More why they have done this is kindly page 80, my lord, family tree.
G tree ಇದೆಯಾ?
G tree 80. In the G tree, my name has not been shown.
ಪ್ರಾಪರ್ಟಿ ಯಾರು? ತಿಮ್ಮಪ್ಪ. ನೀವು ಯಾರಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಇದ್ರಲ್ಲಿ?
ತಿಮ್ಮಪ್ಪನ ಮಗ.
ತಿಮ್ಮಪ್ಪನ ಮಗನ?
ಮಗ. ನಿಮ್ಮ ಹೆಸರು? My name is not shown. My name is HTB Girish. In the family tree they have not shown my name, my lord.
ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲ ನಿಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಲಿಲ್ವಾ?
ಮಾಡಲಿಲ್ಲ.
RA ನಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ, ಆಬ್ಸೆಂಟ್ ಅಂತ ತೋರಿಸ್ತಾರೆ.
ನಿಮ್ಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ದಾಖಲೆ ಕೊಡಿ ನೋಡೋಣ. ದೆನ್ ವಿಲ್ ಕನ್ಸಿಡರ್ ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ. ಆರ್ಯದು ಏನ್ ಹೇಳಿದ್ದಾರೆ? ನಿಮ್ ಸರ್ವಿಸ್ ಆಗಿರೋದು ಸಮನ್ಸು ಬಂದಿರುತ್ತಲ್ಲ, ಅದ್ರ ಕಾಪಿ ತಗೊಬನ್ನಿ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್?
ಇಲ್ಲ, ಇದು ನೋಟಿಸ್ ಆಗಿದೆ.
ಇಲ್ಲ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಡಿ. ರೆಕಾರ್ಡ್ ಬೇಕಾಗಲ್ಲ, ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಮಾಡ್ತೀನಿ, 2 weeks ಟೈಮ್
ತಗೊಳ್ಳಿ. Appellant counsel seeks time to produce the entire certified copy of order sheet in RA in which he was placed as ex parte, and also produce copy of the notice issued against him. This matter on 12/12
15th.
15/12. 39 already urgent. 40 Nilakantaya.
Apparent for respondent.
I'll respondent in this case.
Suit for partition decreed as crime.
ಇಲ್ಲ, ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆನೆ.
ನಾನು ಕೂಡ ರೆಸ್ಪಾಂಡೆಂಟ್.
ನೀವು ಈ ಕಡೆ ಬರ್ಬೇಕು.
ನೀವೇ ಕಲ್ಲೋಗಿ ನಿಂತ್ಕೊಂಡು ನೀವು ಈ ಕಡೆಗೆ ಬನ್ನಿ.
ಈ ಕಡೆ ಬರ್ಬೇಕು, ಕನ್ಫ್ಯೂಸ್ ಆಗುತ್ತೆ.
ಬಂದಿಲ್ಲ. ಅಪಲೆಂಟ್ ನೀಲಕಂಠಯ್ಯ, ಪಸೋರ್.
41.
ಮಂಜೇಗೌಡ DS.
The divergent findings, my lord.
ಏನ್ ಡೈವರ್ಜೆಂಟ್ ಮಾಡಿಫೈ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ.
The trial court, they ordered for the notional share. The appellate court ordered for the equal share.
Correct.
My lord, the partition was took place in the year 1991. That is admitted by the plaintiff sister. In his cross-examination.
Plaintiff has not admitted.
Plaintiff is admitted in his cross-examination, my lord.
Plaintiff admit ಮಾಡಿದಾರಾ?
Please, plaintiff is admitted.
ಯಾರ ಮಧ್ಯದಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಯ್ತು? Whether she was a party?
She was not party in that partition suit.
And then
my lord, in fact, the suit schedule property.
Partition suit?
A suit for partition filed by the sister.
Earlier. Whether plaintiff was made as party?
The plaintiff was not a party in the partition, in this partition deed.
ಮತ್ತೆ partition deed ಅಂತೀರಿ, partition suit ಅಂತೀರಿ.
The suit for partition filed by the sisters.
Go to pleadings. Your issues ಹೋಗ್ಬಿಡಿ. Whether the plaintiff proves that all the suit properties are joint firm properties of plaintiff and defendant.
Please.
Whether defendant number 1 and 2 prove that item number 1 is the self-acquired property of Papegoda.
Please.
Item number 2 property.
Item number 2 is house property, my lord.
Self-acquired property of the defendant number 2.
The plaintiff
to prove that during his lifetime Papegoda himself effected partition in item number 1 of property and allotted the same to his 2 sons.
My lord, the plaintiff was married in the year 1978. The suit schedule property is acquired by her father in the year 1980 after her marriage, and the partition between her father and the 2 children, 2 sons, in the year 1991. 1991. That partition, the partition between the father and the sons, it's admitted in this cross-examination. So in the circumstances, my lord, the trial court is ordered for the notional share. But in the appellate court,
notional share in the share of the father.
Please, my lord. So in the appellate court,
ಎಲ್ಲಿದೆ admission?
My lord, kindly see the page number 64.
ನೀವೇನ್ ದಾಖಲೆ ಹಾಕಿದ್ರಿ earlier partition ಬಗ್ಗೆ?
You produce the partition deed. That's marked as exhibit P2. Sir, D2, my lord. D2.
That is not a registered document.
It's not. It was not registered document.
Whether the same can be reliable, whether it is admissible.
My lord, based on the partition, that partition deed, the RTC, MR, and other revenue document, it is mutated in favor in the name of the defendant's brothers, based on the partition.
ಎಲ್ಲಿದೆ MR?
The RTC are produced. My lord, kindly see
RTC ಆಯ್ತು, MR ಹಾಕಿದಿರಾ?
MR file ಮಾಡಿಲ್ಲ. So we produce the RTC.
MR ಬೇಕಲ್ಲ? Based on ಪಾಲು ಪರಿಕತ್ ಮ್ಯುಟೇಷನ್ ಆಯ್ತು ಅನ್ನೋದಕ್ಕೆ ಎಂಟ್ರಿ ಬೇಕಲ್ಲ? ಪಾರ್ಟಿಷನ್ ಆಗಿತ್ತು ಅಂತ. RTC ನಲ್ಲಿ ಏನಿದೆ? MR ಎಂಟ್ರಿ
RTC ನಲ್ಲಿ my lord is stated.
MR ನಂಬರ್ ಇದೆಯಾ?
MR number, it's mentioned MR number in the MR number mention ಆಗಿದೆ RTC ನಲ್ಲಿ.
ಏನಂತ ಕೊಡಿ. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
My lord, kindly see the page number 28. Para 30. First appellate court order ಅಲ್ಲಿ
Para 30.
para 30 ನಲ್ಲಿ ಅದು ಮಿಡ್ಲ್ ಅಲ್ಲಿ 1 2 3 4
ಹೇಳಿ.
In addition to it, the plaintiff has produced RTC of survey number 65 bar P2 as per exhibit P3. As per this document, Kata of 30 guntas of land was mutated in the name of the defendant number 2 based on order in MR 2793/94 and based on the partition. But the exhibit P1 and P2 does not disclose the
exhibit P1 and exhibit P2 does not disclose the factum of partition dated 15/6/1991.
Please, Mila. But she admitted the partition between the father and his brothers. Kindly see the page number 64, my lord, in the para 22. Though the defendant has proved that during the lifetime of the Papegowda is the father of the plaintiff and defendants, the suit schedule item number 1 property was partitioned between him and his sons Bettegowda and the third defendant through exhibit D2. It is an unregistered document and under section 6 of the Hindu Succession Act, it will not affect the right of the share of the plaintiff in the suit schedule property. In this, under this circumstances, the plaintiff is entitled for partition and separate possession of her 1/9 share in the suit schedule property by Mitts and Bondsman.
Para 40 ಹೋಗಿ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ನಿಮ್ಮ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಡಿಸ್ಕಷನ್ ಅನ್ನ.
When a suggestion to the effect that for the development of family, the government had confirmed occupancy right is not admittedly by defendant number 2. It is the evidence of defendant number 2 that DW2 that they have not given any property to the plaintiff. On the other hand, they have given money to her. This evidence of DW2 is an improvement. This is because he is in written statement or in chief examination, he didn't say that towards share of the plaintiff, they have given money to her. Thus, the evidence of DW2 that they have given money towards the share of the plaintiff is an improvement.
Improvement anta.
My lord, in so far as the notional share, there are no objection from the defendant side. Because, my lord, ಅಲ್ಲಿ 1 ಎಕರೆ 12 ಕುಂಟೆ 1 ಎಕರೆ 12 ಕುಂಟೆ ಅಷ್ಟೇನೆ ಬಂದಿರೋದು ಸ್ವಾಮಿ ಡಿಫೆಂಡೆಂಟ್ಸ್ಗೆ. She married in the year 1978. That property is allotted to his father in the year 1980. ಮದುವೆಗೆ ಎಲ್ಲ ಖರ್ಚು ಮಾಡಿ ಮದುವೆ ಮಾಡಿ ಇಬ್ರು ಗಂಡು ಮಕ್ಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವ್ರು 1 ಎಕರೆ 12 ಕುಂಟೆ 1 ಎಕರೆ 12 ಕುಂಟೆ ಬರ್ತಾ ಇದೆ ಅಷ್ಟೇ. RTC ಮತ್ತೆ ಪಾಣಿ MR ಎಲ್ಲವೂ ಸಹ after the partition in the year 1990, it's mutated in the name of the defendant's brothers and they are in possession. ಈ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ 1/9 ಶೇರ್ ಆರ್ಡರ್ ಆದಮೇಲೆ ಅವರು 1/9 ಶೇರ್ ತಗೊಳ್ಳೋದೇನಿದೆ, ನನ್ನ ಮಗಳನ್ನ ಮದುವೆ ಮಾಡಿಬಿಡಿ ನೀವೇ ಅಂತ ಹೇಳಾಗಿ ಅವರು ಮದುವೆ ಮಾಡಿದ್ಮೇಲೆ ಈ ಅಮ್ಮ ಒಪ್ಕೊಂಡಿದ್ದು. ಆಮೇಲೆ ಇವರು ಡ್ಯೂರಿಂಗ್ ದಿ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಎನ್ ಅಪೀಲ್ ದ ಪ್ಲಾಂಟಿಫ್ ಡೈಡ್ ಇಂಟರ್ಸ್ಟೇಟ್ ಲಿವಿಂಗ್ ಬಿಹೈಂಡ್ ಇಲ್ ಹಾಸ್ಪಿಟಲ್. para 27, my lord, page number.
First appellate court para 53 go hogi.
My lord, page number 26, para 27, my lord.
Para first 53 odri. Appeal allu kuda 53 and 54.
In view of
while
the
confirming the judgment, in D2 does not disclose us any parties have acted upon in terms of exhibit D2. D2 is alleged partition between the parties. That is also not a registered document. Panchayat Palpatti.
Please.
Mutation illa yenilla.
My lord, para 27.
53 odri indra nee 27 ge hogti.
Thus on reappreciation of evidence.
Thus on reappreciation of evidence on record, this court is of the opinion that plaintiff has proved the satisfaction of the court that social properties are
or joint family properties and they are not subject to partition during the lifetime of Papegowda. In this view of the matter, in given the circumstances of the case, the plaintiff is entitled for 1/3 share over the suit schedule property.
Next parana odi.
As has been observed here in above, during the pendency of the suit, the defendant one Ningamma died further during the pendency of the appeal. The plaintiff Lakshmamma also died, and her legal representative was brought on record since the Ningamma has died. Concept of notional partition does not arise at all. In addition to it, since because the partition as per exhibit D2 is not acted upon, the suit schedule properties has remained as a joint family properties in the hand of 3 children of Papegowda. Therefore, both by way of section 6A of the A and section 8 of the Hindu Succession Act, the plaintiff Lakshmamma is entitled for 1/3 share over the suit schedule property. Yes, the findings of the trial court that the plaintiff are entitled for notional share is not sustainable. In view of the same, judgment and decree of the trial court calls for interference. Accordingly, point number is answered in the negative and the point number 2 is in affirmative. My lord, based on the partition, the trial court is ordered that based on the partition, the RTC and Thane mutated in the name of the defendants.
Mutation ಎಲ್ರಿ ಹಾಕಿದೀರ ಅಂದ್ರೆ ಎಲ್ಲೂ ಇಲ್ಲ, ಅದು ಬರೀ RTC ಇಟ್ಕೊಂಡು ಕೂತಿದ್ರಿ ನೀವು. ಹೇಳ್ದ ನಾಟ್ ಆಕ್ಟೆಡ್ ಅಪಾನ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ನೀವೇನ್ ತೋರ್ಸೋದೇ ಇಲ್ಲ. ಪಾಲಪಟ್ಟಿ ಆದ್ಮೇಲೆ ಮುಟೇಶನ್ ಬೇಕಲ್ಲ, ಎಲ್ಲಿದೆ?
My lord, I filed the mutation along with the necessary application.
ಎಲ್ಲಿದೆ? ಎಲ್ಲೂ ಹಾಕಿಲ್ಲ, ಇಲ್ಲೂ ಹಾಕಿಲ್ಲ, ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲೂ ಹಾಕಿಲ್ಲ.
I will file necessary
application. The appellant counsel in length. This matter is listed for admission. This appeal is filed against the concurrent finding. The factual matters of case of plaintiff before the trial court that suit schedule properties are the joint family properties of plaintiff and defendant. And defendant number 1 and 2 took the contention that item number 1 is the self-acquired property of Papegowda, and item number 2 property is the self-acquired property of the defendant number 2. Also the contention that during the lifetime of Papegowda himself effected partition in respect of item number 1 of property and allotted the share same to his 2 sons equally. And having considered the pleadings of the parties, framed the issues and allowed the parties to lead evidence, the plaintiff, in order to prove his case, examined herself as PW1 and got marked the document exhibit P1 to 5. On the other hand, defendant examined 3 witnesses as DW1 to 3 and got marked document exhibit D1 to D9. Having considered both oral and documentary evidence, it is not in dispute that property belongs to the father Papegowda, and the only contention is that there was a partition during the lifetime of father as per exhibit D2, and the document exhibit D2 is not a registered document. And in order to substantiate that parties have acted upon in terms of exhibit D2 also, nothing is placed on record except relying upon document exhibit D8 and 9 and also the taxpayer receipt and death certificate exhibit D5 and bank receipts. And trial court comes to the conclusion that plaintiff is entitled for 1/9 share. In coming to the conclusion that there are no materials to believe the version of the plaintiff, but defendant number 3 and 4 have produced the oral evidence of one of the attesting witness as DW3, whose oral evidence are supporting the case of defendant, and except that he is cordial with the third defendant, nothing has been illustrated in his cross examination, and hence allowed the notional partition and granted 1/9 share. Being agreed by the same, an appeal is filed in RA number 5029 of 2020, and appellate court, having considered the grounds which have been urged in the appellate court, formulated the point whether the trial court is justified in granting 1/9 share, whether it requires interference. And appellate court, having reassessed, comes to the conclusion that the material clearly discloses that though Exhibit D2 is relied upon, and the same is not registered document, and though relies upon Exhibit D2, and the same is also not acted upon, and suit schedule properties are remained as joint family properties in the hands of the children of Papegowda, and discussed Section 6A and also Section 8 of Hindu Succession Act, and plaintiff is entitled for 1/3 share and hence modified the same as 1/3 share as against the decision of the trial court granting only notional share. Being agreed by the finding of trial court as well as the appellate court, the main ground urged in the appeal that first appellate court committed an error in granting 1/3 share, even though there was a partition among the two brothers on 15/6/1991. And also counsel would vehemently contend that RTC clearly discloses that there was a division, and the first appellate court also committed an error in granting equal share of 1/3 instead of notional partition of 1/9 share, on the ground that there was no registered partition among her father and her brothers, and the same is not sustainable, and also committed an error in relying upon the judgment of Vinith Sharma case, and hence this court has to admit and frame substantive question of law. Having heard the appellant counsel and also the counsel appearing for the respondent, and particularly pleadings, in the plaint specifically pleaded that properties are the joint family properties of plaintiff and defendants. And it is the contention of the defendant number 1 and 2 that item number 1 is the self-acquired property of Papegowda, and item number 2 is the property of defendant number 2. And in order to substantiate the same, defendant number 2 has not placed any document in respect of item number 2 is concerned, and also not in dispute that property was acquired by the Papegowda, but he did not execute any testamentary document to dispose of his property, and when assessing the case he died intestate, leaving behind the plaintiff and defendants. And though defendants relies upon the document of Exhibit D2, and the same is inadmissible document, and the same is not registered document, and apart from that, in order to show that they have acted upon, no documents are placed before the court, and hence appellate court rightly comes to the conclusion that the same cannot be relied upon, and admittedly even plaintiff is also not a party to the said document, and when such being the case, and plaintiff being the legal heir of Papegowda entitled for 1/3 share, and when such material was taken note of by the trial court and also the appellate court that she is entitled, and only trial court did a mistake in coming to the conclusion that she is entitled for notional share, and the same is rectified in the first appellate court in coming to the conclusion that she is equally entitled for a share, not 1/9 share as notional share, and relied upon the judgment of apex court in Vinith Sharma case, and rightly comes to the conclusion that she is entitled for 1/3 share and not the notional share. And hence I do not find any ground to admit and frame substantive question of law and not a case to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. Second appeal is dismissed. Remaining matters at 2:30.
My lord, with your lordship kind permission, my lord, serial number 43, I have come to USA. I am moving, my lord. Kindly have it next week, my lord. 43.
You are in
USA, my lord, America. I am moving from one state to another state. Next week, your
He is
lordship.
in USA and seeks time, and counsel for the respondent is present. List this matter on 12/12.
My lord, I have one. My lord,
12/12.
I have one submission, my lord. My lord, the serial number, the list number serial number 68. In the afternoon, I have some inconvenience. Your lordship may kindly put on second.
68 final hearing entry. Final hearing, I made it clear in the morning itself. I am not taking up any final hearing. Today, 45 admission matters are there. Next.
55, my lord.
ಹೇಳಿ 55.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ, ನಾಳೆ ಅಲ್ಲ ನಾಡ್ದು ಹಾಕೊಳ್ಳಿ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ಮೇಲೆ ಆಯ್ತು.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ.
55.
ನನ್ನ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಆಯ್ತು, ಡಿಕ್ರೀಡ್. ಅದೇನ ರೆಸ್ಟೋರ್ ಲಿಂಕ್ಸ್ ರಿವರ್ಸ್ಡ್ ಅಲ್ವಾ?
ಹೌದು, ನಾಳೆ ಅಲ್ಲ ನಾಡ್ದು ಹಾಕೊಳ್ಳಿ. ನಾಳೆ
ಎಲ್ಲ ನಾಡ್ದಿಲ್ಲ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ನೀವು
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರಿಗೆ ಹೇಳಿದೀನಿ.
ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೇನ ನಾವು ಓದ್ ಬಂದಿರ್ತೀವಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಒಂದು
ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. That is between appellant and also the court.
ಅಲ್ಲ, day after tomorrow.
Divergent finding ಇದೆ ರೀ. ಇಶ್ಯೂ ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡೋದು ಅಷ್ಟೇನೆ.
Serial number 53.
Note it.
Serial number 53, my lord.
53 ಹೇಳಿ ಏನು?
Senior minor operation. Minor operation ಆಯ್ತು.
ಮೈನರ್ ಆಪರೇಷನ್ ಮೇಜರ್ ಅಲ್ವಲ್ಲ?
ಇಲ್ಲ.
ನೀವ್ ಹೇಳಿ, ನೀವಿದಿರಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್ ಮೇಡಮ್ ಡಿಲೇ ಇದೆ. ಯಾವಾಗ ಆಪರೇಷನ್ ಆಗಿದ್ದು? ನಿನ್ನೆ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದಾರ, ಮನೇಲಿ ಇದಾರ? ತಗೊಳ್ಳಿ. ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂಡರ್ವೆಂಟ್ ಸರ್ಜರಿ ಅಂಡ್ ಈಸ್ ಅಡ್ಮಿಟೆಡ್ ಟು ಹಾಸ್ಪಿಟಲ್. ಅಂಡ್ ಹೆನ್ಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11/12. ನಿಮ್ ಸೀನಿಯರ್ ಅವ್ರು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವೇ ಓದ್ಕೊ ಬರ್ಬೇಕು. ಡೇಟ್ ಕೊಡಲ್ಲ ಮತ್ತೆ, ಪ್ರತಿ ಸರಿ ಓದಕ್ಕಾಗಲ್ಲ ಕೋರ್ಟ್ನವರು. ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್. ಇಲ್ಲ ಯಾವ್ದೋ ಸ್ವಲ್ಪ ಎಲ್ಲ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ಅವನ್ನೆಲ್ಲ ನೀವು ಕಾಯೋದ್ ಬೇಡ. ಬೇರೆಯವರು ಎಲ್ಲಿವರೆಗೆ ಬಂದಿದ್ದೀವಿ ಮೇಡಮ್? ಈಗ 43 ಆಯ್ತಾ? 42 ಇದೆ, ಅಲ್ಲೆಲ್ಲ ಕನ್ಕರೆಂಟ್ ಇದೆ ಬಿಡಿ.
ನಮ್ದೊಂದು ನಾಡ್ದು ಶುಕ್ರವಾರ ಒಂದು ಆಯ್ತು.
ಒಂದೇ ನಿಮಿಷ,
2 ದಿವಸ.
44 ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲಲ್ಲ? ರಿವರ್ಸ್ಡ್. ಪ್ಲೇಂಟಿಫ್ ಅಂಡ್ ಸಿಸಿ ಇಸ್ ಅಲೌಡ್. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂಡ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. 44 ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 6/1/71. ಆಯ್ತು, ಜಾಸ್ತಿ ಆಯ್ತಾ? ಆಯ್ತು, 6/1/26.
Your lordship, serial number 42.
ಒಂದ್ ನಿಮಿಷ ಇರಿ ಮೇಡಮ್. ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ಇಂಜಂಕ್ಷನ್ಸ್ ಅಪ್ಲೈಂಟ್ ಫಾರ್ ಬೋತ್ ಸೂಟ್ಸ್ ಆರ್ ಡಿಸ್ಮಿಸ್ಡ್. ಡೈವರ್ಸ್ ಡಿಕ್ರೀಡ್ ಕನ್ಫರ್ಮ್ಡ್ ಇನ್ ಅದರ್ ಸೂಟ್. ಇದ್ರ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಬೇಡ. ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲದ್ ನೋಡಿ, ಯಾವ್ದಾದ್ರು ಡೈವರ್ಜೆಂಟ್ ಇದೆಯಾ? ಇದೊಂದು ಕನ್ಫರ್ಮ್ ಮಾಡಿ. 47 ಇದೆಯಲ್ಲ, ನಮನ್ ವಂಕದರಿ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್, ಇಶ್ಯೂ ನೋಟಿಸ್. This matter on 7/1.
ಇನ್ಕನ್ವಿನಿಯನ್ಸ್ ಇದೆ. ಆಫ್ಟರ್ನೂನ್ ಡೇ ಆಫ್ಟರ್ 2 55 ಮೇಲೆ.
ನೀವ್ ಯಾರಿಗೆ?
ಅದೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೆನ್ಷನ್ ಮಾಡಿದೆ.
55
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಅರ್ಥ ಆಯ್ತು ಅಂತ ಅನ್ಕೊಂಡಿದೀನಿ, ಒಂದ್ಸರಿ ಹೇಳಿದ್ದು. 54 ಮಹಾಂತೇಶ್ ಹೊಸ್ಮಠ್ ಇಬ್ರು ಇದಾರೆ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ, ಇರ್ಲಿ ಬಿಡಿ. ನೆಕ್ಸ್ಟ್ ಲಿಂಕ್ಸ್ 57 ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ suit for declaration and injunction decreed owner permanent injunction granted reversed. Issue notice and call for records. List this matter on 7/1. ಅಷ್ಟೇ ಅಲ್ಲ, ಮತ್ತೊಂದು ರಿವರ್ಸ್ ಇದೆ. ಯಾವುದು? 58 ವಿವೇಕ್ ಎಸ್ ಓನರ್ ಹ್ಯಾಂಡ್ ಓವರ್ ದಿ ಪೊಸಿಷನ್ ರಿವರ್ಸ್ಡ್. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 7/1/25.
ಇಲ್ಲ ಹೇಳಿದ್ದೇನೆ. ಹಾ ಬರ್ಬೋದು. 2:30 ಮ್ಯಾಟ್ರ್ ಇದೆ, ಅದಾದ್ಮೇಲೆ ನಮ್ದು. ಹೌದು. ನಂಬರ್ ಹೇಳ್ಬೇಕು. ನಂಬರ್ ಹೇಳಿ ನೀವು. ಹಾ ಅಲ್ಲ ಹಂಗೆ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ ಸರ್? ನಿಮ್ದೇನ್ ರೀಚ್ ಆಗಿಲ್ಲ ನೀವು. ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ಹೇಳ್ಬೇಕು ನಂಗೆ? 7 ಇಶ್ಯೂ ನೋಟಿಸ್ ಲಿಸ್ಟ್ ಆನ್ 7/1/20.
ಅಷ್ಟಲ್ಲ ಮೇಡಮ್, ಇದೇನೋ ರಿವರ್ಸ್ ಅಲೋಡು ಏನೇನು ಹೇಳ್ತಿತ್ತು ಅವೆಲ್ಲ ಇಲ್ಲ.
ಅವ್ರು ಓದ್ಕೊಂಡ್ ಬಂದಿದ್ದೆ ನಾವು ಓದಿದ್ವಿ. ಅದೇನ್ ಬೇಡ, ಬರೀ
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಲಿಸ್ಟ್ ಆನ್ 7/1 7/1/26. 57 ಕೂಡ ಏನ್ ಮೇಡಮ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಲ್ಲ ಇಲ್ವಾ? ನಾನು ಬರ್ಕೊಂಡು ಏನು ನನ್ನ ಕಲಿತಿದ್ದೆ. 58 ಅಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್
ಅಷ್ಟೇ, ನೋಟಿಸ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
ನಾನು ಅವ್ರು ಹೇಳಿದ್ದೆಲ್ಲ ಹಾಕ್ತಿದ್ದೆ. ನಾನು ಡೇಟ್ ಇದ್ರಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಬರ್ಕೊಂಡು ಹೋಗಲ್ಲ, ನೀವು ಊಟ ಮಾಡ್ಕೊಳ್ಳಿ.
ಬರ್ಕೊಂಡಿದ್ದೀರಾ? ಇದರಲ್ಲಿ 32 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಮಾಡಿ ಅಂದ್ರಲ್ವಾ?
ಅಷ್ಟೇ ಅಲ್ಲ, ಅದು
ಡಿಸ್ಪೋಸಲ್ ಇದೆ.
ಡಿಸ್ಪೋಸಲ್. 32. This court made order 23/9/25 in respect of Article 3, 5 to 7 is held sufficient, but are absent
information stated and not the grounds of arrest. The information about the arrest is completely different from information about the grounds of arrest. Mere information of arrest will not amount to furnishing the grounds of arrest. Kindly come to paragraph 28. Therefore, in the facts of the case, we have no hesitation in holding that the arrest of the appellant was rendered illegal on account of failure to communicate the grounds of arrest to the appellant as mandated by Article 22(1) of the Constitution. So kindly come to paragraph number 31, page 38. The non-single judge unfortunately has equated information given regarding the appellant's arrest with the grounds of arrest. The observation that the allegation of non-supply of grounds of arrest made by the appellant is false allegation is completely uncalled for. All courts, including the High Court, have a duty to uphold the fundamental rights. Once a violation of fundamental rights under Article 22(1) was alleged, it was the duty of the High Court to go into the said contents and decide in one way or the other. When a violation of Article 22(1) is alleged with respect to grounds of arrest, there can be possible two contentious rights. A, that the arrested person was not informed of the grounds of arrest, or B, purported information of grounds of arrest does not contain any ground of arrest. As far as the first contention is concerned, the person who is arrested can discharge his burden by simply alleging that grounds of arrest were not informed him. If such an allegation is made in the pleading, the entire burden is on the arresting agency or state to satisfy the court that effective compliance was made with the requirement of Article 22(1). Therefore, the view taken by the High Court is completely erroneous. Para number 33, in the appeal is allowed. The person following order, the arrest of the appellant goes to
Offenses,
in this case, the offenses are different. The offenses 409, 420, 467, 468, 50 and 50A of CRPC does not segregate the offenses 50 and 50A of CRPC does not segregate the offenses by violating the grounds of arrest. Irrespective of offenses, the grounds of arrest are to have been furnished. There are any judgment I will take after judgment. Kindly come to page number 79, sorry, 69.
60?
69. Para 7, 71. Having heard the Land Council appearing for the parties and having gone through the details on record, we are inclined to exercise our discretion in favor of the appellant, keeping in mind the following aspects. The appellant is in jail as an under trial prisoner past 4 years. In the present case, 4 years, 9 months, 4 days. Till this date, the trial court has not been able to even proceed to frame the charge. As pointed out by the council appearing for the state as well as NDA, the prosecution intends to examine not less than 80 witnesses. Next paragraph. Having regard to the aforesaid, we wonder by that the period of time the trial will ultimately conclude. Howsoever serious crime may be, the accused has right to speedy trial as enshrined under the Constitution of India. Next paragraph. Over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. Kindly come to para number 18, my lord, page number 76. Para 18. Criminals are not born out but made. The human potential is everyone is good and so never write off any criminal as beyond redemption. This humanist fundamental is often missed when dealing with delinquents, juvenile and adult. Indeed, every saint has a past and every sinner a future. When a crime is committed, a variety of factors is responsible for making the offender commit the crime. Those factors may be social and economic, may be the result of vague erosion or parental neglect, may be because of the stress of circumstances or the manifestation of temptation in a mind of affluence contrasted with intelligence or the other private. If the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect fundamental right of an accused to have a speedy trial, as enshrined under Article 21 of the Constitution. Then the state or any other prosecuting agency should not oppose the bail for plea on the ground that crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of crime. Next paragraph, we may hasten to add that petitioner is still an accused, not a convict. The overarching postulate of criminal principle that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly. Howsoever cited the penal law makes, we are convinced the matter, the prosecuting agency as well as the court and proceeded the right of the accused to have speedy trial could be said to have been infringed thereby violating Article 21 of the Constitution. In view of the above said, the appeal nearby above and this is other. Kindly come to another page number 79. Under the recent judgment Melod parameter, page number 79. Whether it's the relevant Melod, page number 83, para 7. However, this is a case in which the appellant is in custody as an under trial prisoner since 24/3/2020. He has no other antecedents. The punch witnesses to the recovery Panchanama have also turned asked. Next paragraph. It's been now 5 years that he is in judicial custody. The Lord Counsel for the state has no idea as regards the time likely to consume to complete the recording of trial. Kindly comes to mirror page number 86, para 14. In this regard, the role of the special judge NIA would also assume importance. The special judge should inquire with the special public prosecutor why he intends to examine a particular witness if such witness is going to impose the very same that thing that any other witnesses might have disposed earlier. We may sound as if laying some guidance, but the time has come to consider this issue of delay and bail in its true and proper perspective. If an accused is guilty to get a final verdict after incarceration of 6 to 7 years in jail as an untried prisoner, then definitely it could be said that his right to have speedy trial under Article 21 of the Constitution has been infringed. The stress of long trial, an accused person who remain innocent until proven guilty can also be significant. Accused persons are not financially compensated for what might be lengthy period of pre-trial impairment. They may also have lost job or accomplished experienced damage to personal relationships while incarcerated and spent a considerable amount of money on legal. If an accused is found not guilty, they have likely endured many months of being stigmatized and perhaps even ostracized in their community and will have to rebuild their lives in their own city. Considering this might not be able to plan. With regard to the under trial, the full bench judgment. The kindly come to page number 62.
60?
62. 62. Full bench judgment, the relevant para. Para number 16, page number 67. This court has clarified in numerous judgments that the liberty guaranteed under by Part 3rd of the Constitution will cover within its protective ambit not only due procedure and fairness but to access to justice and a speedy trial. In Supreme Court Legal Aid Committee representing untried prisoners versus Union of India, it was held that under trials cannot indefinitely be detained pending trial. Ideally, no person ought to suffer adverse consequences of his act unless the same is established before natural arbiter. However, owing to the particulars of real life, where to secure an effective trial and ameliorate the risk to society in case potential criminal is left at large pending trial, courts are tasked with deciding whether an individual ought to be released pending trial or not. Once it is obvious that timely trial would not be possible and the accused has suffered incarceration for a significant period of time, courts would ordinarily be obligated to enroll them on bail. Now, my lord, in the present case, but even if assuming my lord for a moment that the petitioner may have failed to be convicted under 201 offense and 120 years. Lord, admitted in my lord, as per the allegation of the charge, my lord, while committing the murder, he was not at all. Therefore, my lord, only 201 and 120 he would be attracted to the present case on hand. But insofar as my lord, record number 2, my lord, can say he was taken into custody. My lord, there are 4 sureties have been given, out of which 2 sureties local, out of which 2 sureties.
What is the punishment for 120B?
My lord, if it is the offense, my lord, the imprisonment of life. My lord, it is depending upon the offences, depending upon the nature of crime involvement. But here, my lord, he was allegation level against this petitioner. He took the articles, returned back, and subsequently destroyed. Therefore, my lord, on the ground of parity and this ground, my lord, he may be, my lord, absolved on bail. Of the accused number 2, my lord, if he furnished another surety, my lord, he would be released on bail. That will not negatively impact on the present petitioner. Therefore, my lord, my humble request, my lord, including this.
Yes.
This is a case of Supari killing, my lords, where accused number 3, the main accused, would give Supari to accused number 1, accused number 2, and accused number 4. The prosecution report, that's the charge sheet, would indicate that she would go pawn her jewels in Chennai, get the money, and distribute the money to A1, A2, and A4. Account details indicate that the money has been transferred. Subsequently, my lords, the accused number 1, 2, and 3, 1, 2, and 3, 4 would come down to Bangalore. 1, 2, and 4 come down to Bangalore in search of the deceased, but they are not able to find him. Subsequent to that, 3 says she will come and identify him. She comes down. She resides along with the deceased, who is the stepson, because she is the stepmother, along with her 2 minor children. A call is made to the accused 1, who along with accused 2 and 4 are drinking in a bar. The conspiracy starts in Chennai, where accused number 1, accused number 2, and accused number 3 have met together along with accused number 4, conspired to do away with the life of the deceased. Subsequent to that, again they meet up in a bar prior to coming over to the residence of the deceased, where accused number 3 is there. They enter in the car. The CC camera would indicate that all the 3 of them, that is accused number 1, 2, 4, have come. 3 is residing with the deceased. 2 accused, leaving 1 accused in the car, would go up, consume alcohol along with the deceased and accused number 3. And the CC cameras would indicate that they come down and they start moving towards.
What is the relationship between A3 and deceased?
Stepson and stepmother, lords.
Oh, stepson.
Stepson.
Deceased is stepson.
Please, lords.
A3 is stepmother.
Yes, lords. They travel towards Andhra Pradesh. The toll plazas indicate, there are photographs to show that they were sitting and drinking together prior to the call being made by accused number 3, using the deceased phone, and they would come to the residence where she indicates, gives the location. Subsequently, taking the deceased, they would go travel towards Andhra Pradesh. The toll plaza cameras would indicate that the car along with these people are traveling. At Kolar, accused number 4, who is the petitioner before my lords, gets down from the car. A wallet, a telephone, and other articles are given to him. He would come back in the wee hours in the morning, hand over these articles to the stepmother, who is accused number 3. Photographs again indicate that he is handing it over to her. She in turn would hand over a laptop bag and a luggage bag. He would take them and destroy it. What the third accused would do is, would take the wallet, use the credit cards, give it to accused number 1 subsequent to the murder. He would take it to the airport in Hyderabad and swipe the card over there to indicate that he has traveled to Hyderabad and from there he's gone away. In the meanwhile, after taking making the accused number 4 get away at Tumkur, they would go to the border, and in the border they would commit the murder subsequently take his body to Andhra Pradesh to Nellore, which is more than 150 kilometers from the border. In a forest, Nallama forest over there, they would bury him. Subsequently, they would come back. The accused number 3 was the stepmother who has the possession of the phone of the deceased, starts sending messages to the biological mother, indicating that he is unhappy over here, he is not able to find a job, hence he would be traveling abroad to seek his employment. But the biological mother would find out that the tenor of the messages and the spelling which they have used is incorrect, and her son would not use such language, would tell the father to verify. The father goes and verifies, and he also is being told by the accused number 3 that the next day morning when she got up, he is moved away with the luggage. The biological mother goes, confronts. The same story is given. Initially, a man missing complaint is registered. Subsequent to the man missing complaint, when the investigation starts, they would come and get the CC camera recordings from the apartment where the deceased and the third accused were there, which indicates that he was taken away by accused number 1, 2, and 4. On being confronted with the photographs, the father would identify accused number 1 to say that he is known to him because of his wife in Chennai. They trace his mobile to Tirupati. By the time they go to Tirupati, he is not there at home. Then they also find out that accused number 2's mobile is also found in Tirupati. So they go to his house, he runs away, tries to lay down before a moving train, he is injured. On his statement, they come back to accused number 1. Accused number 1 by then would have committed suicide. Subsequent to the taking into custody of accused number 2, he takes the police to the place where the body is buried. The body is exhumed only at the instance of accused number 2. At the instance of accused number 2. The prosecution witnesses who have examined and who have supported the prosecution would indicate that accused number 2 was present. His photographs are there to indicate that he was present. He is the person who showed the dead body also. Insofar as accused number 4 is concerned, my lords, he was a conspirator right from the time the plan was hatched in Chennai. Subsequent to that, at the time when a phone call was made asking the accused 1, 2, and 4 to come to the place where the deceased is, at the time when the deceased was taken away, and till Kolar where he was there, the entire conspiracy is one of the conspirators along with the other accused. Subsequently, he would also help in destroying the evidence and to mislead the entire prosecution in case if it comes to it, my lords. We have examined 15 witnesses, my lords. Endeavor was made insofar as one of the witnesses who is the last seen circumstance, who is the watchman in the apartment, we are in the process of filing a complaint that a threat was made. Is till today is at large. We are not able to find him. After the examination in chief, for cross-examination it was deferred, and subsequently he was not to be found. We are not unsure of where his whereabouts are. Proclamation is issued. We are at that stage. Insofar as the release of, if a parity is what is urged, my lords, insofar as the accused number 3 who was released was the prime conspirator, by the time her bail application came up for consideration, my lords, her husband had expired. Natural causes. He was a diabetic patient. He had kidney issues and other issues. He passed away. But my lords, this honorable court would observe that since she is a lady and she has 2 minor children who otherwise are orphaned, that was the prime reason for consideration of this honorable court to grant bail. If a second ground is taken to say that witnesses have turned hostile, I would rely on one judgment which the Honorable Apex Court would indicate that turning of hostile witnesses is not a ground for parity. I just passed this across. A few other judgments also. Not in so far as grounds of arrest, a subsequent judgment of what my learned friend read, my lords, in the case of Darshan. I don't have the thing, my lords. I'll produce it, my lords. State of Karnataka versus Darshan. The Honorable Court Yes, my lords. While reiterating Vihan Kumar, which my learned friend read, at para 20.1.4 minutes, I'm getting it photocopied, I'll have it furnished minutes. It would state like this minutes. In Vihan Kumar versus state of Haryana, it was reiterated that Article 22(1) is satisfied if the accused is made aware of the arrest grounds in substance, even if not conveyed in writing. Similarly, in Kasireddy Upendra Reddy versus state of Andhra Pradesh, it was observed that the arrest is made pursuant to a warrant. Reading out the warrant amounts to sufficient compliance. Both these post Pankaj Bansal decisions clarify that written individualized grounds are not an inflexible requirement in all circumstances. The Honorable Apex Court only could go to say that if at all an intent is indicated to the accused that this is the reason why they want to take him into custody and you are involved in such a case, that is sufficient is what the Honorable Apex Court would hold in the judgment. In the judgments which I wanted to rely upon, Lords may permit me to page number 19 minutes in the first of the judgments, Tarun Kumar versus Assistant Director, para 18 minutes, line 4 minutes, para 18, line 4. It may be noted that parity is not the law. While applying the principles of parity, the court is required to focus upon the role attached to the accused whose application is under consideration. Here is a case, my lords, with the accused who is the petitioner, accused number 4 is the petitioner, was involved in the conspiracy right from the beginning of the plot, my lords. Permit me to come to page number 29, my lords, para 14. Ordinarily, in serious offences like rape, murder, dacoity, etc., once the trial commences and the prosecution starts examining its witnesses, the courts, be it the trial court or the high court, should be loath in entertaining the bail application of the deceased. Multiple times they have approached this honorable court. This honorable court was pleased to reject all their bail applications. Now the change in circumstance, what they claim is only on parity. The third judgment, my lords, is page number 36. Para 7 minutes. Sixth line minutes. Further, merely classifying the appellant as a principal star witness and referring to her statement is of no consequence, since the entire evidence will have to be assessed by the Sessions Court before arriving at a conclusion. If that be the position, when this court at an earlier instance had taken note of all the aspects and had arrived at the conclusion that there is prima facie material against respondent number so and so, the mere examination of the appellant herein cannot be considered as a change in circumstance for the High Court to consider the so-and-so bail application of accused number so-and-so to enlarge on bail. Here is we are on the exact same footing, my lords. Earlier, this honorable court, after going into the entire materials of the prosecution, would reject the bail application. Now, with the sole depositions, the petitioner wants to be examined on the grounds of parity. The last judgment, lords would permit me to come to page 41. As I made a submission earlier, my lords, the one in block letters, my lords, at page 41. Hostility of witnesses cannot be a new ground for granting bail to the accused applicant. If any opinion is taken on the basis of the evidence given by the hostile witnesses, it amounts to evaluating the evidence by this court, which is impermissible while deciding the bail application of the accused under so and so. Now the petitioner wants this court to examine his bail application on these grounds. The Honorable Apex Court would hold that if at all, if that is so done so, it would be in as though they are evaluating the evidence itself. Notice we are in the process of maximum another 6 months to 9 months, we will be able to complete the evidence of the majority of the witnesses who are there, my lords. And this petitioner's application being rejected earlier, and there will be no sufficient substantial change in circumstances, my lords. My humble submission or request prayer is for rejection of the bail application.
The arrest grounds are not been furnished. It's not a case of the prosecution. Yes, we have furnished the arrest grounds of arrest. considering that the grounds of arrest had not been furnished by way of this reply. Section 50 A CRPC melody will be negatory. Melody, the grounds of arrest had not been complied. It is the law magistrate to inquire into whether the grounds of arrest has been furnished. It's a 50 melody. Person arrested to be informed of grounds of arrest and the right to bail. Every police officer, other person arresting any person without warrant shall forthwith communicate full particulars of the offence for which he is arrested or other grounds of such arrest. 50A subclass 4. It shall be the duty of the magistrate before whom the arrested person is produced to satisfy himself that the requirements of section 2 and section 3 have been complied with respect of such arrested person. Therefore, my lord,
Yes, heard reserved. Grateful.
$78. Vinekitiyam.
ಯಾವ್ದ್ರಲ್ಲಿ ಓಂಕಾರೇಶ R2ಗೆ ಇದಾರ ಯಾರೋ ವಕಾಲತ್ ಹಾಕಿದ್ರಲ್ಲ ಹಾಕಿದಾರ ಯಾರು ಓಂಕಾರೇಶ್ ಯಾವಾಗ ಹಾಕಿದಾರೆ ವಕಾಲತ್ ಮೇಡಮ್ ನಿನ್ನೆ ಇಲ್ವ ಈಗ ಅವರು ಓಂಕಾರೇಶ್ ಇಲ್ಲ ತಗೊಳ್ಳಿ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಓಂಕಾರೇಶ್ has filed ವಕಾಲತ್ for R2 and counsel is absent and his name is not shown in the cause list and hence list this matter on 4/12. 4/12. Huh? Offer. ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ ನೋಡಿ ಅದೇನ ಬಿಲ್ಡಿಂಗ್ ಟ್ಯಾಕ್ಸ್ ಅದ ಬಿಬಿಎಂಪಿ Council Sri Vankaresha again seeks time. Accordingly, a week's time is granted. ನೋಡೋಣ ಬರ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೋ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ 4/12.
Hearing on IA 79. That was disposed of by order of your lordships may not on 8/80/2002. Matter pertains to granting of maintenance for the children. Benefits for the wife and residents. This order was passed on 8/2022. Passed this job may not on 27/9/2023. This termination of the job, because when we left the job and it's given because of the time. Circumstances that we have moved on. Post-COVID, it is not on his level, it was easy for him and looking for the job.
When he lost his job?
On 27/9/2023.
27/9?
2023.
23 after COVID was over.
ಆದ್ಮೇಲೆ ಕೆಲಸ ಸಿಗೋದು ಕಷ್ಟ ಆಗ್ತಾ ಇದೆ ಮೇಲೆ.
What was the interim order granted earlier?
10,000 rupees per month for both the children, and then provide a residence for her in the house where he stays, or directly to pay 10,000 rupees. I'm seeking for a reduction of the amount of 50% because I have not got any job. I produced my income tax returns to show that as of now my salary is only 50,000 rupees.
Only rupees?
50,000 rupees per month on average I earn, my lord.
50,000.
I produced my income tax returns along with my additional documents. Wherein I have made it very clear that the income tax returns are showing my salary is my income what I'm working as a consultant. I get job at the once or twice a week. I'm permitted to go to work. But hourly basis what I will pay. So based on this, I requested my lord to modify the order by 50% so that I can
manner, my lord, and visitation rights, my lord, I have not been able to access because I've been permitted to meet children in her house. And there is austerity and animosity between us, so visiting the children there is difficult. That permit me to take the children outside. Well,
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ
the additional documents, additional affidavit which I have filed.
ಮಾಡಿಫಿಕೇಶನ್ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
The income tax returns are on August 2025.
What was your salary earlier at the time of granting?
It was little over 1,30,37,000 is what I see in the order.
Even in his
Now you have left that job or?
I don't have the job, that's why I produced that.
What about earlier job, madam? What happened? Whether you have been
I was working in Terex, my lord.
now you have been removed.
I've been removed.
Where is the document removal?
Page number 27, IMO modification, IA 1/2023.
27.
27.
Relieving letter. Relieving letter.
Relieving letter. Before that, I have not got any job. Before that, I have not got any job or work. What is the way I'm working now, my lord? I want to produce my income tax returns. For the additional affidavit that has been filed in August 2025. For the year assessment year 24-25 is 24 where I was employed and I lost the job. My income for that year after I lost the job was 85,490. That is because after September I was employed.
Available at page number? Annexure A. Annexure A. Annexure A is only a petition under section 31 of the Protection of Women from Domestic Violence Act. Available at which page, madam?
Along with this
Only
no documents were furnished along with the
along with
additional.
IA, only no such document. Income tax details, not nothing.
Additional affidavit.
Additional affidavit.
Documents documents have not been furnished along with the additional affidavit.
Your objection, sir.
Additional affidavit.
Additional affidavit in support of IA for modification. Affidavit and income tax details.
Income tax returns is produced.
It was objections to my enhancement application.
Not in this, I produced 20 financial year 2024-25 Annexure B. My salary was 3,60,270. That is the finding a job at this age with my level, the decision is happening all over globally. I'm not getting any job. I'm only doing the consultancy job that is available.
What is your age now?
It's 4950.
4950. Yes.
My lord, sir.
That's all.
All that I am saying, they are saying that first and foremost, there are three things that are there. Visitation rights are seeking for modification, permitting to meet the children outside. Instead of meeting the children in their house.
Whether this court earlier granted any such order? Any such order? Where is that order?
Point number 3 at legal 14 of your lordship's order dated 8 April 2022.
As sought by her, she is ready to stay in the ground floor with her children, or otherwise the first respondent husband has to pay monthly rent of rupees 10,000 to the first respondent husband.
Below that, point number 3. This aspect of the rent, I'm not able to pay this amount also is what I was modification. 50% is what I'm saying that I would be able to pay with the current salary I'm managing
You are not provided any accommodation and also not paid the rent also.
No, my lords.
So far, my lord, wherever.
Order is very clear, madam. It is appropriate to direct the first respondent and husband to provide an accommodation in the ground floor in his house to the petitioner wife, along with their children as sought by her, as she is ready to stay in the ground floor with her children, or otherwise the first respondent husband has to pay monthly rent. You are not given any accommodation, then you have also not paid the amount. Now you are seeking for reduction of, but you are having a building.
Building, my lord, my brothers and sisters, all of them are there in that house. It belongs to all the family.
But her request is only to accommodate her in the ground floor.
Our area is Adesh has changed them and nine. They themselves have stated that there is a business that being run over there by my brother and sisters.
Brother and sister-in-law, by the petitioner only. So there is availability of.
Madam, let her complete, then you can make submission.
Admittedly by them, they said business is being run there by family members and not by me. And I could not make aware of that house. So whatever amount your lordship has directed, my lord, considering the fact that my salary has now come down and money capacity is only about 50,000.
If not possible in ground floor, then you pay the accommodation charges. Then where she has to live along with children? Here she has to live along with two children. If not possible to provide an accommodation, then you have to pay. Where she has to go?
Two aspects, my lord. When I get a job, I certainly pay the direction as directed by lord. At this moment, because I lost the job and I'm not, even the moment I lost the job in 2022, I'm not being able to
Yes, madam. What is your
My lords, I also
application
filed
for enhancement?
enhancement application.
You have filed objections
in view
to
of the
this,
modifications
notification.
of the developments, my lords. Your lordship may kindly turn to page 47, my lords.
47 of
47 of my application, my lords, for
your
enhancement.
application.
My application for enhancement, my lords.
Enhancement. What is there in page 47?
47 is it's a brochure, my lords. It's about, it's a company that has been flaunted by the petitioner, my lords.
That means he has started company.
He has started a company in the year 2018, my lords. But when he approached this honorable court, he has just mentioned that his only source of income is through the salary out of his employment, my lords. He has suppressed this fact that he has flaunted a company in the year 2018, my lords. And your lordship may kindly turn to 59, my lords. These are the projects that they have completed, my lords. The number of projects that have been completed by the company clearly shows that he has earned several crores of rupees, my lords, through this company. And this particular company.
This company belongs to him.
How this for me?
Where is the document?
My lords, the GST is at GST certificate is at page 75, and it is an admitted fact, my lords. He himself has furnished a partnership deed of the company, my lords. And GST at page 75 clearly shows the address of the company is the very address in the cost title, my lords, where the petitioner has resides, my lords. And the partnership that have a partnership deed that has been furnished by the petitioner at in their objections to the enhancement application clearly shows that this company has been flaunted in the year 2018, my lords. And this very fact has
Where
been
is the
my
payment
lords,
of where is the GST payment, madam? In his
GST
name?
payment is at page 75, my lords.
75, nothing, madam.
75 only this for me.
75.
Form.
This is only a 75.
This is the GST form.
Yesterday, the form is yesterday. What is the payment he made?
My lords, I have no access to that part of the transaction, my lords. ಇದು
stands in
ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಸಿಕ್ಕಿರೋದು ನಾನು
it
ಪ್ರಿಂಟ್
stands in whose name, madam?
My lords, it stands in the name of
Yes,
the
name.
company, and this company, the address is number 70 First B Main Road, 14th Cross, First Main Road, Soundarya Layout, Sendehalli Post, Karnataka.
That is
This
his
is the address of the petitioner, my lords.
petitioner's address.
ಹೌದು ಸ್ವಾಮಿ, ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇರೋ ಅಡ್ರೆಸ್ ಅಲ್ಲೇ ಇದು ಕಂಪನಿ ಇರೋದು. And he is one of the partners also, according to his very own document furnished. And this fact has been suppressed before this honorable court, and when this petition came to be filed in the year 2019, Swami. So the conduct of the petitioner in filing the income tax returns showing minimal income also clearly shows that he has suppressed his income before the income tax authorities at the time of filing his returns. And throughout, my lords, he has been resorting to the ways where he can evade paying maintenance to the children, my lords. And subsequent development, my lords, I have been transferred to Karwar, my lords. Only today morning I have received this document, the transfer order. Your lordship may kindly permit me to publish it. The latest salary certificate of the respondent and also the transfer orders, my lords. Apart from maintaining the children here in Bangalore, she has to maintain herself. She has to rent a house there in Karwar.
You refer page 47.
47.
47 in connection with which GST tax invoice? Subhash Enterprises, page 47.
47 is
Bill to student Shreya Praveen, adenadu maganda?
47 of which?
47 ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಹಾಕಿದಿರಲ್ಲ ಅದರಲ್ಲಿ.
Swami, ಅದು 47 is Tektronix Engineering brochure.
ಇಲ್ವಲ್ಲ ಮೇಡಮ್, ಅದು 47 ನಾಟ್ ದಿ ಬ್ರೋಚರ್. ಏನ GST ಟ್ಯಾಕ್ಸ್ ಇನ್ವಾಯ್ಸ್ ಅಂತ ಇದೆ ನೀವು ಕೊಟ್ಟಿರೋದು. ಪೇಜ್ 47 ಯು ರೆಫರ್ಡ್. 47
is brochure, Swami.
ಬ್ರೋಚರ್ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ ನೋಡಿ. ಬ್ರೋಚರ್ ಎಲ್ಲಿದೆ?
Brochure is the colored printout Mr. Lordship is seeing.
ಎಲ್ಲಿದೆ ಬ್ರೋಚರ್? ಇಲ್ಲ 47 ಅವ್ರದ್ದೇನದು ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಅವ್ರದ್ದು ಫಸ್ಟ್ ಒನ್. ಅದೇನದು ಪ್ರಶಾಂತ್ 46 47 GST ಇದೆ.
50 75.
You have also produced some photographs, constructions.
Howdu, Swami. Those are all the projects that have been undertaken by this particular company, Swami.
Company.
59 in the.
Where is the document that he is a partner to that company?
Partnership deed.
47 ಅಲ್ಲ ಮೇಡಮ್ ಅದು. ಕಾಂಟ್ಯಾಕ್ಟ್ ಅಸ್ ಅಂತಿದೆ. Where is the document that he is a partner?
I will take your lordship to that.
I have produced those documents regarding this.
You have already produced.
My
You
lord,
are a partner.
My lord said that.
2018.
And then no business was done during that time. I was also engaged or required and there is a retirement deed in 2022. I'm not.
You have also produced retirement deed?
At page 16. R3.
Retirement of partnership. I also reduced the income tax of the return for this company.
My lord, sir, as soon as I furnished this brochure, all these documents came forward before this court, my lords. The partnership, the unregistered partnership, the
Madam
retirement.
says,
all the members of the partnership are the family members, Your Honor.
Retired from that
Ella
partnership.
family members, Swami. Our Thai, Tengi, Tamma. brother, sister, it's all that.
Partners.
All along, his mother was a dependent on him. That continuously from the day he has filed the petition, he kept on making submission that he has to maintain his mother. She's completely dependent. He has to bear the medical charges. Now all of a sudden she has money to repay the housing loan and also become a partner of this partnership firm by paying a huge amount. Allah, but still she has money for all that.
Brother and brother, sister's husband are running this business.
It looks like
They also have a share, it's a family home. Brother, sisters, moved on over here. That was the reason why she left the house. She didn't want to stay in the joint
No, that's not true.
She wanted, right from the beginning, that she wanted a separate independent house, at least separate when I go back,
That's all.
My lord, sir. When the site was purchased and the construction was
I will
started.
go through the material and I will pass orders.
Please, my
Further arguments, 80. Prasanna Kumarji.
Yes, madam. What happened, madam?
Charge sheet is not filed, your lordships. The matter is to be transferred to the IG, your lordships. Commissioner had written a letter to the IG, your lordships, regarding the same, regarding transfer of the matter to the Lokayukta, your lordships. And the same letter was forwarded to the government. Your lordships, I'm producing the document with order.
Transferred in the sense?
Transfer the matter to Lokayukta, your lordships.
Lokayukta.
Please.
On what date?
Please, your lordships, I'm passing the.
Now you are not continuing the investigation.
Lordships, we are continuing the investigation, your lordship, subject to the, an order is being passed by the government, your lordship. On page number 4 is the order. Is passed. That's subject to the outcome of the petition that is pending before the apex court, your lordships.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಕಾಟನ್ಪೇಟೆ ಪೊಲೀಸ್ ಠಾಣೆ ಮೊಕದ್ದಮೆ 64-63 ಭ್ರಷ್ಟಾಚಾರ ನಿಗ್ರಹ ಕಾಯ್ದೆಯನ್ನು ವರ್ಗಾಯಿಸಿ ಆದೇಶ ಹೊರಡಿಸಿರುವಂತೆ ಕೋರಿರುತ್ತೀರಿ. ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಸದರಿ ಪ್ರಕರಣದ ಆರೋಪಿಯು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾಖಲಿಸಿರುವ ಕ್ರಿಮಿನಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ನೀಡಿರುವ ತಡೆಯಾಜ್ಞೆ ಜಾರಿಯಲ್ಲಿ ಇರುವುದರಿಂದ ಪ್ರಕರಣ ಪೂರ್ಣ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೆ ನಿರೀಕ್ಷಿಸಿ 2 ಮೊಕದ್ದಮೆಗಳ ವರ್ಗಾವಣೆಗೆ ಇದು ಯಾವಾಗಿಂದ ಹಳೇದು ಕೊಡ್ತಾ ಇದೀರಿ ಮೇಡಮ್? ಈಗೆಲ್ಲಿದೆ?
That's why your that's why it's kept pending, your lordships.
ಸ್ಟೇ ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ?
In respect of accused number 2, your lordships.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಗೆ ಯಾವ್ದು ಸ್ಟೇ ಇಲ್ವಲ್ಲ? ಈ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿದೆಯೇನ್ರಿ ಯಾವ್ದ್ರಲ್ಲಾರು? ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ? ಇದು ಹಳೇದು 2020ನೇ ಇಸ್ವಿ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕ್ತಾ ಇದೀರಿ ನೀವು.
Your lordships, in respect of accused number 1.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಗೆ ಆಲ್ರೆಡಿ ಕ್ವಾಶ್ ಆಗಿದೆ ಮೇಡಮ್. ಐ ಥಿಂಕ್ ಯು ಆರ್ ನಾಟ್.
That is pending before.
ಆಯ್ತು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ. What prevented you to investigate the matter and file charge sheet against this accused number petitioner?
This is what is kept pending subject to the.
ಇಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್? ಭ್ರಷ್ಟಾಚಾರ ನಿಗ್ರಹ ಕಾಯ್ದೆಯನ್ವಯ ವರ್ಗಾಯಿಸಿ ಆದೇಶ ಹೊರಡಿಸುವಂತೆ ಕೋರಿರುತ್ತೀರಿ. ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾಖಲಿಸಿರುವ ಕ್ರಿಮಿನಲ್ ರಿಟ್ ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ ಸಂಬಂಧ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯ ನೀಡಿರುವ ತಡೆಯಾಜ್ಞೆ ಜಾರಿಯಲ್ಲಿ ಇರುವುದರಿಂದ ಅಂತ ಬರೀತೀರಿ. ಇದು this is in respect of accused number 1 is concerned.
From that time they've kept it pending for want of. This is the report that I've got, your lordships.
ಏನ್ ರಿಪೋರ್ಟ್ ಮೇಡಮ್? ಇಲ್ಲಿ ಏನಿದೆ? ಈ ಲೆಟರ್ ಅಲ್ಲಿ ಏನಿದೆ? ಓದಿ ಒಂದ್ಸರಿ ನೀವೇನ 21/7/2020 ಲೆಟರ್ ಅಲ್ಲಿ
ಪ್ರಕರಣದ ಆರೋಪಿಯು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ
ಪಿಟಿಷನ್ ಸಂಖ್ಯೆ 2389/2020 ಇದೆಯಲ್ಲ, ಅದು ಈಗ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? ಇಲ್ಲಲ್ಲ.
That is not pending, your lordships.
At
that point of time there was stay and your lordships.
ಸ್ಟೇ ಆಯ್ತು ಮೇಡಮ್, ಅದೆಲ್ಲ ಮುಗಿದೋಗಿದೆ. ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ 20ರಲ್ಲಿ ಆಗಿದೆ ಅದು. ಈಗೇನ್ ನೀವು ಈ ಲೆಟರ್ ರೆಫರ್ ಮಾಡೋದು? ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ? ಈ ಕೇಸ್ಗಳಿಗೆ ನಿಮ್ಗೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಕ್ ಏನ್ ತೊಂದರೆ ಇದೆ? ಅದನ್ನ ನಾನು ಕೇಳಿದ್ ಲಾಸ್ಟ್ ಟೈಮ್.
Subject to the outcome of these petitions, your lordships.
ಏನ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ಔಟ್ಕಮ್ ಮೇಡಮ್? ನೋ ಸ್ಟೇ ಇನ್ ದಿಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಈ ಕೇಸಲ್ಲಿ ಯಾವ್ದಾರಲ್ಲ ಸ್ಟೇ ಇದೆಯಾ ನಿಮ್ಗೆ? ನಾಟ್ ಟು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಅಂತ? Illa. Why you are not conducted the investigation? ಯಾವ್ದು ಹಳೇದು ನೀವು you are dumping the waste to this court. This was 2020 in connection with other petition is concerned. Where is the stay in these cases?
My instructions are that that's this.
Your instruction is not correct, madam. That's what last time I asked you. What prevented you in proceeding the matter? Crime was registered in 2020. What you are doing from 2020 till date?
Holding on to this order, your lordships, they have not done. Stall the investigation.
Alla madam, holding on this order andre ellide madam ee petition no ee petition mostly A1 allow agi quash agi Supreme Court ಅಲ್ಲಿ ಇದೆ.
ನ್ಯಾಯಾಲಯದಲ್ಲಿಯೇ ಎರಡು ಮೊಕದ್ದಮೆಗಳನ್ನು ಭ್ರಷ್ಟಾಚಾರ ನಿಗ್ರಹ ದಳ ಠಾಣೆಗೆ ವರ್ಗಾವಣೆ ಮಾಡಲು ಅನುಮತಿ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿ ಈ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಪಡೆದುಕೊಳ್ಳಲು ಕ್ರಮ ವಹಿಸುವಂತೆ ತಿಳಿಸಲು ನಿರ್ದೇಶಿಸಲ್ಪಟ್ಟಿದೆ.
ಈ 2389 ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? You have to advise the government, madam. You are an additional SPP. You are dumping the record.
I'm not.
Then you are dumping the record. What I directed you to last time? Why you have not conducted the investigation and not filed the charge sheet? You make the submission with regard to the status of investigation in respect of cases registered by the state. Where is the status?
This is what.
This is what ಅಂತ ಹೇಳಿ ನೀವು ನನಗೆ you are an officer of the court.
Please, your lordships.
ಕೊಡ್ರಿ ಅವ್ರಿಗೆ ಅದು ಏನಿದೆ ಅದ್ರಲ್ಲಿ ನೋಡೋಣ. ಹೇಳಿ ಅವರೇನೆ. What I asked last time. You are dumping a letter of the year 2020 when the case was pertains to that is in respect of A1 is concerned. ಹೌದಾ? A1 ಆಗ್ಲೇ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಕ್ವಾಶೋ ಆಗಿದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ. ಯಾರು ನೀವೇನ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ? ಯಾರು ನೀವಾ? ಆ ಪೆಂಡಿಂಗ್ ಅಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಏನು ಡಿಸೈಡ್ ಆಗಿಲ್ಲ. 4 ವರ್ಷ 5 ವರ್ಷ ಆಯ್ತು. ಈ ಕೇಸಲ್ಲಿ when you have registered the case against A2 also in the said crime, only quash was made only in respect of A1. What is the progress by you with regard to these two crimes against this petitioner? That's what I asked you. What is the status of the investigation?
Not done proceeded with the investigation.
Why?
With regard to
No stay. No stay against him. I will impose the heavy cost on the state if that is the case. Why they have not done? Why they have registered the case in crime number 61 and 63?
Since it's matter, but since even Lokayukta had filed a complaint, your lordships.
Lokayukta separate cases, madam. There are 3 cases. They have already argued.
Similar matter, your lordships. Since
Yen similar matter.
Complaint and allegations were also same, your lordships.
Maybe same, madam. Why you have not investigated the matter? Who is your IVO? Who is your IVO? Who is your IVO?
Sub inspector is present, your lordships. IO is not present.
Why you keep him present? You are dumping a letter of 2020 before this court saying that when they have sought for transfer of the case to the Lokayukta, a letter is addressed. That is in respect of the earlier petition filed by A1 is concerned. No stay. This court has not granted any stay in respect of this petitioner is concerned. What prevented you in proceeding the matter? Or otherwise you file a B report or C report. We can relieve them. If no material, you file a B report. No such material. Why you harassing that man?
I have verified, your lordships. They say because of this particular.
If no material, you file a B report.
Please.
Otherwise, you keep the IO. Why he has not done the investigation from 2020 till 25?
Please, I'll keep the IO present.
Cool. SPP submits that. ಏನದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡೋದೇನು? Additional SPP files memo. with letter dated 29/10/2020. ಹಳೆ ಡಸ್ಟ್ ನಮ್ಮ ಕೋರ್ಟ್ಗೆ ಹಾಕ್ತಾ ಇದೀರಿ ನೀವು. And also 12/6/2020. And mainly relies upon the document dated 21/7/2020, wherein reference is made with regard to criminal petition number 2389 of 2020, and the same is not pertaining to this petition is concerned. And also, this document is not relevant to the present petitions are concerned, and hence directed to keep the IO present before the court in the next date of hearing, and IO should make submission with regard to why he has not conducted the investigation in these two crimes and list this matter on 4/12, or otherwise I will pass strictures against him. No stay. Supreme Court ಅಲ್ಲಿ ಏನು ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ, ಏನೂ ಇಲ್ಲ. A1 ಕ್ವಾಶ್ ಆಗಿದೆ. A2ಗೆ you have not conducted the investigation from last 5 years. You kept quiet. Your IO is kept quiet. Then you file, let him file B report if no material. Why you people are harassing him? ಯಾವಾಗ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ 4/12?
This one fast over matter.
ಫಸ್ಟ್ ಓವರ್ ಎಲ್ಲ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
Ravikumar BR.
Yes, madam. Handing over the papers to the appellant. Kodi. Learned counsel for the appellant submit that NOC was given to the appellant. The counsel for the appellant is directed to produce acknowledgement for handing over the papers to the appellant on the next date of hearing. ಕೊಟ್ಟಿದ್ದಾರಾ? The appellant counsel files memo. Date ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ? ಹಾ ಸರಿ, ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು ಇದು? 25 ಅಂದ್ರೆ ನಿನ್ನೆ. ಮತ್ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಹೇಳಿದ್ರಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಪೇಪರ್ಸ್ ಅಂತ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪ್ಲೆಂಟ್ ಸಬ್ಮಿಟ್ ದಟ್ NOC ವಾಸ್ ಗಿವನ್ ಟು ದಿ ಅಪಲೆಂಟ್ ಅಂತ ಹೇಳಿದಿರಿ. ದ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪ್ಲೆಂಟ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ದಿ ಪೇಪರ್ಸ್ ಅಂತ ಮಾಡಿದ್ವಿ. ಯಾವಾಗ ನೀವು ಪೇಪರ್ಸ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿರೋದು ಅವ್ರಿಗೆ? ಮತ್ತೆ ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್? ಯಾವಾಗ ಕೊಟ್ರಪ್ಪ ನಿಮಗೆ ಪೇಪರ್ ಎಲ್ಲ? ಮೊನ್ನೆ, ನಿನ್ನೆ ಎಲ್ಲ ಮೊನ್ನೆ 15 ದಿವಸದಿಂದ ತಗೊಂಡಿಲ್ವಾ? ನೀವು ಯಾವಾಗ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಇಸ್ಕೊಂಡಿದ್ದಪ್ಪ? ನೋ ಅಬ್ಜೆಕ್ಷನ್. ಯಾವಾಗ? ನೀವು ಹೇಳ್ಕೊಡ್ಬಿಡ್ರಿ ಅವನಿಗೆ. ಡೋಂಟ್ ಎಜುಕೇಟ್ ಯುವರ್ ಕ್ಲೈಂಟ್. ನಾ ಕೇಳ್ತಾ ಇದ್ದೀನಲ್ವಾ? ನಿಮಗೆ ಕೇಸು ನೀವೇ ನಡ್ಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ನೀವು NOC ತಗೊಂಡು ಹೋಗಿದೆಯಲ್ಲಪ್ಪ, ಬೇರೆ ಲಾಯರ್ ಇಟ್ಕೋತೀನಿ ಅಂತ. ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ತಗೊಂಡೋಗಿ? 8 ದಿವಸ 10 ದಿವಸ? ಯಾಕೆ ಇಟ್ಕೊಂಡಿಲ್ಲ ಲಾಯರ್ ನಿನ್ನುವೆ? ಇನ್ನು ನೋಡ್ತಾ ಇದೀಯಾ? ಆಯ್ತು ತೋಳಿ. ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಫೈಲ್ಸ್ ಮೆಮೋ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ದಿ ಪೇಪರ್ಸ್ ಟು ದಿ ಹೆಸರೇನೋ ಕುಮಾರ ಅಪಲೆಂಟ? ಇಲ್ಲಲ್ಲ ಮೇಡಮ್, ಏನೋ ಬೋರಯ್ಯ ಅಂತ ಇದೆ. ಇವರು ಇದಾರ ಪಾರ್ಟಿ? ಇವ್ರ ಪಾರ್ಟಿ ಇದಾರೆ ಮೇಡಮ್? ಎಷ್ಟನೇವ್ರು ಹೇಳ್ರಿ? ಅಪಲೆಂಟ್ ನಂಬರ್ ಎಷ್ಟು? ಇಲ್ಲ ರೀ, ಇಲ್ರಲ್ಲಿ ಇರೋದೇ ಒಬ್ರು. ಯಾರಿಗೋ ನೀವು ಮಗನಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ನಾವ್ ಹೆಂಗ್ರಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡೋದು? ಬೋರಯ್ಯ ನಿಮ್ ತಂದೆ, ಇಲ್ಲಿ ಸೈನ್ ಹಾಕಿರೋದು ನೀನು. ನೀನ್ ಹೆಂಗ್ ಸೈನ್ ಹಾಕಕ್ಕಾಗುತ್ತೆ? ಮೇಡಮ್, ಯು ಆರ್ ಅನ್ ಆಫೀಸರ್ ಆಫ್ ದಿ ಕೋರ್ಟ್, ಯು ಹ್ಯಾವ್ ಟು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್. ಯಾರ್ದೋ ಅನ್ನೋನ್ ಪರ್ಸನ್ ತಗೊಬಂದು ನೀವು ಸೈನ್ ಹಾಕ್ಬಿಟ್ರೆ ಮಗನಿಗೆ ಕೊಟ್ರೆ, ಮಗ ವಕಾಲತ್ ಕೊಟ್ಟವನ್ ನಿಮ್ಗೆ? ಕೇಸ್ ಕೊಟ್ಟಿರ್ಬೋದು ಮೇಡಮ್, ಸೈನ್ ಹಾಕ್ತವ್ರ ಯಾರ್ರಿ? ನೀವು ಅವನ್ ಸೈನ್ ಮೇಲೆ ಮಾಡ್ತೀರಾ? ಯು ಆರ್ ಎನ್ ಅಡ್ವೊಕೇಟ್. The counsel files an acknowledgement and the same not pertains to the appellant, and the same is pertains to the son who is present before the court. And he seeks, ಎಷ್ಟು ದಿವಸ ಬೇಕಪ್ಪ ಲಾಯರ್ ಇಟ್ಕೊಳಕ್ಕೆ? ನೋಡ್ತಾ ಇದೆಯಲ್ಲ, 2 ವಾರ. And hence finally given 2 weeks time to engage the counsel. In view of, ಈಗ ನಿಮ್ಗೆ ಅದನ್ನ ನಾನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ತೋಳಿ. And hence the acknowledgement is not accepted and the same is not of the appellant. And in view of the son undertakes to engage the new counsel, 2 weeks time granted. And list this matter on 12/12. If new advocate is not engaged, the appeal will be dismissed in the next date of hearing. 12 dismiss ಮಾಡ್ತೀನಿ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ. ಪ್ರತಿ ಸರಿ ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದ್ ನಿಮ್ಗೆ ಇಲ್ಲಿ ನಿಮ್ ನಾಟಕಕ್ಕೆ ನಾವ್ ಇಲ್ಲಿ ಇದ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕಳ್ಸರಿ ಅವ್ರನ್ನ ಮೊದ್ಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂದ್ರು, ಇಲ್ಲಿ ಏನು ಇಲ್ಲ, ಮಗನ್ ಕರ್ಕ ಬಂದ್ ನಿಲ್ಸವ್ರ ಇವತ್ತು. ಅದರ್ವೈಸ್ ಅಲ್ಲಿ ಇಂಪೋಸ್ ದಿ ಕಾಸ್ಟ್. ಆಗ್ಲೇ ನಿಮಗೆ ಬುದ್ಧಿ ಬರೋದು, ಇಲ್ಲ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ನಾನೇನ್ ಮಾಡೋಣ. ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೆ, ನೀವೇನ ಫಾಲ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿ, ಕೊಟ್ಬಿಟ್ಟಿದೀನಿ NOC ಅಂತ. NOC ಇಲ್ಲ, ಅಕ್ಲಾನ್ಮೆಂಟ್ ಇಲ್ಲ, ಈಗ ಅವನ್ ಕರ್ಕ ಬಂದ್ ನಿಲ್ಸಿದಿರಿ. ಅರ್ಥ ಆಯ್ತು ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೀನಿ. ಅವ್ನ್ ಪಾರ್ಟಿ ಅಲ್ಲ ಮೇಡಮ್. 12/12. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕೇಸಲ್ಲಿ ನೀನ್ ಬಂದಿಲ್ಲ, ನಿಮ್ ಲಾಯರ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ ಅಪೀಲ್. 12. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದ್ರಿ?
43, 44 urgent, 45 Moinuddin, Karat Kumar Shetty.
May kindly be passed over.
ಏನ್ರಿ 3:45 ಪಾಸ್ ಓವರು?
In another court, your lordship, that's right.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನಿದೆ ನೋಡಿ, ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ನಿಮ್ದೇನು ಅಪೀಲ್? PFA ಕೊಟ್ಟಿಲ್ಲ, ಏನಾಗಿದೆ ನೋಡಿ ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಎಲ್ಲ ತಗೊಳ್ಳಿ. ಇವರೆಲ್ಲ ಮಾತು ಕೇಳಲ್ಲ. 2 ಸೂಟ್ ಹಾಕಿದಿರಿ, ಅದ್ರಲ್ಲಿ ಬೋತ್ ಸೂಟ್ಸ್ ಆರ್ ಡಿಸ್ಮಿಸ್. OS 173 of 12 ರಿವರ್ಸ್ ಆಗಿದೆ, ಡಿಕ್ರಿ ಮಾಡಿದ್ದಾರೆ. ಇನ್ನೊಂದನ್ನ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅದನ್ನೇ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. ಆಯ್ತು, ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ PFA ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಟ್ಟೇ ಇಲ್ಲ. ಯಾರು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿಲ್ಲ, ಕೊಡಿ. ಎಲ್ಲಿದೆ ಅಂಡರ್ಟೇಕ್ ನೋಡಿ? ಇನ್ನೊಂದ್ರಲ್ಲಿ ಏನು ಅಂಡರ್ಟೇಕ್ ಆಗಿದೆ ನೋಡಿ. ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 18/9/25. 2 ಕ್ಲಬ್ ಆಗಿದೆ, ಅವ್ರಿಗೆ ಒಂದೇ ಇದೆ ಆರ್ಡರ್ ಶೀಟ್.
Yes sir, ಅದು ಒಂದೇ ಫಸ್ಟ್
ಒಂದೇ ಇತ್ತು. ಕ್ಲಬ್ ಆದ್ಮೇಲೆ ಕೊಡಿ ನೋಡೋಣ. ಅಲ್ಲೇನೋ ಅಂಡರ್ಟೇಕಿಂಗ್ ಇದೆಯಾ ನೋಡಿ. Court wide order dated and directed to secure the records of the sound. So the registry is directed to issue reminder to the counsel. Opponent is directed to serve the copy of the appeal memo on learned counsel for the caveat respond. Learned counsel for the respondent submits that another appeal is also served. ಆಯ್ತು, ಇದಾದ್ಮೇಲೆ ಕಾಮನ್ ಆರ್ಡರ್ ಏನಾಗಿಲ್ಲ. 474 ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದನ್ನ ಲಿಸ್ಟ್ ಮಾಡ್ಲಿಲ್ವ ಮೇಡಮ್ ಇದ್ರ ಜೊತೆ? 467 4 ಒಟ್ಟಿಗೆ ಇದೆಯಲ್ಲ. ಎಲ್ಲಿದ್ದಾರೆ ಅಂಡರ್ಟೇಕಿಂಗ್? ಯಾವತ್ತಿದೆ ಅಂಡರ್ಟೇಕಿಂಗ್? ಅಂಡರ್ಟೇಕಿಂಗ್ ಎಲ್ಲಿದೆ ಅಂತ ನೀವೇನ ಈಗ ಅಂದ್ರೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡ್ರಂತವ್ರು ನೀವೇ ಟೈಮ್ ಕೇಳಿದಿರಿ ಲಾಸ್ಟ್ ಟೈಮ್. When both the matters are clubbed together on 11/11/25 at the request of the learned counsel for the appellant, list these matters on 26/11/25 ಅಂತಿದೆ. ಇವತ್ತೇ 26. ಎಲ್ಲಿದೆ ಅಂಡರ್ಟೇಕಿಂಗ್? ಏನ್ರಿ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಾ ನೀವು? ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಇದಿರಲ್ಲ, ಅದು ಸೇಮ್ ಕಾಮನ್ ಏನ್ ನೋಡಿ. ಮಾಲೇಶ್ ಗೌಡ ಸಿನ್ಸ್ ದಿಸ್ ಇಸ್ ಬೈ LRs. ಈ LRs ಯಾರಿಗ ಹಾಕಿದಿರಲ್ರಿ ನೀವು? ನೀವು ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಯಾಕೆ PF ಕೊಡ್ಲಿಲ್ಲ? ಅದು ಆರ್ಡರ್ ಆಗಿರೋದು 18/9/25 ಅಲ್ರಿ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಬಂದಾಗ 27/10 ಹೇಳಿದಿರಿ ಇನ್ನೊಂದು ಅಪೀಲ್ ಇದೆ ಅಂತ. ಅದ್ಯಾಕೆ PF ಕೊಡ್ಲಿಲ್ಲ ಅದ್ರಲ್ಲಿ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಮೇಲೆ? ಅದನ್ನೇ ಕಥೆ ಹೇಳ್ತಾನೆ. ಏನ್ರಿ ಮಾಡ್ತೀರಾ ನೀವು ಇಲ್ವಾ?
ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
ಪಾಸ್ ಓವರ್ 46 ವಿಜಯ್ ಕುಮಾರ್ R ಜಯರಾಜ್ DS ಪ್ಲೀಸ್. Hmm? Further, it is held that the defendant is directed to hand over the possession of the suitable property to the plaintiff within a period of 2 months from the date of this order. Huh? Huh? Not maintainable ಅಂತ. ಯಾಕೆ ಮೇಂಟೈನಬಲ್ ಅಂತ ಹೇಳಿದ್ರು ಅದನ್ನ ಹೇಳ್ರಿ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಯಾಕೆ ಹೋಗ್ತಾರೆ? ನೀವು ಸೆಕ್ಷನ್ 6 ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿರೋದ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಮ್ಮ ತಂಗಿದ್ದಾಗ ಹೆಂಗ್ ಬರುತ್ತೆ ನಿಮ್ಗೆ? ಹಾ ಹೌದು. ಬಟ್ ವಾಟ್ ಇಸ್ ದ ರಾಂಗ್ ಇನ್ ದಿ ಆರ್ಡರ್? What is the error in the order on that? Whether the present regular appeal is maintainable before this court on section 96 of appellate. So whether the trial court was justified in declaring the suit of the plaintiff by holding that proved the dispossession by the defendant. ಹೌದು, ಡಿಸ್ಪೋಸೇಷನ್ ಆದಾಗ ಸೆಕ್ಷನ್ 6 ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ. ಹೌದಾ? ಸೆಕ್ಷನ್ 6 ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ. ಆವಾಗಿದ್ದಂಗೆ ಮತ್ತೆ ನೀವ್ ಹೆಂಗ್ ಮೇಂಟೈನ್?
Lordship, may I kindly see the judgment 98 Supreme Court.
ಕೊಡಿ ಏನು? ಸಮರಿ ಸೂಟ್ ತಾನೆ?
ಹೌದು, ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಸೆಕ್ಷನ್ 6 ಅಲ್ಲಿ. ವಿ ಸೇ ದಟ್ ವಿ ವರ್ ಇನ್ ಪೊಸೆಷನ್, ದೇ ವರ್ ನೆವರ್ ಡಿಸ್ಪೋಸೆಸ್ಡ್. Sale deed is there in my favor. I purchased the property under a sale deed. Kindly see para 3, my lord. That answers the question. Therefore, the appeal is maintainable. Matter needs to be remanded back to the first appellate court.
It is well settled that any statutory provision barring an appeal or revision cannot cut across the constitutional power of a high court. Even the power flowing from the paramount charter under which the high court functions would not get excluded unless the statutory enactment concerned expressly excludes the appeal under letters patent. No such bar is discernible from section 6(3) of the act. It could not be seriously contended by learned counsel for the respondent that clause number 15 of the letters patent is invoked, then order would be applicable. Consequently, in our view, on the clear language of clause 15 of the letters patent, which is applicable to Bombay High Court Act, the said appeal was maintainable as the order under appeal was passed by the learned single judge of the High Court exercising original jurisdiction of the court. This is in case of original jurisdiction is concerned.
Now, so far as we are concerned, we are also bound by the High Court Act, which says appeal is maintainable. Appeal is
reason in court. First appellate court reasons court.
First appellate court para 25 onwards. That's the only reason. Kindly come to para 25 and 26. That's right.
Reasons.
ಬೇರೆ ಏನು ಹೇಳೋದಿಲ್ಲ. They refer to a judgment which arose under a interlocutory order, which is not even applicable. Para 25 to 29, that's only order. Merits, they don't go into the merits. But unfortunately, point number 3 is answered. Merits ಮೇಲೆ ಹೋಗ್ತಾರೆ ಮತ್ತೆ. Appeal not maintainable ಅಂತೇಳಿ merits ಹೋಗೋದು ಮತ್ತೆ. Ignore the sale deed, my lord. Trial court ignore the sale deed. Sale deed under which I am put in possession, and RTC is produced. By the time RTC was produced, the land had been converted. Exhibit.
Sale deed
ಅವರೇ ಪ್ಲೇಂಟಿವ್ಸ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿರೋದು. ಪ್ಲೇಂಟಿವ್ಸ್ ಅವ್ರ ತಾಯಿ ಎಲ್ಲ ಸೇರಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಕೊಟ್ಟಿರೋದು. But your lordships will get from the trial court judgment. My lords kindly come to pay. ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. ಎಕ್ಸಿಬಿಟ್ D3 ತಗೊಳ್ಳಿ ದಯಮಾಡಿ. ಎಕ್ಸಿಬಿಟ್ D9 ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಅದನ್ನು ನೋಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ. Land is converted, my lord. Exhibit D6, land is converted. D9 is the sale deed. Then, my lord, form number 15 ನಲ್ಲೂ ಕೊಟ್ಟಿದ್ದಾರೆ exhibit D10. Then your lordships will go to the conversion order exhibit D16. ಇದನ್ನೆಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು RTC ಯಾವ್ದೋ ಕೊಟ್ರೆ ಅದ್ರ ಮೇಲೆ ಬೇಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಧೀನದಲ್ಲಿ ಅವರು ಇದ್ರು ಅಂತ. They create an artificial cause of action by the suit under section 6 without showing that they were in previous possession. Suit is filed under Order 7, Rule 1. Appeal provision, I quote section 10, so far as
What is your defense in the return statement?
Return statement is I am the owner of the property, I am in possession. Earlier suit also
What is their claim?
their claim is that they don't refer anything to the sale deed at all. And ultimately they ask for a declaration that the sale deed is not binding and all that.
No, I have not sought for declaration.
See, you have sought for declaration,
Not
not
sought for
about your title. Title is,
I have not sought for declaration.
yes. Go to single judge. What is for recovery of possession, man? That's it. Not for declaration.
For declaration.
They don't seek for declaration of their title, which is denied by me. And second appeal, first appeal to section 5 ಬರುತ್ತೆ. ಅದೇ first appeal jurisdiction ಅಲ್ಲೇ ಡಿಫೈನ್ ಆಗೋದು. Single judge and a division bench is equivalent to clause 15 of the Federal Patent Act.
ಹೇಳ್ರಿ ಏನ್ ನಿಮ್ ಸೇಲ್ ಡೇಟ್ ಇದೆ?
Please, plus before I read section 6(3), plus your lordships may kindly see para 13 where a finding is made. This is a suit under section 6. I'm only seeking recovery of possession. But facts being admitted is my mother was granted the land way back on 30th April 1975 by the AC as per the Village Officers Abolition Act. Lord, she died on 8th April 2016. Thereafter, plaintiffs are in possession, cultivating the land. It is an agricultural land. Yes, 8th April 2016. Thereafter, my lords, I am in possession. That is the plaintiff, along with my younger son. My lords, your lordship may kindly see even my plaint governments
that the defendant was well associated with my mother. That's the plaintiff mother. But the defendant was nowhere in town because her husband was working as a BDO and it was a transferable job. Only in the year 2020-21, there is a trespass. As I specifically averred in my plaint. Your Lordship may kindly see para 13 of the judgment rendered by the Honorable Trial Court. Keeping in mind of rival side pleadings as well as admitted facts, I would like to go through the records to know whether the plaintiff was in peaceful possession and enjoyment over the suit scheduled property before trespassed him over the suit scheduled property by placing cogent and reliable evidence. In order to substantiate the same, the plaintiff himself examined as PW1 and in support of his oral evidence, and he got produced exhibit P1 to P23. On perusal of the exhibit P10 to P12, it reveals that this plaintiff is in peaceful possession and enjoyment over the suit scheduled property. The exhibit P10 to P12 RTCs of the plain scheduled property, which gives strength to the case of the plaintiff. According to section 133 of Karnataka Land Revenue Act, there is a presumption regarding entries in the revenue records. Any entry in the record of rights and a certified entry in the register of mutations or in the Pata book shall be presumed to be true until the contrary is proved or a new entry is lawfully substituted thereof. On perusal of exhibit P10 to 12, it is crystal clear that plaintiff was in possession and enjoyment of the suit scheduled property as on the date of presentation of suit. There is nothing on record is produced by the defendant to rebut a presumption under section 133 of the Karnataka Land Revenue Act. The entries in the revenue records have presumptive value to the extent that the entries made therein are correct. Defendant has not chosen to rebut the said entries, hence entries in the revenue records presumptive value stands established. This itself sufficient to draw an adverse inference against the defense set up by the defendant. Further, the defendant has not challenged the revenue entries, revenue records standing in the name of the plaintiff. If at all the defendant is having any right, title or interest over the suit scheduled property, he will not sit numb in all these years without questioning the plaintiff's documents. Their cases on the basis of sale deed. Whereas my cases, I'm in possession of the property. And as per section 6, I'll only have to establish that prior to expiry of 6 months, as on the date of presentation of the suit, I am in possession.
You ಸೇಲ್ ಡೀಡ್ ಮೇಲೆ ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ?
ಕನ್ವರ್ಷನ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು. ಕನ್ವರ್ಷನ್ ಆಗಿತ್ತೆ. ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಎಕ್ಸಿಬಿಟ್ D6. ಕನ್ವರ್ಷನ್ D6 ಇದೆಯಲ್ಲ?
ಏನ್ ಹಾಕಿದ್ರಿ ದಾಖಲೆ?
D6 ಇದೆ.
D6
ಹೌದು. ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಕೊಟ್ಟಿತ್ತು. Your Lordship will kindly say that the presumption rebut because it is no longer a agriculture land. Your agriculture land ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. But by then it had lost its characteristics. Conversion order exhibit D16 ತಗೊಳ್ಳಿ.
ಯಾವಾಗ ಆಗಿದ್ದು ಕನ್ವರ್ಷನ್?
ಅದು ಮೊದಲೇ ಸೇಲ್ ಡೀಡ್ ಆಗಕ್ಕೆ ಮುಂಚೆ 83 ಮುಂಚೆನೆ.
ಸೇಲ್ ಡೀಡ್ ಆಗಿದ ಮುಂಚೆನೆ?
ಹೌದು. 83 ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಆಯ್ತು. ಅದಕ್ಕೆ ಮುಂಚೆನೆ ಆಗಿತ್ತು.
ಕನ್ವರ್ಷನ್ ದಾಖಲೆ ಹಾಕಿದೆ?
ಹೌದು ಹೌದು ಹಾಕಿದೆ. ಎಕ್ಸಿಬಿಟ್ D16 ಹಾಕಿದೀವಿ. D16 16.
ಯಾವ ವರ್ಷ ಆಗಿರೋದು ಅದು?
ಒಂದು ನಿಮಿಷ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬಂದಿದೆ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್.
ಹೌದು ಹೌದು.
ಯಾವ ವರ್ಷದ್ದು ಅದು?
ಒಂದೇ ಒಂದು ನಿಮಿಷ. ಮೊದಲೇ ಆಗಿತ್ತು ಅದು. ಅವ್ರ ತಾಯಿ ಬದುಕಿದ್ದಾಗಲೇ ಅವರೇ ಮಾಡಿಸ್ಕೊಟ್ಟಿದ್ರು. ಅದಾದ್ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡೋದು.
ಅದ್ರಲ್ಲಿ ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಕನ್ವರ್ಟೆಡ್ ಹೇಳಿದಾರಾ?
ಹೌದು.
ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಕನ್ವರ್ಟೆಡ್ ಅಂತ?
ಎಸ್. ಯಾವುದು? ಹೌದು. ಒಂದು ನಿಮಿಷ. ಒಂದು ನಿಮಿಷ. ಬೇಡ ಬೇಡ. 28/10/83 ನಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ. 28/10/1983 ನಲ್ಲಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಹೌದು ಆರ್ಡರ್.
ಸೇಲ್ ಡೀಡ್ ಆಗಿರೋದು 21/11/1983.
ಹೌದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಅದು.
ಹಿಂಗೇನ್ರಿ ಕನ್ವರ್ಟೆಡ್ ಪ್ರಾಪರ್ಟಿ ಹೌ ಕ್ಯಾನ್ ಯು ಪ್ಲೀಡ್ ದಟ್ ಇಟ್ ಇಸ್ ಅನ್ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್?
ಆಮೇಲೆ ನಾನು ಕಂದಾಯ ಕಟ್ಟಿದ್ದೀನಿ ಪಂಚಾಯತಿಗೆ.
ಆಲ್ಸೋ ನೋ ಡಿಸ್ಕಷನ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಸೇಲ್ ಡೀಡ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಕನ್ವರ್ಟೆಡ್. Nothing. Maybe you have invoked section 6, but when there is a dispute with regard to the title is concerned, whether the same could be invoked.
The very fact
property was converted and then sold. That to extent of 91.7 feet into 46 feet.
Only in respect of 8 guntas. 8 guntas. Total property is 28 guntas. 8 guntas. Plus, I'm only saying, even there are cattle, there are about agricultural products, agricultural implements are there. All that is still there, even as of today.
But you only sold the property after converting the property for non-alienation. for non-other purpose and sold it immediately after the conversion. Conversion was made in the month of October and you have sold the property on 21/11/1983.
The party to the sale deed. He is a party to the sale deed.
No, even as per
Also is a party to the
grant-
sale deed.
No, it was.
How can you suppress and get an order by invoking section 6?
It was in fact, my lords, a granted land.
Order the appellant counsel.
One
and
other
also the
aspect, my lords,
counsel-
I will only place on record, one other aspect.
Yes.
Appeal not maintainable on that aspect. They in fact file a caveat prior to institution of the suit. Defendant files a caveat as against the plaintiff. My only case is, my lords, there is the trespass as against my property while I was not in town. Place on record only
Can
two
you
judges.
say that that is your property when you have executed a sale deed in the year 1983 itself? That to a property was converted and thereafter you sold the property in favor of the appellant. How can you claim that that property belongs to you on dispossession when the possession was delivered in terms of the sale deed in the year 1983 itself? How
No,
you
I'm
can
only
plead
saying
that
it
it is
could
a
have.
dispossession and you
If
suppress
he's,
the fact
no, if
and
he
filed a
has,
suit.
if he has produced documents, he had to establish case by leading cogent evidence. I'm only saying.
I'm not deciding on merits. I will frame a substantive question of law.
I'm only placing on record this judgment because appeal itself is not maintainable. Your Lordship, so kindly see para 40, para 16. Of course, this was insofar as.
Depends upon factual aspects of the case. I know section 6 also. Section 6
Six.
scope is very limited.
Section 6(3).
Within 6 months, they have to.
Yes, I have to show my possession.
Got to file, but you have filed. But you have filed stating that you are the owner. You have been dispossessed wrongfully, but actually you are not the owner. You have executed the property in the year 1986-83 itself. That too converting the property for non-agricultural purpose and sold it by 91.7 feet into 66 feet.
I admit that there is no finding insofar as in both the courts. I admit that. Kindly see para 16 for a moment.
Even
Yes,
when the specific defense was taken.
Yes.
By the trial court not discussed.
I'm admitting that. I'm saying, my lords.
Anything is not
There is no discussion.
How
There
can
is
the
no
court
finding.
Then how can court can invoke section 6?
Your Lordship, kindly see one, because he is supposed to file CRP is what I'm saying, my lords. Para 16, Your Lordship, may kindly see in the judgment, in the case of Mohammed Matab, para 16, it was on the interrogatory application itself. A proceeding under section 6 of the Specific Relief Act 1963 is intended to be a summary proceeding, the object of which is to afford an immediate remedy to an.
Yes. Judgment ne trial court to refer ಮಾಡಿ
ಇನ್ನೊಂದು judgment
very
ಕೊಟ್ಟು.
same judgment.
ಇನ್ನೊಂದು judgment ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
ಹೇಳಿ ಅದು.
In the case of Jaswant Singh.
ಇದೇ judgment
ಹೌದು.
appellate courtನವರು.
ಹೌದು, correct. That's right. Kindly see one more judgment I have given. It's only one page. Jaswant Singh. Lordships may turn over the page. Order anta ide. Delay condoned. Permission to file a special petition is granted. Delay in filing substitution application is condoned. Abatement is set aside. Application for substitution is allowed. Heard the learned counsel appearing for the petitioner. We find no merit in the special leave petition. The special leave petition is accordingly dismissed. However, it is surprising that in a section 6 suit, appeals have solemnly been filed and heard on merits. What is even more surprising is that from the first appeal dismissal, a second appeal is also filed and dismissed. We need to remind the courts below that section 6(3) of the Specific Relief Act 1963 shows that the remedy under section 6 is summary in nature and that no appeal lies.
That's all. Third. Heard the appellant counsel and also the counsel appearing for the respondent. The trial court considered the suit when the suit is filed under section 6 and granted the relief, and the same is challenged before the appellate court, and appellate court dismissed the appeal in coming to the conclusion that under section 6(3) of the act, the appeal is not maintainable. And hence, the second appeal is filed before this court. The main contention of the counsel appearing for the appellant that though suit is filed under section 6 and section 6 scope is very limited, when the owner of the property is dispossessed, suit can be filed within 6 months. But specific defense was taken that very plaintiff and other family members have executed a sale deed in the year 1983 in respect of the very property.
Exhibit D9.
And
Exhibit D9, madam.
Exhibit
D9.
D9, and possession was also delivered, and the possession is legal, and no such any illegal dispossession as claimed by the plaintiff. And counsel also submits that suit is filed claiming that the same is an agricultural property, but the same is not the agricultural property, and before selling the property, it was converted and then sold the property in favor of the appellant.
Exhibit D16, madam.
And the same is Exhibit D16, and hence the trial court ought not to have entertained the suit under Section 6. The counsel, in support of his argument, relied upon the judgment AR 1998 Supreme Court 424, wherein a discussion was made when the order passed by single judge under Section 6 decreeing the suit and bar to appeal and revision contained in Section 6(3) does not apply to letters patent appeal. And counsel, referring paragraph number 3, would contend that it is well settled that any statutory provision barring an appeal or revision cannot cut across the constitutional power of a high court. Per contra, the counsel appearing for the respondent would submit that when the suit is filed invoking Section 6, and the trial court also discussed the material on record, that too on merits only, granted the relief. And when the proviso under Section 6(3) is not, under proviso under Section 6(3) is very clear that no appeal lies, and the same was taken note of by the first appellate court and dismissed as not maintainable. The counsel also relies upon the judgment 2013 within bracket 9 Supreme Court cases 221, and the said judgment is also referred by the first appellate court. The counsel also relies upon the judgment 2018 Supreme within bracket SC 1597, and also brought to notice of this court paragraph number 6 and 7, wherein also Apex Court reminded the courts below that Section 6(3) of the Specific Relief Act 1963 shows that remedy under Section 6 is summary in nature and that no appeal lies. Having heard the appellant counsel and also the counsel appearing for the respondent, and also considering the material on record, particularly when the suit is filed invoking Section 6, that the plaintiff was dispossessed, and when the specific defense was taken that very plaintiff and his family members have executed a sale deed in the year 1983 and possession is delivered legally in terms of the sale deed, and the same ought to have been taken note of by the trial court while invoking Section 6, and such finding is not found. And even also first appellate court, without discussing the same, pressed into the service of Section 6(3) and held that appeal is not maintainable. And when such being the case, when the appellant also claiming the right and title based on the sale deed executed by the plaintiff and their family members in the year 1983, and possession was also delivered long back in the year 1983, and also records disclosures in terms of Exhibit D9 and also Exhibit D16. Property was converted for non-agriculture purpose and sale deed was executed, but plaintiff contend that it was a agriculture land and sought for the relief, and all these factors were not taken note of by the trial court as well as the first appellate court, and hence held without considering the matter on merits that appeal is not maintainable. Hence matter requires reconsideration. Admit the following substantive question of law arises for the consideration of this court: whether the trial court committed an error in granting the relief as sought invoking Section 6 of the Act, even though specific defense was taken that there was a sale deed in terms of Exhibit D8, D9, and also a conversion order in terms of Exhibit D16 as the property was not the agricultural property as contended by the plaintiff, and it was converted and then sold. Whether the first appellate court committed an error in invoking section 6(3) that no appeal shall lie and the same is a bar in view of section 6(3) of the Act, and whether such finding amounts to perversity without considering the matter on merits as contended by the appellant. That's all, two issues. Records
whether appeal is maintainable ಅನ್ನೋದು ಒಂದು
ಆಯ್ತು. Whether the appellate court rightly held that appeal is maintainable, or appeal is not maintainable in view of section 6(3) of the Act.
Great.
Records are received and hence no need of filing of paper book.
Interim order be extended.
List the matter for 12/12. Interim order idea. Interim order granted earlier is extended till next date of hearing.
Great.
47 already urgent. 48 Jay Prakash RV.
Plaintiff's appeal. Suit for bare injunction in respect of the suit schedule property. The plaintiff had taken this property on license basis from the defendant. It was a vacant site at that time. He took this property for the purpose of construction of a woodcraft industry, and he put up construction also of a permanent nature on this property. During COVID period, he fell in arrears of rent, and the defendant started interfering with the possession of the plaintiff. At that time, this suit for injunction was filed. The defendant in that suit filed a counterclaim seeking possession of the property and also arrears of license fee. The trial court, before the trial court, there was no dispute with regard to the fact that it was a license. But the trial court had framed certain issues. I request your lordship to kindly see paragraph, page 45. Page 45. Facts. It is
Facts issues ಬಂದ್ಬಿಡಿ page 50. In page 50.
First issue is whether the plaintiff proves that he is in possession of the suit schedule property as per the oral lease agreement between himself and the defendant. The court, this issue does not arise for consideration on the basis of the pleadings. Your lordship may kindly see that is the reason why I showed page 45.
What is the pleading of the plaintiff?
Pleading. The plaintiff submits that the defendant is the owner. The plaintiff is licensee of the said property, and by virtue of license granted through written document dated 11/2/2015, he is running woodcraft business in the suit schedule property. That is the averment in the plaint. And in the written statement, it is admitted.
That is the reason only issue number 1 was framed, because you have pleaded that you are in possession of the property based on the
license. Not at a question of proving tenancy does not arise at all.
The tenant's oral lease agreement.
Then the defendant in the written statement admits this. Page 47, the defendant filed the written statement denying the possession of the plaintiff as tenant and also ownership to business which was established in the suit. The defendant admitted that there was license among himself and plaintiff through an agreement dated so and so. The issue, the first issue does not arise for consideration at all. Now, this is one aspect of the matter. When it is admitted under the Easements Act, section 60B may kindly be seen, madam. Section 60B, if it is a license, and on the basis of that license, if a construction of a permanent character is made on the suit schedule property, that becomes an irrevocable license. Section 60B may kindly be seen. 60, a license may be revoked by grantor unless it is coupled with transfer of property and such transfer is in force. I request your lordship to kindly have a look at section 60. Easements Act. The licensee acting upon the license has executed a work of a permanent character and incurred expenses in the execution. Now, my lord, the trial court dismissed my suit and allowed the counterclaim and directed delivery of possession and along with the arrears of license fee.
Because they have claimed the counterclaim.
Pardon?
There is a counterclaim also.
The defendant had filed a
Counterclaim also allowed.
allowed.
But you are squatting on the property without payment of rent.
No, my lord, that is there.
Matte that is there antandre?
No. So far as counterclaim is concerned, my lord, one thing my lord, he has claimed.
There is an understanding between the parties, and also they have given the permission. License was given to put up a construction.
Yes.
But you have constructed.
Yes.
But you are enjoying without payment of any rent.
No, my lord, so far as license fee is concerned, my lord, what can be claimed is a license fee, arrears of license fee for a period of 3 years. My lord, it comes to, even according to the defendant, what was agreed was 1,500 rupees at that point of time. My lord, it comes to 54,000. Now decree is passed for 87,000. That is not permissible.
Maybe including interest.
Pardon? No.
Maybe including interest.
No, my lord, the claim is not including
what
interest.
would be the arrears? 1,500 rupees since
for 3 years.
7 to 18.
Yearly 18,000. For 3 years, it comes to 54,000. But what is awarded is 87,000.
Yeah, why it was
with
difference?
interest?
Why it was difference anta kelide?
That difference is because the defendant had claimed that much, that is allowed.
87,000 ಮಾಡಿದಾರಲ್ಲ ಇಲ್ಲಿ. After deducting the said amount, the arrears comes to rupees 87,000. Para 26 ಅಲ್ಲಿ ನೋಡಿ.
Yes.
On the basis of admitted rentals and due period.
That
if it is put for calculation.
Yes, my lord, that
would
can be
comes to
claimed
around
only for a period of 3 years.
90,000.
My lord, whatever arrears, that can be claimed only for a period of 3 years,
The defendant
not
himself
beyond that.
stated in the written statement, paragraph 18, that on 15/5/2000, the plaintiff has made payment of an amount of 3,000 towards the rental arrears. After deducting the said amount, up to till date, counterclaim.
That is 3,000 had been paid.
Howdu.
What was claimed was 87,000. That is granted.
You made the payment on 15/5/2019, 3,000. Howda?
Howdu.
You have acknowledged.
Yes.
The arrears. Howda?
If it is taken as acknowledgement. No, my lord, that payment.
Counsel.
I am not much against it.
Not kanunu, matu dharma. You have taken the premises, agreeing to pay the
but eviction,
rent of rupees 1,500. For a period of 3 years, you have not paid anything. When he
that was during.
And also you approaches the court for the relief of permanent injunction against them.
Because he started interfering with my possession, that I had to file this.
ನೀವು ದುಡ್ಡು ಕೊಡದವ್ರು ಇನ್ನೇನ್ ಮಾಡ್ತಾನೆ ಮತ್ತವನು?
ಅಲ್ಲ ಈಗ ಡಿಕ್ರಿ ಆಗಿದೆ if it is confirmed. But so far as possession is concerned.
Squatting on the property without payment of agreed lease amount.
No, so far as possession is concerned, my lord, license has become irrevocable. Under section.
Possession cannot be.
Yeah, that cannot be done.
In favor of you, once you have violated the terms of the document. That's why they have claimed.
No, my lord, that document is not considered at all.
Counterclaim ideyalla. What is their counterclaim relief?
Counterclaim is for possession and also arrears.
That's what.
So far as possession is concerned.
Because you failed to pay the amount, that's why they claim the counterclaim. That's all.
No, my lord, so far as possession is concerned, when I have put up.
Counsel, this court will not encourage such people.
No, my lord, one judgment in this regard. So far, section 60B.
Judgment code, it applies. Each facts of the case.
Section 60B on the admitted facts.
Section 60B will not give all right to you squat on the property without payment of rent.
No, paragraph.
Agreed rent.
Paragraph 9 make Paragraph 9 of the judgment. This is 87 Supreme Court.
Yes.
License as defined by section 52 of the Act means grant of permission by a person to the other, a right to do or continue to do in or upon the immovable property of the grantor, something which would, in the absence of such right, be unlawful. Such right does not amount to an easement or any interest in the property. The right so conferred is license. The grant of license may be express or implied, which can be inferred from the conduct of the grantor. Section 60 provides that a license may be revoked by the grantor unless it is coupled with a transfer of property and such transfer is in force. The licensee acting upon the license has executed a work of permanent character and incurred expenses in the execution. A revocation of license may be express or implied. Section 62 enumerates circumstances on the existence of which license is deemed to have been revoked. One of such conditions contemplates that where license is granted for a specific purpose and the purpose is attained or abandoned, or if it becomes impracticable, the license shall be deemed to be revoked. Section 63 and 64 deal with licensee's right on revocation of license. These are all the provisions. Then para 10 maintained. In their pleadings, the defendant had invoked the protection of both clauses of section 60 of the Act. Firstly, they pleaded that the license was coupled with transfer of property inasmuch as the school had been realizing rent from third parties who were permitted to use a portion of the land. Secondly, they pleaded that the license, namely the school, had executed permanent construction and incurred expenses in execution thereof, acting on the license. The trial court as well as High Court both rejected the respondent's claim of license being irrevocable under section 60A of the Act, but they upheld the respondent's plea of license being irrevocable under clause B of section 60 of the Act. It is true that the pleadings raised in the written statement of defendant did not expressly use the expression that the school had executed work of permanent character, acting upon the license. But reading the entire written statement, one cannot escape the conclusion that the defendants had raised the plea that Rajaram Kumar Bhargava, the grantor of the license, had granted license for running the school in the building and for using the open land for the purpose of school. And in pursuance of the license so granted, the school had executed work of permanent character and incurred expenses in making the same. The defendant further pleaded that no objection had been raised by the grantor of the license or by anyone else against the school in making the construction. Repeated assertions have been made in their written statement that Rajaram Kaur had granted a permanent license which was irrevocable. Then just last 8 lines after discussion, the result is that the respondents acting upon the license had executed works by incurring expenses which rendered the license irrevocable. As regards evidence of, we have produced the statement of so and so, so and so. So holding the...
Your license is irrevocable?
Yes.
Irrevocable?
Yeah, irrevocable.
Only for a period of 6 years?
Yeah, yes.
For a period of 6 years?
Yes, if it is granted, if a construction of a permanent character is made on the property,
Only pleaded for a period of 6 years, not for permanent. You have pleaded in the plaint for a period of 6 years.
In the pleading, it is stated that it was for a period of 6 years.
For a period of 6 years.
That has expired. No,
For a period of
my
6 years,
submission to you, notwithstanding the
said rental amount was enhanced from year to year. The current rate of rent per month is 1,500. The plaintiff has paid the rental amount since 2018 consistently during the COVID-19 lockdown. He had not paid the rentals, and after lifting out of the lockdown, the plaintiff approached the defendant for clearance of rental arrears.
Yes, pleading is like that. 6 years anta bardiyare. But even that license becomes irrevocable if a construction of a permanent character is made on that property. That is paragraph 15 of the...
Maybe constructed the building permanent in nature, but you have failed to pay the rent as agreed.
But on that ground, it cannot be revoked.
Notice terminated your tenant's license and filed the
No.
counterclaim.
What is terminated is a tenancy, not under section 105. That is what is stated. So far as license is concerned, license is not terminated. But paragraph 15 of the judgment, only three or four lines. I will read. Paragraph 15. In the middle, if a person, your lordship,
Yes.
if a person allows another to build on his land in furtherance of the purpose for which he had granted license, subject to any agreement to the contrary, cannot turn round later on to revoke the license. This is
ನಿಮ್ ಲೈಸೆನ್ಸ್ ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೆ?
that is for a period of 6 years commencing from that is what is stated in the plaint also.
ಅದೇ ಎಷ್ಟು ವರ್ಷ?
From 11 to 2015, 11 to 2021 ಗೆ ಮುಗಿದಿತ್ತು.
21 ಆಗುತ್ತೆ ಅಷ್ಟೇ. ನೀವು ಸೂಟ್ ಹಾಕಿದ್ದು ಯಾವಾಗ?
ಅದಾದ್ರ ಮೇಲೆ 21/4/2021. After expiry.
But even you have not paid the rent from last 3 years.
Last three years rent ಮಾತ್ರ ಆಯ್ತು.
Even a period of 6 years was also elapsed.
No, during
no
1920.
No subsistence of your license also. No case. Told.
Yes.
Heard the appellant counsel. This matter is listed for admission. These matters are listed for admission. These two second appeals are filed against the concurrent finding. The factual matters of case of appellant before the trial court while seeking the relief of permanent injunction. It is contended that defendant is the owner of the suit scheduled property. The plaintiff is licensee of the said property by virtue of a license granted through written document dated 11/2/2015 for a period of 6 years. That comes to an end on 11/2/2021, and he is running woodcraft business in the scheduled property. Full stop. As per the terms of license, the plaintiff construct permanent structure of building in the suit scheduled property for the purpose of woodcraft business. It is also stated that monthly rent was at ₹701 and same will be announced from certain period, and it is currently ₹1,500 per month. The defendant agreed that he would pay the cost of structure after the termination of license period or completion of license period, to the plaintiff. In view of the COVID-19 pandemic, the license period was orally enhanced by the plaintiff and defendant. The plaintiff had paid the rent every month. It is also contended that the defendant without any reason came to the suit property on 17/4/21 with KB person in order to cut down the electricity supply, which would have been taken for the woodcraft industry. The same was done in order to harass and thereby to see that plaintiff should vacate and hand over the suit property. The plaintiff invested an amount of ₹5 lakh in the woodcraft business, and due to COVID-19 pandemic, he had no earning in such 1 year period. The defendant, without taking care of legal aspects, gave pinpricks to the plaintiff in order to harass him, and hence filed the suit seeking the relief of permanent injunction. In pursuance of the suit summons, defendant appeared and filed written statement contending denying the possession of plaintiff as tenant and also ownership to Madani Woodcraft business, which was established in this scheduled property. The defendant admitted that there was license amongst himself and plaintiff through an agreement dated 11/2/2015. It is also contended that, and the same is an unregistered document, and the same is covering the period for rent more than 11 months. Therefore, said document is of no legal consequences in the absence of registration, as it is compulsorily registrable document. The other contention is taken in the written statement that the structure of plaintiff is temporary. The plaintiff had continued his woodcraft business at his property bearing Panchayat property number 3588 of Sante Bennuru village, and that too after the date 11/2/2021, The plaintiff has purposefully not produced the license in order to misguide the court. And said property is situated nearby this suit property. The plaintiff, with an intention to gain wrongfully, is avoiding and handing over the vacant possession of the suit property and remained it in possession illegally. It is also contended that in terms of the agreement dated 11/2/2015, that structure put up by the plaintiff has to be left as it is to the defendant. The rate of rent was also enhanced to rupees 1,500 from 11/2/2018, and the plaintiff paid rupees 3,000 only on 15/5/2019. Thereafter, he had stopped the payment of rent on the mutual understanding that the rental amount has to be adjusted towards the cost of structure, which would be by the plaintiff. The plaintiff has also agreed to pay the remaining amount of rent 11/2/2021. The plaintiff filed the suit without any cause of action and hence prayed that plaintiff has no right to remain in the suitable property as tenant, and therefore the suit is not tenable in the eye of law. The defendant also made the counterclaim contending that the plaintiff had agreed to pay an amount of rent of rupees 1,500 per month as rental amount. He had not paid the said amount since 11/2/2018 till filing of the suit and the counterclaim. Even after filing of the suit also, the plaintiff has not been paid the rental amount as agreed. The defendant in need of suit property, and as such he approached the plaintiff with a request for vacant possession of the same. When the plaintiff has not come forward to hand over the vacant possession of the property, got issued the termination of notice dated 16/6/9/21 and thereby terminated the tenancy of defendant from 1/10/2021, and said notice came to be served upon the plaintiff. Even after also the plaintiff has not vacated and handed over the premises. After terminating it, the plaintiff has no legal right to continue the possession in and over the suitable property, and he is in arrears of rent of rupees 87,000 from 11/2/2018 till filing of the counterclaim, and hence prayed the court to grant the counterclaim. When the counterclaim was made, the plaintiff also filed the rejoinder, and he denied the rental arrears since from 11/2/2018 and the rental amount of rupees 1,500 per month, and contended in the statement that the plaintiff has paid the rental amount since 11/2/2018 consistently. During the COVID period, pandemic-19 lockdown, he had not paid the rentals. And after lifting out the lockdown, the plaintiff approached the defendant for clearance of the rental arrears and amount. However, the defendant refused to receive the rentals in order to explain the plaintiff's possession from the suitable property. The trial court, taking into note of the pleadings of the parties, that is plaint averment and written averment, and as well as the counterclaim, framed the issues and allowed the parties to lead evidence. The plaintiff examined one witness as PW1 and got marked document exhibit P 1-17, and the respondent also examined one witness as DW1 and got marked document exhibit D1 and 2. The trial court, having considered the oral and documentary evidence, answered the issue number 1 and 2 as negative and answered the issue number 3 and 4 as affirmative. And while answering issue number 1 and 2, the court comes to the conclusion that the license period was terminated by issuing the notice, and hence the possession is not a legal possession, and also comes to the conclusion taking note of the admission on the part of rate of rent, and also deducted the amount of rupees 3,000 which was paid in the year 2019, and comes to the conclusion that arrears of rent is 87,000 up to the date of counterclaim, and hence answered issue number 3 and 4 as affirmative, and ordered to vacate hand over the vacant possession of the property within 3 months. Being agreed by the said judgment and decree, an appeal is filed and appellate court also having reassessed the material available on record in keeping the contents, in keeping the grounds which have been urged in the appeal memo. Formulated the point whether the appellant has established that the trial court erred in dismissing the suit of the plaintiff and decreeing the counterclaim relief sought by the defendant, directing the plaintiff to hand over the vacant possession of the suit property to the defendant, and also directing to pay the arrears of monthly rent of rupees 87,000 without appreciating the oral and documentary evidence led by both the properties and whether it requires interference of this court. The first appellate court, having reassessed the material available on record, comes to the conclusion that there is a license and also the document which clearly discloses handing over the possession in favor of the appellant, and also the same is for a period of 6 years, and 6 years period has already been elapsed. And apart from that, taken note of non-payment of rent, and also the rate of rent 1,500 was also admitted, and only taken the contention that during the COVID period could not able to pay the arrears of rent, and the same is calculated, and taking into note of the payment of rupees 3,000, and the same was deducted out of 90,000 and ordered to pay the balance amount of 87,000. And the appellate court also taken note of the document exhibit D1 is unregistered rent agreement, for any rent agreement covering more than a period of 1 year as per section 17 of the Registration Act. Such rent agreement shall be registered in accordance with law. If any agreement not registered, it will hit by section 49 of the Registration Act. And also taken note of plaintiff claims that as per exhibit P1, it is the defendant who has to pay the cost of permanent structure put up by the plaintiff in the suit shell property, and also taken note of the material available on record, both oral and documentary evidence, comes to the conclusion that the appellant committed a default in payment of rent and squatting on the property illegally without payment of rent, under the circumstances not entitled for any relief, and hence confirmed the order of the trial court. Being agreed by the concurrent finding, present second appeal is filed before this court. The main contention of the counsel before this court that when the permanent structure was put up, ought not to have terminated the contract between the plaintiff and defendant. And counsel also would vehemently contend that the same is irrevocable as provided under section 60B of Indian Easement Act 1882. When the plaintiff has made construction of permanent nature on the suit shell property by incurring expenditure after taking the vacant property on license basis. The counsel also would vehemently contend that the first appellate court also committed an error in dismissing the appeal without looking into the pleadings of the parties, and particularly the fact that license granted in favor of the plaintiff was irrevocable in view of section 60B of the Indian Easement Act 1882, and also committed an error in awarding 87,000 as rent without considering the oral and documentary evidence, and hence this court has to admit and frame substantive question of law. The counsel also, in support of his argument, relied upon the judgment 1987 within bracket 2 Supreme Court cases 555 and brought to notice of this court paragraph number 9, wherein discussion was made with regard to section 60 A and B, and also brought to notice of this court paragraph number 10, wherein also discussed and brought to notice of that this court that the result is that the respondents acting upon the license had executed works by incurring expenses which rendered the license irrevocable. As regards evidence, we have perused the statement of Ganga Prasad Dayam, DW1, and Shankar Dutt, DW2, and Bola, DW3. And their testimony fully established that the school had constructed 3 classrooms, latrines, and urinals, and the incurred expenses. And having taken note of the same, it is held that difficult to believe that he had no knowledge of the constructions, such defense which was taken. And hence, counsel pressed into the service of the principles laid down in the said judgment. Having heard the appellant counsel and also on perusal of material available on record, very plaintiff himself has pleaded in the plaint that there was a license and the same is also for a period of 6 years from 11 to 2015 to 11 to 2021. And also it has to be noted that the present suit is filed for the relief of permanent injunction after the period of 6 years, and also it is emerged during the course of evidence that the rent was not paid after completion of 3 years, that is from 11 to 2018. And there is an admission on the part of the plaintiff also in the written statement filed by the plaintiff when the counterclaim was made that the present current rate of rent is rupees 1,500. And when such being the case, the defendant also terminated the license period since period was already completed but not vacated the premises. And also there was an arrears of rent and claimed the arrears of rent at the rate of rupees 1,500 from 11 to 2018. And also due was taken note of to the extent of 87,000. And also terminated the tenancy and made the counterclaim. And having taken note of all these materials before the court, the trial court answered the issue number 1 and 2 as negative. And though the plaintiff is in possession of the property and the possession is unauthorized possession since the same is terminated by causing the legal notice, and also material discloses that he did not pay the rent. And though it is admitted in the pleading also that due to COVID-19 could not able to pay the rent, but even for having paid the rent subsequent to the COVID also, nothing is placed on record. All these materials were taken note of by the trial court and also the appellate court while considering the grounds which have been urged, and particularly taking note of document exhibit P1 is an unregistered document, and also the same is not a registered document. However, the defendant did not trouble the possession of the plaintiff for the period for which he had agreed from 11 to 2015 to 11 to 2021. And immediately after the expiry of the period of 6 years, the plaintiff only approached the court seeking for the relief of permanent injunction. And immediately the defendant also issued notice and made counterclaim. And also arrears of rent was also not paid. And taking note of all these factors into consideration, when the termination was made and counterclaim is made, both trial court and appellate court considered the said fact into consideration. No doubt, the counsel appearing to the appellant relied upon the judgment and pressed into the service section 60B. But in the case on hand, it is very clear that the vacant land is given to the defendant, and the same is also for a period of 6 years, not for permanent period as contended by the plaintiff appellant. When the document itself, which is not disputed, and the said document is also very clear, the same is for a period of 6 years. And after the period of 6 years only, the plaintiff has approached the court when he did not vacate the premises, and thereafter legally terminated the tenancy and filed the counterclaim, and counterclaim is also entertained. And when such being the case, the very contention and principles laid down in the judgment will not come to the aid of appellant counsel, and appellant cannot squat on the property without payment of rent as agreed, and no dispute with regard to even the rate of rent also, and categorically pleaded in the written statement filed by him to the counterclaim also the present rate of rent is 1,500. At the same rate of rent, the defendant also claimed the arrears of rent and also claimed the counterclaim. And when such being the case, I do not find any ground to admit and frame substantive question of law. And hence both the appeals are dismissed.
49. Please, Sheshgiri.
ರೆಕಾರ್ಡ್ಸ್ ಯಾವ್ದು ಬಂದಿಲ್ಲ?
OS records ಬರ್ಬೇಕು.
OS ಬರಬೇಕು. RA ಬಂದಿದೆಯಾ? ನೋಡಿ. Yes, madam.
No, manager, short tape may be given.
The records, ಈಗ ಹಾಕ್ಬಿಡಿ. Records of original suit are not received, and hence registry is directed to issue reminder and get the records. List this matter on 11/12.
Grateful.
50. ಏನು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ A3 for CDF 4 days in filing LR application. Setting aside the abatement, bringing LRs of deceased R1 on record. ಮೊದಲು R1 ಗೆ ನೋಟಿಸ್ ಹೋಗಿತ್ತಾ?
ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ, ಅದಕ್ಕೆ ನೋಟಿಸ್ has to be ordered.
ಮೊದಲು ಹೋಗಿತ್ತಾ ಅಂದೆ. ಸತ್ತೋಗಿದ್ದ ಅಂತ
ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ.
ಸತ್ತೋಗಿದ್ದ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಯ್ತು? R1
ನಾವೇ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ವಿ.
ನೀವೇ ರಿಪೋರ್ಟ್ ಮಾಡಿದಿರಾ? LRs ಬೇಕಾ ಅಥವಾ ಹಂಗೆ?
ಬೇಕಿಲ್ಲ, ಅವರಿಂದ ಇವ್ರು ರಿಲಿಂಕ್ವೆಶ್ಮೆಂಟ್ ಡೀಡ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ವಿ ಅಂತ they themselves has produced the document from the R1 plaintiff number 1.
R1 ಇಂದ ರಿಲಿಂಕ್ವೆಶ್ಮೆಂಟ್ ಡೀಡ್
ಮಾಡಿದೀವಿ ಅಂತ their contention.
They are claiming.
ಅವ್ರ 1/8 ಶೇರ್ ಏನಿದೆ ಅದನ್ನ ನಾವು ತಾಂಡಿದೀವಿ ಅಂತ their claim.
ಅಂತ ಹಾಕ್ಬೇಕು.
Our contention additional document produced before the
you stepped into the shoes of R1 ಹೌದಲ್ಲ? In view of relinquishment deed, why they are necessary party? ಆಯ್ತು, for want of time list this matter on 12/12. 51 ಏನಾಯ್ತು ಮೇಡಮ್? ಬಂತಾ
10
ಏನಾಯ್ತು?
12 ಬೇಡ, ಬೇರೆ ಯಾವ್ದಾರು ಒಂದು
12/12 ಬೇಡ, ಯಾವ್ದು ಬೇಕು ಹೇಳಿ, ಅವ್ರು ಇದ್ದಾಗ್ಲೇ ಕೇಳ್ಬಿಡಿ.
ಅದೇ 10-12 ಯಾವ್ದಾದ್ರು
ಬೇರೆ 15/12
ಆಗೋದು ಆಗಿದೆ. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ರೂ ಸರ್ವ್ ಆಗ್ಬೋದೇನೋ ಅಂತ, ಅಷ್ಟೊಂದು ಸರ್ವ್ ಆದ್ರೆ ಅದು ನಾಳೆಗೆ ಏನಾದ್ರು
ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ against the LRs of R1 on A number 3 of 25, 4 of 25, 5 of 25. Emergent notice. Emergent notice. Immediate ಕೊಟ್ಬಿಡಿ, ನಾಳೆನೇ ಕೊಟ್ಬಿಡಿ.
ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಇರೋದು, ಬೇರೆ ಇಲ್ಲ. ಈಗ ಇರೋದೇ ಅದು, ಬೇರೆ ಇಲ್ಲ.
ಈಗೇನ್ ಬರೀ ಸ್ಪೀಡ್ ಪೋಸ್ಟ್?
ಬರೀ ಸ್ಪೀಡ್
ಅದೇನ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ತೆಗೆದಾಕಿದ್ರಲ್ಲ, ಅದೇನಾಯ್ತು ಈಗ? ಇದೆಯಾ ಮತ್ತೆ ಅಕ್ನಾಲಜ್ಮೆಂಟ್?
ಇವರು ಪೋಸ್ಟ್ ನಲ್ಲಿ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡ್ಯಾರೆ, ಟೈಮ್ ಬಿಂಗ್ ಹಳೆದ್ನು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ.
ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ವಾ ಈಗ?
ಈಗ ಅವೈಲಬಲ್ ಇದೆ.
ಮೊದಲು ತೆಗೆದಾಕಿದ್ರು, ಮತ್ತೇನ ಈಗ ಮತ್ತೆ ಮಾಡಿದಾರೆ. ಆಯ್ತು, 15 ಇಮಿಡಿಯೇಟ್ ಕೊಡಿ. ಏನಾಯ್ತು ಮೇಡಮ್? ಆಯ್ತಾ ರಿಸಲ್ಟ್?
ಆರ್ಡರ್ ಆಯ್ತು, ಅದರಲ್ಲಿ ರದ್ದು ಪಡಿಸಿ ಇದು ಬೈಲಾ ಎಕ್ಸೀಡ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ. ದೇ ಆರ್ ನಾಟ್ ದ ಮೆಂಬರ್ಸ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ, ಮತ್ತೆ ನಿಮಗೆ ಇದನ್ನು
another connected matter milord 896 of 25 ಅದರೊಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಐ ಫೈಲ್ ದಟ್ ಔಟ್.
896 ಇನ್ನೊಂದಿದೆಯಾ?
ಇನ್ನೊಂದಿದೆ,
RSA
896 of 2025.
The appellant counsel submits that connected RSA 896 of 25 is also pending and the same may be posted along with this appeal. And hence registry is directed to put up the same and list this same along with this appeal on 12/12. Murali, dismiss for want of time, list this matter on 12/12.
12 ಬೇಡ ಸುಮನ್.
12 ಬೇಡವಾ? ಯಾಕೆಂದ್ರೆ 12th ಏನಾರು ಒಳ್ಳೆ ದಿವಸ ಇಲ್ವೇನ್ರಿ? ಎಲ್ಲರೂ ನೋಡ್ರಿ 12th ಬೇಡ 12 ಬೇಡ.
Itinerary codes are there, madam. Itinerary codes are there. I have to go to Chiklapur, so that's good.
12 ಫ್ರೈಡೆ ಅಲ್ವಾ?
Friday.
ಒಳ್ಳೆ ದಿವಸ ರೀ, ಶುಕ್ರವಾರ.
ರೂರಲ್ ಕೋರ್ಟ್ ಗೆ ಹೋಗೋದಿರುತ್ತೆ, ಹಾಗಾಗಿ.
ಆಯ್ತು, ಯಾವ್ದು ಬೇಕು? 15
15th August.
15 12 ಆಯ್ತು.
53 urgent 54.
53 already urgent. 54 ಮಾಂತೇಶ್ ಎಸ್ ಹೊಸ್ಮಠ ಡಿಸ್ಮಿಸ್ ರಿವರ್ಸ್. ಇದೇನ ಮಾಡಿದ್ನಲ್ರಿ ಅವಾಗ್ಲೇ ಆರ್ಡರ್?
ನೋಟಿಸ್ ಆಗಿತ್ತು.
PS ನಾಗರಾಜ್ ರೆಕಾರ್ಡ್ ಬಂದಿದೆಯಾ?
ರೆಕಾರ್ಡ್ ಇದೆ.
ಆಯ್ತು, ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್.
ಅರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ ನೋಡಿ, ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಯು ಕ್ಯಾನ್ ವಾಚ್.
ಆಯ್ತು, 12/12.
55
55 ಜೇಕರ್ ಶೀಟ್ ಯಾವ್ದಾಗ್ಲೇನ್ ಮಾಡಿದ್ವಲ್ಲ ಏನೋ ಬೆಳಗ್ಗೆನ ಕೇಳಿದ್ರಲ್ರಿ ಮೇಡಮ್? ಆಗ್ಲೇ ಮಧ್ಯಾಹ್ನ ಮಾಡಿದ್ನಲ್ಲ ಮೇಡಮ್, ಇಳ್ದೋಕ್ಕಿಂತ ಮುಂಚೆ. ಡಿಕ್ರೀಡ್ ರಿವರ್ಸ್ಡ್ ಅಂತ ಇದೆಯಲ್ಲ, ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್
TCR ಬಂದಿದೆ.
ಬಂದಿದ್ಯಾ? ಆಗ್ಲೇ ಹಾಗಂತ ಇಟ್ಕೊಂಡ್ವಿ, ಕಟ್ಸ್ ಬಂದಿದೆ ಅಂತ.
ಹೌದು.
ಎಲ್ಲಿ ಅವರು? ಸನತ್ ಕುಮಾರ್ ಶೆಟ್ಟಿ ಇಲ್ವಾ?
ಇದ್ರು ಬೇರೆ ಯಾವ್ದೋ ಕೋರ್ಟ್.
ಆಯ್ತು, ಅಪರೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಅಬ್ಸೆಂಟ್, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 12/12.
56 Somnath H.
Somnath H. 10th share 1 to 5, 11 to 22, 6 to 10 dismissed. Confirmed.
My lord, senior counsel is engaged in the matter. My lord, I pray for a short date.
Senior counsel engage ಮಾಡಿದ್ರೆ ಬರ್ಬೇಕು ಮೇಡಮ್.
My lord, she is senior counsel Sushila is engaged.
ಇದಾರಲ್ಲ ಮತ್ತೆ.
I am extremely sorry.
ಏನಾದ್ರು ಎಕ್ಸಾಮ್ಷನ್ ಇದೆ ಮೇಡಮ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್?
ಇಲ್ಲ ಇಲ್ಲ, ಖಂಡಿತ ಕೊಡ್ಬೇಡಿ ಸರ್. Not at all. Sorry.
For want of time, this matter on 12/12. Same ಆಗ್ಲೇ 5.
ಯಾವತ್ತು ಸುಮ್
12/12.
ತುಂಬಾ ಡೇಟ್ ಒಂದೇ ನಮ್ಗೆ 4 ಪ್ರಾಪರ್ಟೀಸ್ ನಮ್ದು
ಯಾವಾಗ
ಪರ್ಸನಲ್.
ಬೇಕು ಹೇಳಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ ಬೇಕಾ?
ಥರ್ಡ್ ಸೆಕೆಂಡ್
ಇವತ್ತು 45 ಇತ್ತು ಅಡ್ಮಿಷನ್ಸ್ ಗೆ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಥರ್ಡ್ ಕೊಟ್ರೆ ಆಗ್ಬೋದು ಸರ್, ಇಫ್ ಇಟ್ ಇಸ್.
ಥರ್ಡ್ ಇಲ್ಲ, ಥರ್ಡ್ ನೋ ಸಿಟ್ಟಿಂಗ್. ಏನೋ ಅಡ್ವೊಕೇಟ್ಸ್ ಡೇ ಬರ್ಲೇಬೇಕು ಅಂತ ಕೂತ್ಕೊಂಡಾರೆ, ಹೋಗ್ತಾ ಇದೀನಿ ಹಾಸನ್.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ 12 ಗೆ ಇರಲಿ 5
4th ಆಗ್ಬೋದಾ 12th?
ಆಗ್ಬೋದು ಸ್ವಾಮಿ 4th ಗೆ ಆಗ್ಬೋದು ಸ್ವಾಮಿ
4th 12.
ಗ್ರೇಟ್ಫುಲ್ ಗ್ರೇಟ್ಫುಲ್ ಐ ಆಮ್ ಸಾರಿ ಮೈ ಲಾರ್ಡ್
59 parted in heading. Vaishali Hegde.
59
59.
I am for the respondent.
Yes, madam.
Your Lordship's court commissioner report ಬರ್ಬೇಕಿತ್ತು.
Court commissioner.
Court commissioner.
Court commissioner ಯಾರು ಅಪಾಯಿಂಟ್ ಮಾಡಿಲ್ವಲ್ಲ ಇದರಲ್ಲಿ?
ನಾವು ಕಳಿಸ್ಕೊಟ್ಟಿದ್ರಿ ಮೈಸೂರಿಗೆ.
ಕಳಿಸಿದೀವ? ನೋಡಿ ಮೇಡಮ್ ಹಿಂದಿನ ಆರ್ಡರ್ ನೋಡಿ. ಇದರಲ್ಲಿ ಏನು ಇಲ್ಲ ಅದರಲ್ಲಿ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಇದೆಯಲ್ಲ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ರಿಪೋರ್ಟ್ ಫ್ರಮ್ ತಾಲೂಕಾ ಸರ್ವೇಯರ್ ಮೈಸೂರು ಸಿಟಿ ಬಂದಿಲ್ವಾ? ಡೇಟ್ ಅನ್ನ ಫಿಕ್ಸ್ ಮಾಡಿದ್ವಲ್ವಾ ವಿತ್ ಕನ್ಸೆಂಟ್?
ಇದೇ ಇವತ್ತು ಕೊಟ್ಟಿದ್ರಿ ಮೇಡಮ್. 21st ಒಳಗೆ ಬರಬೇಕು ರಿಪೋರ್ಟ್ ಅಂತ ಮಾಡಿದ್ರಿ ತಾವು.
Even measure the defendant site number 1811 new number 32 which is stated. ಏನಾಯ್ತು ನೀವು ಹೋದ್ರಾ? ನೀವುಗಳು ಹೋದ್ರ ಏನಾಯ್ತು?
ಏನು ಗೊತ್ತಾಗಲಿಲ್ಲ ಸಮಸ್ಯೆ.
ಹೋಗ್ಬೇಕಲ್ಲ ನೀವು. Are given 5 days time to file any memo of instructions before the court to effect the measurement. Registered directed to send the copy of this order as well as memo of instructions to be filed by the so and so appellant and the relevant counsel. Keveta respondent to the Taluka surveyor Mysore city to measure the property on 15/11/25. Taluka surveyor is directed to submit the report on nim date fix ಮಾಡಿದ್ವಲ್ರಿ 15/11ಕ್ಕೆ. What happened madam? ಇಬ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ? ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ವಲ್ಲ ಸರ್ವೆ ಮಾಡಕ್ಕೆ.
ಹೌದು.
ಏನಾಯ್ತು? ಆಯ್ತಾ?
ನಾನು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದೆ ಮೈಸೂರು ಅಡ್ವೊಕೇಟ್ಗೆ ಮತ್ತೆ ಪಾರ್ಟಿಗೆ ಇಬ್ರಿಗೂ.
ಈಗ ಏನಾಯ್ತು?
ಗೊತ್ತಾಗಿಲ್ಲ, ಕ್ಷಮಿಸ್ಬೇಕು.
ಏನಾಯ್ತು? ಏನ್ ಮೇಡಮ್? ಬೋತ್ ಆರ್ ಬ್ಲಾಂಕ್. ಡೇಟ್ ಎಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡಿದೀವಲ್ಲ. ಮೆಜರ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಆನ್ 15/11/25. ತಾಲೂಕಾ ಸರ್ವೇಯರ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಸಬ್ಮಿಟ್ ದಿ ರಿಪೋರ್ಟ್. ಅದಕ್ಕೆ 6 ದಿವಸ ಮತ್ತೆ ಟೈಮ್ ಕೊಟ್ಟು ರಿಪೋರ್ಟ್ಗೆ ಅಂತ ಮಾಡಿದ್ವಿ. ಬೋತ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ದೇ ಹ್ಯಾವ್ ನೋ ಎನಿ ಇನ್ಫಾರ್ಮೇಶನ್ ವೆದರ್ ದಿ survey was conducted on 15/11/25 and hence directed both councils to verify and submit. List this matter next week ಯಾವಾಗ ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀರಿ ಹೇಳಿ? ಪೂರ್ತಿ ಚೆಕ್ ಮಾಡಿ ಹೇಳಿ.
Can it be in any
if you people have not followed it up, that I will recall the order. Without commissioner report, I will proceed with the matter.
I'll ask instructions.
If no respect to the court order, why should we have to keep the matter pending alive? ಕೊಡಿ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಫ್ರೈಡೆ ಕೊಡಿ. ಅಷ್ಟೊಳಗೆ ಅವರೊಂದು ವಾರ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. 5/12.
ಸಂಗಮೇಶ್ ಆರ್ಬಿ.
ಸಂಗಮೇಶ್ ಆರ್ಬಿ.
The matter was heard for some time.
ಇಬ್ರು ಇದೀರಾ ಏನು? ನಿಮ್ದು ಬರೀ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ ಏನಿದು? ಪಾರ್ಟ್ ಆರ್ಡರ್.
This is for part heard notes where the matter was heard for some time.
ಬಿಟ್ ಆಗಿದೆಯಾ?
It was admitted notes even for final hearing.
ಅದೇನಾ ಹಿಯರ್ ಮಾಡುವಾಗ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಏನೋ ಆಗ್ತಿದೆ ಅಂತ
order of the Tahsildar which I referred, wherein notes the defendant has admitted.
Time list this matter on 12/12.
We filed the objection for that application.
Objection.
And now notes I have filed application for additional documents. They have filed objections also. So if that application can be heard along with the main and disposed notes, we are ready.
Main ene ಅದು ಹಿಯರ್ ಮಾಡಬಹುದು.
Very well.
Law is settled. Along with necessity ಇದ್ರೆ ಮಾತ್ರ.
The shorter date possible because
next week ಅಲ್ಲಿ ಕೂಡ ಅದರ ಡೇಟ್ ನೋಡೋಣ ಪಾರ್ಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ.
Heard for some time. I may take 15-20 minutes notes now.
ಯಾವಾಗ? 5/12. ಆಯ್ತು.
5/12.
C1 ಚಿದಂಬರ GS.
ಚಿದಂಬರ GS ಶ್ರೀಕಾಂತ್ ಪಾಟೀಲ್.
Short matter discrepancy in the schedule and also in the document produced by the defendant. Divergent finding. I think that led us to settle the matter.
ಏನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನೇ ಡೈರೆಕ್ಟ್ ಮಾಡಿದೆ.
ಹೌದು.
ಇಬ್ರದು ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ನೋಡಿ ಅಂತ. ಇಬ್ರು ಕೂತ್ ಮಾಡಿದ್ದೆ. ಏನಾಯ್ತು?
ಆಗಿಲ್ಲ ಸರ್.
ಮಾತಾಡ್ಲಿಲ್ಲ?
ಅಲ್ಲ ಪಾರ್ಟಿನೇ ನಮ್ we not able to get the contact of the parties.
Your party?
Both the parties. We also told.
Both.
It was there in the morning.
ಏನು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನೋ ಇದೆಯಾ ಮೇಡಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಏನಾದ್ರು ಇಲ್ಲೇನು ತೋರಿಸಿಲ್ಲ ಅದಕ್ಕೆ?
ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಅಷ್ಟೇ ಇದೆ.
ಅತಿ ರಿಕ್ವೆಸ್ಟ್ ಅಂತಿದೆ. ಆಯ್ತು. ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 4/12.
ಪ್ಲೀಸ್
4/12 ಹೇಳಿ.
ಆಯ್ತು.
ಇಬ್ರಿಗೂ ಕೇಸ್ ಇಲ್ಲ ಅದಕ್ಕೆ ಹೇಳಿದೆ ನಾನು. ಇಬ್ರು ಏನಾದ್ರು ಕುತ್ಕೊಂಡು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ಳೋದಾರು ಮಾಡ್ಕೊಳ್ಳಿ.
ಹೌದು ಹೌದು.
62 ಮುದ್ದುರಾಜ್ ಸಿ.
ಶಂಕದಿಂದಲೇ ತೀರ್ಥ ಬೀಳ್ಬೇಕು ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಪೆಲೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ. ರೆಸ್ಪಾಂಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಮುದ್ದುರಾಜ್ ಅಪೆಲೆಂಟ್ ಆಗಿದೆಯಾ? ನಿಮ್ದು ಆಗ್ಬೇಕಾ? ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ?
20 minutes.
20 minutes. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಕೊಡಿ ನೋಡೋಣ. ಇವೆಲ್ಲ ಪಾರ್ಟ್ ಆರ್ಡರ್ 4/12. ಇನ್ಮೇಲೆ ಮಧ್ಯಾಹ್ನದವರೆಗೆ ಅಡ್ಮಿಷನ್, ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಪಾರ್ಟ್ ಆರ್ಡರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ನಾಳೆಯಿಂದ. ಇಲ್ಲ ಅಂದ್ರೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮುಟ್ಟಾನೆ ಯಾವ್ದು ಆಗ್ತಾನೆ ಇಲ್ಲ. 45 ಅಡ್ಮಿಷನ್ ಇದ್ರೆ ಏನ್ ಮಾಡೋದು RSC ನಲ್ಲಿ? ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿ, ಬೆಳಗ್ಗೆ ಹೇಳಿದೇನಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ಯಾವ್ದು ರೀಚ್ ಆಗಲ್ಲ ಇವತ್ತು. ಎಲ್ಲ 12 ಯಾವ್ದೋ ಎಂಟ್ರಿ ಮಾಡಿ ಯಾವ್ದೋ ಒಂದು ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಮೇಡಮ್ ಯಾವ್ದೋ ಇದೆ ಅಂತ ಅವಾಗ ನೋಡ್ಬಿಡಿ, ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಯಾವ್ದಾರು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಕ್ ಹೇಳಿ. 12 ಆಲ್ ಆರ್ 12.
30. I am sorry, I could not able to.
ಕರೆದು ಡೇಟ್ ಬೇಕಾ ಕೊಡ್ಬೇಕಾ? ತಗೊಳ್ಳಿ
ಎಂಟ್ರಿ ಮಾಡಿ
ಫಸ್ಟ್ 63ಕ್ಕೆ ಬನ್ನಿ.
30.
ವಿನಾಯಕ ಬಿ ಅಂಜನಾ ಮೂರ್ತಿ.
ಅವರು ಫಾಸ್ಟ್ ಓವರ್ ಕೇಳ್ತಾರೆ.
ಈ ಫಾಸ್ಟ್ ಓವರ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ಈಗೆಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ? ಆಯ್ತು, ನಾನು ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದೆ ಫಸ್ಟ್ ಬಂದಾಗ್ಲೇ ಫೈನಲ್ ಇಯರಿಂಗ್ ಇವತ್ತು ರೀಚ್ ಆಗಲ್ಲ ಅಂತ. ಯಾವ್ದು ಪಾಸ್ ಓವರ್ ಇಂದ ಬಂದ್ಬಿಡಿ.
CL number 70.
74 ಏನಾಗ್ಬೇಕು ಹೇಳಿ. ಅಯ್ಯೋ ಯಾವ್ದಾವ್ದು ಇದೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡೇ ಮಾಡ್ತಾರೆ. 74 12 ಫಾಸ್ಟ್ ಓವರ್ ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3. ಪಾರ್ಟಿ ಸೈನ್ ಇಲ್ಲ, ಅಕ್ಲೈನ್ಮೆಂಟ್ ಇಲ್ಲ. ತೊಗೊಳ್ಳಿ. Memo for retirement filed is not accepted. Council is directed to produce the acknowledgement, and if fails to produce the acknowledgement, the appeal will be dismissed in the next date of hearing. List this matter on 12.
Serial number 8. ಗಿರೀಶ್ ಕೊಡ್ಗಿ.
ಗಿರೀಶ್ ಕೊಡ್ಗಿ ಅವ್ರು ಏನೋ ಹೇಳಿದ್ರು ಬೆಳಗ್ಗೆ
ಸಿಗ್ನೇಚರ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ
ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಇದಾರಾ? ತೊಗೊಳ್ಳಿ. In spite of this court directed to verify and submit regarding service of notice in respect of R6, even though matter is called twice, no representation by the appellant counsel. If no representation in the next date of hearing, second appeal will be dismissed. List this matter on 12.
9. Srinivas Hatti.
ಏನ್ರಿ ಅದು?
Sir, PF ಕೊಡ್ಬೇಕು ಫಸ್ಟ್ ಟೈಮ್.
ಕೊಟ್ರಾ? Counsel submits that PF is paid and hence issue notice to R2 to 6. And interim order granted earlier is extended till next date of hearing. 671/26.
17. Siddharth Suman.
The appellant, last occasion, Senior Counsel also said the only thing we had almost worked out a settlement. It is only the road, my lord, which is a little controversial right now. Share and everything, to a certain extent.
ಏನಿಲ್ರಿ, ಶೇರ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಇದೆ, ಕಾಂಪನ್ಸೇಷನ್ ಗೆ ಸಂಬಂಧಪಟ್ಟ ಇದೆ.
ಇಲ್ಲ, ಕಾಂಪನ್ಸೇಷನ್ ಕಾಂಪನ್ಸೇಷನ್ ವರ್ಕೌಟ್ ಆಗಿಲ್ಲ. ಬಟ್ ಇನ್ ಸೋ ಫಾರ್ ಆಸ್ ಅ ಶೇರ್ ಇಸ್ ಕನ್ಸರ್ನ್ಡ್, ವಿ ಆರ್ ಟ್ರೈ ಟು ವರ್ಕೌಟ್ ಸಮಥಿಂಗ್. ಅದೊಂದು ರೋಡ್ ಮಾತ್ರ ಮಲರ್. ರೋಡ್ ಅಲ್ಲಿ ದೇರ್ ಸೀಮ್ಸ್ ಟು ಬಿ ಸಮ್ ಕಾಂಟ್ರವರ್ಸಿ.
ಮಾಡಿ ಕೂತ್ಕೊಂಡು ರೆಡಿ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ಬಿಕಾಸ್
ಟೋಟಲ್ ಕೇಸ್ ಇದ್ದಾಗ ಮಾತ್ರ ನಾನು ಕಾಂಪ್ರಮೈಸ್ ಮಾತಾಡ್ತೀನಿ ಅಂತಾರೆ. ಕೋರ್ಟ್ ಇಂದ ಹೋದ ತಕ್ಷಣ ಯಾವ ಕಾಂಪ್ರಮೈಸ್ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
My colleague was present last occasion, ನಾನು ಇರ್ಲಿಲ್ಲ.
ಆಯ್ತು,
which is why. ಆ ರೋಡ್ ಮಾತ್ರ ಒಂದು ನೋಡ್ಬೇಕು ಮೇಡಮ್. That's the only thing which is left.
ಆಯ್ತು, ಮಾತನಾಡಿ. ಯಾವಾಗ? ಒಂದು ವಾರ
ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ ಮೇಡಮ್, ಬಿಕಾಸ್ ಆ ರೋಡ್ we have to only figure out where. ಯಾಕಂದ್ರೆ
ನಾನು 2 ಸರಿ ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ ನೋಡಿ. ಇದೆಲ್ಲ ನಿಮ್ದೇನೆ ನೋಟ್ಸು, ಇಷ್ಟುವೆ ನಿಮ್ ಕೇಸ್ತೆ.
ಮತ್ತೆ ಹಂಗಿದ್ರೆ ಮೇಡಮ್ 6th it may be listed, not 6th.
6th Saturday. Sorry. 8th ಆಗ್ಬೋದಾ? 8th Monday.
Please.
Told. Appellant counsel submits that there is an element of settlement and counsel for R2 to 15 also not disputes the same. And hence list this matter on 8/12 to report the settlement. If no settlement, argue the matter on merits, 25. Not on merits for admission.
Please. Then may I request 9th Manathan at the.
Aye, 9/12.
Please. Oblige.
One day will not make any difference. Yav madam?
25.
25. Balraj and Shankar Narayan, but idrallen Balraj ಬೆಳಗ್ಗೆಲೂ ಇರಲಿಲ್ಲ. ಬಂದ್ರಾ ಈಗಲೂ? ಇಲ್ಲ. ತೊಗೊಳ್ಳಿ. This matter is called twice. ಇಲ್ಲೇನು ಕಾಸ್ಟ್ ಬೇರೆ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೋಣ ಕೊಡಿ.
They remained as morning called out their short time and the afternoon.
ತೊಗೊಳ್ಳಿ. This court, with order dated 11/11/25, when there was no any representation on behalf of the appellants afternoon, adjourned the matter on cost of rupees 5,000 payable at registry within a week. and granting time, one more opportunity is given to the counsel for the appellants. And today this matter is called twice in the early morning and also in the afternoon, and no representation, and cost also not paid. And hence it appears the appellant counsel is not interested in pursuing the appeal, and hence appeal is dismissed.
27. Vikas M.
27. Vikas M. Modified. ಇದರ ಇಲ್ಲ
ಇಲ್ಲ
ಬೆಳಿಗ್ಗೆ ಅವರೇ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರ ಪಾಸ್ ಓವರ್ ಅಥವಾ ನಾವೇ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ?
ಪಾಸ್ ಓವರ್.
Told this matter was called in the early morning and also in the afternoon at 5:10 and no representation. And if counsel doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. This matter on 12/12.
28.
28 SV Prakash, Vasanta Kumar KM.
The respondent, my lord.
I
think in the execution, my lord, SLD has already been executed.
then ಹೇಳಿದ್ರಲ್ಲ
Sir, ಇಲ್ಲ with you. ಇಲ್ಲ ಡೈರಿ ಇದೆ. ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಥ್ರೂ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಡೈರಿ ಆಗಿದೆ.
ಇದೆಯಾ?
ಇದೆ.
ಮತ್ತೆ
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೀವು ಚೆಕ್ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಅಂದ್ರಲ್ರಿ. ಅಲ್ಲ ರೀ ಇದು ಸೇಲ್ ಡೀಡ್ ಇದೆ ರೀ. Delivery of possession ಎಲ್ಲಿದೆ?
I will get the copy. That's what I
ಇಲ್ಲ ಅಲ್ಲ. Totally. Counsel for the respondent submits that already sale deed was executed by the trial court and possession is also delivered, and hence directed to produce the document for having delivered the possession.
Please.
Since the counsel for the appellant disputes with regard to the delivery of possession, list this matter on 812. Mugita Chandrachud 30.
Appearing for respondent number
1/4 item number 1 not binding, modified 1/4 in all.
ಅವರು ಈಕ್ವಿಟಿ
ಇದ್ರಲ್ಲಿ ಏನ್ ಇಲ್ವಲ್ರಿ ಚಂದ್ರಚೂಡ್ ಅವರ? ಏನಿದೆ?
Sale deed was executed for the benefit of the family. Clear the antecedent debt. Father created a mortgage in favor of third party during his lifetime. He underwent
for want of time list this matter. Want of time list this matter on 12/12.
31.
For appellant in this case.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ರೀ. ತುಂಬಾ ಇದೆಯಾ ಪಾಸ್ ಓವರ್ ಆಗಿರೋದು? For want of time
31 I appellant.
31 ಏನೆ 12/12 want of time
11/12 ಹಾಕಿ.
ಆಯ್ತು 11/12 ವರ್ಕಿಂಗ್ ಅಲ್ಲ?
ಹೌದು ಸರ್.
11/12
30ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅಂತ ಸರ್.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? 30ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರೆ extended till next date of hearing.
40.
Appearing for respondent.
40.
Appearing for respondent.
Decreed as claimed. ನೀಲಕಂಠಯ್ಯ ಬರ್ಲಿಲ್ವಾ ಬೆಳಗ್ಗೆನು? ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ.
Sorry. This matter is called twice in the early morning and also in the afternoon, and no representation. If opponent counsel doesn't appear in the next date of hearing, appeal will be dismissed for non-prosecution. List this matter on 12/12.
45.
Finally,
I am for the respondent.
I would appellant in this case.
ಹೇಳಿ. Both suits ಏನೋ ಒಂದು ಸೂಟ್
ಒಂದು ಕನ್ಕರೆಂಟ್
ರಿವರ್ಸ್
ಇನ್ನೊಂದು
ಆಗಿದೆ,
ಡೈವರ್ಜೆಂಟ್.
ಒಂದು ಕನ್ಕರೆಂಟ್ ಒಂದು ಡೈವರ್ಜೆಂಟ್. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಅಲ್ಲ?
ಬಂದಿದೆ.
ಈಗ ಏನೋ ಇದರಲ್ಲಿ ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನೀವು
So I'll undertake to file.
Counsel Sarath Kumar Shetty undertakes to file wakalat for respondents in RSA number 474 of 25. ಅಷ್ಟೇ ಅಲ್ಲ? List this matter on 12/12.
15th.
And if wakalat is filed, all ಬರಬೇಡಿ. If wakalat is filed, show the name of the counsel for the respondent.
Kindly, I will be 15th ಹಾಕೊಳ್ಳಿ.
In the cause list. ಆಯ್ತು. List this matter on 15/12.
Highly obliged.
Kindly.
ಯಾವ್ದು ಇದ್ದಂಗಿಲ್ಲ.
54.
54. ಏನಾಯ್ತು 54?
One more
Mantesh S. Hosmat.
Yes, ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಅಪೀಲ್ ಕನೆಕ್ಟ್ ಆಗಬೇಕು ಸರ್. ಇನ್ನೊಂದು ಅಪೀಲ್ ಕನೆಕ್ಟ್ ಆಗಬೇಕು.
ಅದ್ರೇನು ಬೆಳಗ್ಗೆಲ್ಲ ಮಾಡಿದೀವಿ ಆರ್ಡರ್. ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ ಅದು ಇಲ್ಲ, ಅದೇನೋ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಆಗಿದೆ. ಈಗ ಮಧ್ಯಾಹ್ನ ಕೊಟ್ವಿ 12/12 ಗೆ. ಈಗ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಏನ 12/12 ಕೊಟ್ಟಿದೀವಿ ನೋಡಿ. ಇನ್ನೊಂದು ಇದೆಯಾ? ತೊಗೊಳ್ಳಿ, ಅಲ್ಲೇ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್. 54. Appellant counsel submits that
1148 of 18.
Connected RSA
48 of
48 or
48 of 18.
25.
18.
18 ಹಂಗೆ ಇದ್ರ ಜೊತೆ ಕನೆಕ್ಟ್ ಆಗ್ತದೆ. ಅರೇಂಜಿಂಗ್ ಡ್ರಾಫ್ಟ್ ಆಫ್ ಸೇಮ್ ಜಜ್ಮೆಂಟ್ ಸೇಮ್ ಜಜ್ಮೆಂಟ್ ಆದ್ರೆ ಹಂಗ್ರಿ 25 ಪಾರ್ಟಿ ಸೇಮ್ ಆದ್ರೆ ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ, ಬೇರೆ ಬೇರೆ. ಆಯ್ತು 12/12 ಹೌದು ಬನ್ನಿ.
My lord, CL number 70, my lord, or date may be fixed, my lord, final hearing.
ಕೊಟ್ವಲ್ರಿ ಎಲ್ಲ 12/12ಕ್ಕೆ
ಎಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್.
ಎಲ್ಲ ಫೈನಲ್ ಇಯರಿಂಗ್ 12/12ಕ್ಕೆ ಹಾಕಿದೀವಿ ನೋಡಿ. ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ, ಏನ್ ಮಾಡೋದು? ಇವತ್ತು 45 ಇತ್ತು ಅಡ್ಮಿಷನ್ ಕೌಂಟೆಡ್. ರಾತ್ರಿ ಓದಕ್ಕಾಗ್ಲಿಲ್ಲ ಅಂತ ಬೆಳಿಗ್ಗೆ 5 ಗಂಟೆಗೆ ಎದ್ದು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ. ಇಲ್ಲಿ ಒಂದು ಟೈಮ್ ಕೇಳ್ತಾರಲ್ಲ, ಟೈಮ್ ಯಾಕೆ ಕೊಡಲ್ಲ ಅಂದ್ರೆ ಇದೇ ರೀಸನ್ಗೆ. ನಿನ್ನೆ ಕಂಪ್ಲೀಟ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಬೆಳಗ್ಗೆ 5 ಗಂಟೆಗೆ ಎದ್ದು ಓದ್ದೆ. ಇವತ್ತು ವಾಕಿಂಗ್ ಇಲ್ಲ ಏನಿಲ್ಲ, ಎಲ್ಲ ಹೋಯ್ತು. 11. 2100.
Madam, 17 interim order extension.
Sir.
ಆರ್ಡರ್ ಆಗಿರೋದ್ನ
ಅದೇನಾಗಿದೆ
455
ಸ್ಟೇ ಏನಾಗಿದೆ ಅಂತ ಸರ್ ಕೋರ್ಟ್
ಯಾವತ್ತು ಹೇಳಿ ಆಗಿರೋದು?
ಸರ್ವೆ ಮಾಡಿ ನೀವು ಹೋಗ್ಬೇಕಲ್ವ, ನೀವು ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್
ಏನಾಗಿದೆ ರಿಪೋರ್ಟ್ ತಗೊಂಡ್ಬನ್ನಿ ಅಷ್ಟೇ, ಬಂದಿಲ್ಲ ಏನೋ ನೋಡಿ ಏನಾಗಿದೆ
ನೀವು ವೆರಿಫೈ ಮಾಡ್ಬೇಕು. ನಿಮ್ಮ ಕೌನ್ಸಿಲ್ ರೌಂಡ್ ಬಂದಿತ್ತಲ್ಲ.
ಮೇಡಮ್ ಕಳ್ಸಿದೀನಿ ಅದನ್ನ ಕಳ್ಸಿದೀನಿ ಮೇಡಮ್, ಮಾಡ್ಕೊಡ್ತಾರೆ.
1153
ಅದ್ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀವಪ್ಪ ಎಲ್ಲದನ್ನು.
17
ನಾವು ಪರ್ಟಿಕ್ಯುಲರ್ ಫೈಲೇ ನೋಡ್ಬಿಟ್ಟು ಕೊಡ್ತೀವಿ.
ಐದು ಅಂತ ಹೇಳಿದ್ರೆ 5ಕ್ಕೆ